PROCEEDINGS. Call to order of the court. The court calls civil action. 3:23 CV01746S, Susquehanna Radio, LLC, formerly known as Susquehanna Radio Corp. versus Jacob Kemp and Daniel McDowell. Counsel, please make your appearance on the record by, and I'd like lead counsel to stand up and make your appearance on the record. And who's with you today? Mr. Pernini. Thank you, Your Honor. David Pernini of Wargo, French, singer. With me today is David Anderson of Baker Hostetler. Tyler Dysart. Also, the court. Well, hold on, Mr. Pernini. Sorry, the court, and you'll be taking lead today. Mr. Pernini. Mr. Pernini. Well, Mr. Anderson will be doing opening and questioning some of the witnesses, and then I'll be questioning some of the witnesses. The court. Okay. I've got you, Mr. Pernini. Mr. Anderson. Mr. Anderson. Yes, Your Honor. The court, and Mr. Pernini, Mr. Dysart. The court. Okay, Mr. Pernini. And then Brian Jorgensen is also in the courtroom today. He will not necessarily be taking the court. Good morning, Mr. Jorgensen. Mr. Jorgensen. Good morning, Mr. Pernini. He will not necessarily be taking a role in the presentation of evidence, but if there's any NLRB issues that the court has questions about, he's available. The court. I don't really see that NLRB has anything to do with this hearing this morning, so, Mr. Pernini. Oh, I'll disagree, but the court, I'm here on a temporary, a preliminary injunction matter, and the issues are pretty narrow. But I know people are trying to throw the NLRB in this, but I don't really see it being relevant today at all. So you've got limited time. I intend to have you all be focused on the time. I've got a criminal sentencing later this afternoon that I intend to keep on time, and so use your time wisely. But I'm telling you right now, I'm focused on the elements and the burden that you all have on the preliminary injunction. Who's behind you? Mr. Pernini. I'm sorry, Your Honor. With me today. Also, this is Daniel Bennett. The court. Yes, he was here last time. Mr. Pernini. That's right. And then Jeff Catlin. The court. Jeff, what did you say his last name was? Mr. Pernini. Catlin, Catlin. The court. He was here last time. Okay, Mr. Pernini. And then Mr. Larry Rosen, who was not here last time. The court, and Mr. Rosen's relationship to the Mr. Pernini. Mr. Rosen is an expert in the area of the court. Oh, so he's going to be a witness. Mr. Pernini, he's going to be a witness, yes, Your Honor. The court. All right. Is that everybody on your team? Look around, cause there's been at least one additional people have come in. Mr. Pernini. Yeah. The court. Pardon. Mr. Pernini. That's it for our side. The court. Okay. And then on behalf of the defendants, Mr. Kingston. Good morning, Your Honor. Philip Kingston, Shiles Winnipst. With me is Frank Cawley of the Cawley Law Group. The court. Ms. Griffin. Mr. Kingston. Ms. Griffin from Clark Hill. Your Honor. You met Jacob Kemp last time. Daniel. The court. Yes. Good morning, Mr. Kemp. Mr. Kingston. McDowell. I'm sorry, Your Honor. The court. And Mr. McDowell. Mr. Kingston. Mr. McDowell was traveling. The court. Right. And he's present today. Mr. Kingston. He's present. We did not make Will set up anything for no reason again. Sorry about that, Will. And later you will hear from Adam Romo, who's not here yet, but we didn't think it was necessary for him to be here at the start. The court. Okay. Thank you. I view today as a continuation of the hearing we started several weeks ago, but we stopped to allow the parties, at their request, to start mediation or complete mediation before this hearing began. So I am not going to repeat all the instructions and the communications that I had given the lawyers before, except there's a couple that are worth bear repeating. First, just so we're clear, today before the court is ECF document number 9 titled, Plaintiff's Renewed Application for Temporary Restraining Order and Request for Preliminary Injunction. I understand that at this time the plaintiff is not seeking a TRO, of course, and then at least the allegation relative to anti-solicitation will not be before the court. Am I correct? Mr. Pernini, you are correct, Your Honor. The court, in response to this document, this application, I have before me defendant's amended response and opposition to plaintiff's original and renewed application for injunctive relief as well as ECF 26. If I didn't say so, the one I just said was ECF 19 is plaintiff's reply for defendant's responses and opposition to injunctive relief. I have you all have been working fast and furious and filing things left and right. I do have in front of me something that was filed, I believe, in the last hours, the defendant's motion to dismiss pursuant to Rule 12b-1 and Rule 12b-6. I haven't looked at this, because it's not ripe and that's not before the court right now, but I just want to let you know that that's not something I believe is appropriate to review. But I have received kind of unfortunately, ECF 43, which is titled Plaintiff's Factual Update and Supplemental Bench Brief in Support of Preliminary Injunction Hearing, as well as defendant's response to plaintiff's factual update and bench brief in support of preliminary injunction. I question whether these should have been filed, whether statements should have been made. Maybe the best interest of your respective clients were not at the heart of all this. I think it's inappropriate to go into mediation, and I'm just going to. I've read it, but I think, quite frankly, that these two documents make the lawyers look like they're fighting in the sandbox. Okay, and that's not a good impression. And so I'm going to set that aside and we're going to start anew. So what I also want to tell you today is that the evidence received on this motion for preliminary injunction shall become part of the trial record. As you know, you're set for trial in December. I don't need to go into the dates and the pre-trial conferences, but that's still set. And I know that there are no remote witnesses today because nobody asked for them, so we've taken down the need and the electronics for that. There's one other thing. We're going to go straight through my court reporter, and I tend to go longer than people need breaks, but if anybody needs a break, you just raise your hand and say that we need a break. Okay, I want to try to get this all done today. I'm prepared to go into the evening. I will stop at approximately 2:30 to allow my criminal sentencing to proceed on time. It should not be a long one. You all can take a break. My hope is that we get all the evidence and opening in whatever before my criminal sentencing. I'll do that. You take a break, and then you come back with closing argument. But this is a dynamic situation. I may change my mind on exactly how it plays out, but I just want to tell you, that's the plan today. Any questions about the plan on behalf of the plaintiff? Mr. Pernini, no, Your Honor. The court, on behalf of the defendants. Mr. Kingston, we're good, Your Honor. Thank you. The court, okay. Thank you. All right. Then, at this time, I'm going to take up opening statements. Pursuant to instructions that you all received earlier, I believe each side gets 15 minutes. I won't cut you off in the middle of a sentence. You know, this is pretty much a mini bench trial, but keep in mind that, we need to get through this today. All right, if you wonder whether I prefer the podium or counsel table, that's your preference. Just stand when you're addressing the court. If you have an objection, just stand. I'll acknowledge you. Witnesses, I have a slight preference for you to stay at counsel table, but really that's up to you. I know a lot of other federal judges are much pickier on that, but that's up to you. With respect to approaching the witness, you ask me the first time if you want to approach the witness, but you'll have continuing permission to approach the witness after I give you permission the first time. Okay, any questions on behalf of plaintiff? Mr. Anderson, no, Your Honor. The court, defendants. Mr. Kingston, we understand, Your Honor. The court, okay. Then at this time, let's go ahead with opening statement for the preliminary injunction by the plaintiff. Go ahead, Mr. Anderson. Good morning, Your Honor. May it please the court. Your Honor, we're here seeking an injunction on behalf of Susquehanna, which I'm going to refer to often today as the ticket. We're here today because certain defendants. The court, it's easier to pronounce, so that's great. Mr. Anderson, yes, Your Honor. The court, do you mind if I refer to it that way? Mr. Anderson, that'd be fantastic. The court, your client that way. Mr. Anderson, perfect. The court, okay. Mr. Anderson, thank you, Your Honor. Susquehanna, the ticket, it's referred to as a radio station, but it's much more than that. It's an audio media company. I think there was a time, Your Honor, when we all thought about a commercial radio station as the thing we tuned in our radios to, whether we're in the car, whether we're sitting around the fire at home. But that's not really what a commercial radio station is today. Things evolve, as has radio stations, and they have the concept of radio station has a very different meaning today than it did 50 years ago, 25 years ago, and definitely within this past decade. We've seen significant changes in what it does. It's an audio media company today. It does a lot more than broadcast on radio. And that's true for the ticket. The defendants here are former employees of the ticket. They were on-air talent. They weren't always on-air talent. Defendant McDowell was. But Defendant Kemp had other roles and then ended up being an on-air talent. And they had a show from 12 to 3 o'clock, Monday through Friday, called The Hang Zone. They had that from February 2020 until they left employment here at mid-July 2023. As part of that show, which was broadcast on the radio, there was streaming available from that people could listen to it from their phones. They could listen to the Hang Zone, and then portions of the Hang Zone were broadcast or uploaded into podcasts. Various 2 to 3 podcasts from the ticket, which would contain excerpts, and this, that, and the other from the hang zone that contained both defendants talking. In addition to the hang zone, the defendants also did provided some original content outside of the hang zone for the ticket. And we'll get into that with the evidence today, Your Honor. But I think that's important, that these weren't just 2 folks on a radio station from 12 to 3 o'clock. They also did a number of other functions and things for the station, including providing original content for podcasts for the station. And I think one critical part of that, Your Honor, is that when they were doing all that, not just the 12 to 3 o'clock show, Your Honor, but also providing content and going to events and promotions and providing content for original podcasts, that was all part of their job duties. And, as we'll see today in their employment agreements, it's right, they're listed as part of their job duties. Again, this isn't, the ticket is not just a, particular number on a dial. It is a brand. It is an audio media company. And these folks, the defendants, in connection with their job duties and responsibilities, had to do a lot more, including provide content for podcasts. Now, there were some contract negotiations that took place, Your Honor, the past few months leading up to their departure in July. Suffice it to say, they couldn't come to an agreement and they left. That's all well and good. But the moment they left, Your Honor, they immediately started up a competing podcast, and that's one thing. But to add insult to injury, the podcast was the exact same show they did for the ticket. But instead of calling it the hang zone, they called it the dumb zone, which, as you'll hear today in the evidence, Your Honor, that name was used frequently during the hang zone episodes for the ticket. So they basically take the same show, change the name ever so slightly to use a name they were already using at times for the hang zone, and then start uploading podcasts that have the same format, same kind of show content, marketed to the same kind of listener base. It's just a copycat, the same show, but now they're doing it outside the ticket in a podcast forum. You're going to get to hear today from the evidence, Your Honor, whether it's podcast or whether they got a YouTube channel, it all competes. I think one really important thing you'll hear today is that, any average listener has only a finite amount of time that they're going to devote each day to listening to audio content. Right. And so for me, for example, that might be 40 minutes a day driving a car, listening to podcast on my phone, or listening to streaming. But whatever an average person devotes to a day, any audio content that they're going to listen to, it's you're competing with something else. So if you're going to listen to 40 minutes of a podcast, that means less time for radio and things of that nature. So everybody that's providing audio content within this Dallas-Fort Worth area is competing for a person's attention. Right. Just the amount of time they'll give a day for to give attention to whatever audio they want to listen to, cause we got to work. Now, they're going to argue today, I think, Your Honor, because they have in pleadings, that because they are a fee subscription podcast behind a paywall, how can that possibly compete with free programming from the ticket? And it's real easy, Your Honor. They are directly competitive. You'll see evidence today that listeners are leaving the ticket to go follow the defendants to their podcast regardless of whether or not it's fee-based. And again, they're all competing for the same time. And I think a big piece here is it's not just a 0 to 3 o'clock time slot. Because the defendant's podcast can be uploaded anytime, now it's not just a 12 to 3 o'clock you're competing with. Listeners can listen to that anytime. So now, you're talking about competing with the ticket's morning show, evening show. And it's cutting into all that. Now, competing is one thing, but then using that competitive in violation of their non-competes, using this competitive podcast to not only compete but also to throw the ticket under the bus, to disparage them, to talk to cast them in a negative light, all in an attempt to garner more of the ticket's listener base so that they'll go over there and pay these fees for the defendant's podcast. It's adding insult to injury. And the net result of all that, Your Honor, is that my client is being irreparably harmed. Their damaged reputation, their goodwill and reputation is being dragged through the mud. And how do you put a value to that? How do you put a number, a dollar amount on someone's reputation? Listeners, as you'll see today, Your Honor, listeners have been sending hateful emails, communications to my client. Their reputation is not just being tarnished, it's being greatly hindered. And you'll hear evidence today that their ratings are falling as a result of that. There's not any possible way I can think of that. The measure of harm that my client sustained could be calculated in some, monetary dollars and cents that would encapsulate the total harm. You might be able to pinpoint, okay, there's a loss here and a loss there, but not the full harm. You just can't do it. The harm is irreparable, and it's immediate. It's happening. It's been happening. I wish now we would have had this hearing 3 weeks ago, because we need this action stopped. We need their podcast stopped. but I want to draw your attention. The court, wait a minute. You all agreed between last time and this time to an order that the court signed, which was agreed to by you all. I didn't have much to do except signing the order as to what would be acceptable and what wouldn't. So the conduct you wanted stopped was agreed to by you and your client. So I want to make that perfectly clear. So your statement that you wish it would have been done multiple weeks ago and now you all had me sign an order, then had me sign another order where you reached agreement. So I don't find that very persuasive of an argument. Right there, Mr. Anderson, Your Honor, all apologies. All I meant by that not trying to do anything to the court. Just knowing what I know now about how the last couple of weeks were going to go, I wish we would have just gone forward. That's all I'm saying. The court, okay. I don't think that's what you said, but I just wanted to make sure that all right. Then I understand what you meant to say. Continue, Mr. Anderson. So let's look at the non-compete for just a second. It's 6 months. It is a very short time, compared to, as Your Honor knows, a lot of non-competes that are enforced in this state, whether by federal courts or state courts, of a year, year and a half, 2 years. This is a 6-month window, and you'll hear evidence today as to why. That's a minimum amount of time. It's a very short time that it is necessary to protect the company's interests. So that is, with respect to the non-compete, Your Honor. But it doesn't stop there. Their conduct goes beyond that. There were websites and social media accounts created with respect to the Hang Zone. I believe the defendants are going to argue, well, we paid for that stuff, so it's ours. And that couldn't be farther from the truth, Your Honor, because under their contracts whatever is created in connection with their jobs belongs to the ticket. And if they had a budget for their jobs at the ticket, and if there were costs associated with websites or social media or whatnot, all they had to do was seek reimbursement, and there was a budget for it, and it would have been reimbursed. But they didn't seek reimbursement. They don't get the benefit of saying, well, because I didn't seek reimbursement, I get to keep it. So they hijacked the Hang Zone website and social media accounts, changed them to the Dumb Zone in order for customers that used to go to Hang Zone to now find the Dumb Zone. I think, Your Honor, just to wrap it up, what we're asking for is a very short preliminary injunction in terms of 6 months. We're going to have trial before 6 months. 6 months from when they left, or from when they first violated it, will be mid-January. We're going to have trial before then, so that makes a preliminary injunction entered today even that much more reasonable. We'll get to the trial before we get to the end of that 6 months, so it's more than fair. It's very geographically reasonable because it's just in the Nielsen-rated Dallas-Fort Worth area market, which is roughly 9 counties or so within around the DFW area. It's 6 months. And it wouldn't prevent them from doing a podcast available to somewhere, in Austin or Houston. But I get that they want to do it here. But their non-competes don't allow for it. They're in direct violation of it. We have a likelihood of success on the merits for both the non-compete violations and for the taking of the websites, the taking of the property. For those reasons, Your Honor, we are asking for a preliminary injunction to be entered today and to be held in force through trial. Thank you. The court, okay. Thank you. Opening on behalf of the defendants. Mr. Kingston, yes, Your Honor. The court, and thank you, counsel, for giving back some of the time. Mr. Anderson, yes, Your Honor. The court, all right. Mr. Kingston, Your Honor, we have a very simple story here. These guys worked at the ticket for a long time and they ultimately couldn't reach an agreeable contract for their next however long they were going to work at the ticket, and they simply left. As is often the case in a contested case, Your Honor, our view of the facts is quite different from Mr. Anderson's good presentation. What my clients have said to me over and over is that what they were trying to do when they left was be cool. They didn't want to hurt the ticket. They have friends at the ticket. You're also going to hear today that they were, apparently, very reasonably frightened of litigation. So what they did was they put their work behind a paywall. They don't do a live broadcast. They don't even publish the podcast in their own time slot, the old time slot that they had for the ticket. I thought Mr. Anderson's statement that the fact that you can listen to the Dumb Zone anytime means that it's competing with the entire ticket content is a very odd thing to say. We view it the exact opposite way. We're not competing with them. Mr. Anderson also referred to the listeners of the ticket as customers, and that's going to be a key difference today, Your Honor. The ticket's customers are not listeners. The ticket's listeners are the product. The ticket's customers are advertisers. You will hear today, well, I don't know what you're going to hear today, Your Honor. We have a sworn pleading that I don't believe will be backed up by sworn testimony in your court today. I believe that plaintiff has finally come to the realization that Dan and Jake do not advertise and have not interfered with the advertisers of The Ticket. So, I don't know, we'll see what we'll hear today. This is a different audience that Dan and Jake are seeking. You'll hear them explain what the difference is. The Ticket seeks a very narrow audience. They seek a much broader audience. You're going to hear that Susquehanna, I'm sorry to use that name. I know it's not as friendly as The Ticket, but Susquehanna owns many radio stations. It is not The Ticket. It is a large organization. The reason that's important for the court is because the plaintiff continually promotes the wrong measure of irreparable harm in this court. This court is applying the federal standard of irreparable harm, which includes, as Judge Kinkead has taught us, if you are alleging loss of revenue as a business, you must also allege and prove that you risk bankruptcy or financial ruin from the competitive activity. I don't think any witness will back that up today, Your Honor. They're not disparaging their former colleagues, their friends, the work that they do. I think the court has probably already listened to the clips that we have sent to the court. I think you probably listened to the clips that plaintiff has pointed to as disparagement, and in no case are these disparaging. In fact, they're quite complimentary. Even when my clients have discussed their departure from The Ticket, they have done so in ways that I think are designed to treat it as a business dispute, not intended to harm The Ticket in any way. You're going to hear from Adam Romo today, Your Honor. He's the CEO of IATSE's, a very important advertiser for The Ticket. What you're going to hear is that podcasting is so important to The Ticket that he never, ever heard from The Ticket about their podcast, that he was never asked to advertise in a podcast, and the podcast were never monetized. For IATSE's, you're also going to hear Mr. Romo talk about his relationship with Dan McDowell, and you're going to hear him tell the court that Dan McDowell specifically told him to continue to advertise with The Ticket, the exact opposite of this entire, very lengthy series of allegations from the plaintiff. And then you're going to hear the plaintiff's allegations. I don't know to what extent they'll be backed up by witness testimony, but I can say 3 things about what has been filed with this court. It is false, it is sworn, and it has not been withdrawn or amended. I think those are 3 bad things. The other thing I would like to draw the court's attention to is the definition of a podcast. It is true that Susquehanna's parent corporation runs a network of podcasting. It is not true that Susquehanna makes money from podcasting. That will be interesting today. We agree with the court that the definition of immediate risk of irreparable harm is very hard to meet when the plaintiff has agreed to a month of the conduct that it now contends to the court threatens its business. The court will hear about the magnitude of the revenue that defendants are generating compared to the magnitude of the revenue that plaintiff generates. And I think that is interesting both from the standpoint of irreparable harm but also from the standpoint, as I discussed earlier, of whether this actually threatens the existence of Susquehanna. Last thing I just wanted to mention because I think you'll be interested to hear it, and it will be ultimately the subject of an affirmative defense or maybe even a counterclaim. My learned brother said that the defendants had a budget that they could pay for these websites and social media accounts that they created to promote plaintiff's business, and that's not true. We'll hear more about that later. Your Honor, just to finish off the opening, no good deed goes unpunished, and that's what you're going to hear from the witnesses today. The court, thank you, counsel, and thank you, also, on giving back time to the court. I just want to make clear that today is the evidentiary hearing on the application for temporary preliminary injunction. So what is presented today by both sides is critical to the court on making a determination. Reliance on pleadings or what counsel says in statements or argument is not what I consider evidence. So this is a very factually based determination by the court, and so that's how I'm viewing today. So call your first witness, Mr. Anderson. Yes, Your Honor. Plaintiff calls Jeff Catlin. The court, thank you. Sir, if you'll take the stand over here, raise your right hand. Whereupon, the oath was administered by the court. The court, please have a seat. Make yourself comfortable. Bring the microphone in front of your mouth. And, when you and counsel are ready, go ahead. Mr. Anderson, Your Honor, do you mind if I do you? Have a preference if I stand or sit? The court, you can do either one when you're examining the witness in this bench trial. Go ahead. Mr. Anderson, thank you, Your Honor. Whereupon, Jeff Catlin was called as a witness and, having been duly sworn, testified as follows. Direct examination by Mr. Anderson. Q. Good morning, Mr. Catlin. A. Good morning. Q. Will you please state your full name for the record? A. Jeff Catlin. Q. Mr. Catlin, where do you currently work? A. I work at The Ticket, Susquehanna Media Corporation. Q. What's your title there? A. Operations Manager. Q. Okay. When did you first begin at The Ticket? A. March 1st of 1994. Q. Mr. Catlin, as a preliminary matter, you're here today on behalf of Plaintiff Susquehanna Radio, LLC. A. Yes. Q. And so I oftentimes may use that interchangeably with the ticket. That's the station you're the operations manager for. A. That's correct. Q. If I mention the ticket, you'll know I'm talking about Susquehanna as well. A. Yes. Q. With respect to your current role, I'm sorry. When did you first begin at the ticket? A. March 1st of 1994. Q. Okay. And what was your job title at that time? A. I was afternoon producer. Q. How long did you have that position? A. Until 2000. Q. What position did you take at that time in 2000? A. In 1996 I was promoted to assistant program director. I stayed with the same company but moved to Kansas City, where I was a program director for 7:10 a.m. KMO. And I returned, again, same company, in March of 2003 to become the program director of the ticket. In 2008 I was promoted to operations manager for the cluster of the stations that we had in Dallas, and I've held that position ever since 2003. Q. What are your job duties and responsibilities as the operations manager? A. I oversee all the on-air content, all the on-air programming, all the on-air talent, the support personnel, such as producers and board ops and anchors, any of the on-air commercial production, station events, station marketing and branding, the brand manager, those kind of things. Q. Just briefly, you know the defendants, obviously. A. Yes. Q. Mr. McDowell and Mr. Kemp. It's fair to say you were their boss. A. Yes. Q. They reported to you. A. Yes. Q. As the operations manager for the ticket, can you please explain what the ticket is? A. The ticket is a brand. It's a media company. It provides entertainment and content throughout Dallas-Fort Worth to listeners. Q. Ever heard the term commercial radio station? A. Yes. Q. What's that mean to you? A. It's a broadcast entity that provides content in the market, whether that's on air or podcasting or streaming. And we do events. We do a variety of things. Q. Now, when I grew up listening driving down the road, when I first turned 16, I listened to radio in my car or in a boombox I had in my room. And that's what I viewed as a radio station. Do you view the ticket as being under that definition? Is the ticket a radio station within that confine? A. Yes. Q. Is it anything beyond that? A. Yes, it is. Q. For the things you just mentioned here. A. Correct. Q. You said some things about podcasts and streaming. Do all those things just to click off some things I heard. You said a brand. A. Yes. Q. Concert promoter. A. Aha. Q. Events. A. Yes. Q. Did you say podcast? A. I did. Q. Did you say streaming? A. Yes. Q. Did you say social media? A. I did not, but we do have social media presence. Yes. Q. Are all those things, those functions, do those fit within what you would define as a commercial radio station? A. Yes. Q. Does that fit the description of the ticket? A. Yes, it does. Q. In what formats does the ticket provide its content? A. We broadcast live over the air on a radio, as you mentioned. We also provide on-demand audio in podcast form across a variety of platforms. We stream our content online through apps and websites 24 hours a day, 7 days a week. Q. All right. We've heard a lot about podcast. We'll hear a lot more, I suspect. Do you know what podcast is? A. Yes, I do. Q. What is a podcast? A. Podcast is on-demand content that you can save and listen to at any time you would like. Q. Is it? I think of it like talk radio, which you can listen to on demand. How do you feel about that definition? A. Correct. Q. What's the difference between podcast versus traditional radio broadcast? A. Radio broadcast traditionally is happening in real time. If you don't listen to it at that moment, you've missed it. A. Podcast is audio content that's available, and you can download it and save it and listen to it at your convenience, whenever you want and as often as you want. Q. You mentioned, also, streaming. Can you explain the difference between podcast versus streaming? A. Yes. Again, podcast is something that is on demand that you can save and listen to later or listen to as many times as you want. Streaming is a digital version, an online version, of a radio broadcast that's happening online in the moment, live. You can't save it and you can't download it. Q. But the streaming, can you listen to that on a phone? A. Yes. Q. Can you listen to traditional radio broadcast by phone? A. No. Q. Podcast, can you listen to that by phone? A. Yes. Q. Does the ticket stream any of its shows or content? A. Yes, it does. Q. Does the ticket provide any of its shows or content on podcasts? A. Yes. Q. Can you elaborate on that? What podcasts does the ticket put out? A. The ticket has 3 different podcast channels. One of them is called the Ticket Top 10, and we provide daily highlights of all of our primetime, Monday through Friday, 6 a. to 7 p. shows on that channel. We have another channel which we provide special content, original, never before aired content, in podcast form on that channel. And then we have a third channel that is a daily repeat of a segment that happens on the air called Why Today Doesn't Suck. Q. The one that has original content on it, do you know what that one's called? A. It's called Sports Radio 96.7 and 1310 The Ticket. Q. You mentioned some original podcast content. A. Yes. Q. What kind of original content podcast does the ticket traditionally put out? A. Well, depending on the season, we could do special original content, say, around the NFL draft, maybe around the Super Bowl. We do in-season shows for the Texas Rangers, the Dallas Mavericks, the Dallas Stars, college football that are all original content podcasts available only on that channel that have never been on the radio station before through the traditional method. Q. With respect to whether it's radio broadcast or streaming or podcast, do you charge a fee for that? A. No. Q. Do you try to monetize that? A. Yes. To my knowledge, yes. Q. Each one of those. A. I believe so, yes. Q. How long has the ticket been streaming its broadcast? A. Around 1996. The court. I don't know what you mean, and the witness means by you try to monetize that. So since I'm the one who needs to understand, Mr. Anderson, Your Honor, the court, you might ask a follow-up question. Mr. Anderson, I will, Your Honor. I'm just recalling. That's more of a Dan Bennett question. My next witness. The court, well, you asked this witness. I have no idea what that means. Mr. Anderson, yes, Your Honor. The court, in the context of this litigation. But, go on, Mr. Anderson, I'll follow up. Q. Mr. Catlin, we're just when you said that the ticket tries to monetize using its different audio formats. What does that mean? A. We have ads in our podcast channels, yes. Q. Can you elaborate a little bit more on how you monetize? Using ads. A. We place ads within the podcasts and our sales team would sell those to clients. Q. So if a listener wanted to obtain a podcast from the ticket, listen to it, how would they go about doing that? A. They could do it a variety of ways. Our podcasts are available on our website. You could do it through Apple Podcast app or a Spotify app or any third-party podcast service that you could get on your phone. You could listen to it there. The podcasts are also available on our station-specific apps, Sports Day Talk app or the Ticket's Susquehanna app. Q. So if a listener using one of those methods you just mentioned downloaded or accessed one of the Ticket's podcasts and listened to it, would they likely hear an advertisement? A. They likely would, yes. Q. And so, for example, you mentioned earlier, I think, let me ask you this, were any portions of the Hang Zone that the defendants were the host of, were any portions of the Hang Zone put into podcast form for the ticket? A. Yes, they were. Q. And were there any advertisements played in those podcasts? A. Yes. Q. And those advertisements would be a way for the ticket to make money. A. Correct. Q. On podcasts involving the defendant's content, not their content, but the Hang Zone. A. Correct. Q. How long, and I apologize, I think I asked this but I don't recall your answer. How long has the ticket been streaming its broadcasts? A. Since around 1996 or 97. Q. Okay. What percentage of its broadcasts are streaming versus traditional radio broadcast? A. I'm sorry, I don't understand your question. Q. Sure. Of its broadcasts, there's traditional radio, there's streaming. A. Okay. Q. What percentage, if you know, of is the streaming? A. 100%. Q. Of the content that's put out by I get from your answer that 100% of its content is streamed. A. Aha. Q. So streaming versus just radio, have you seen, from a listener standpoint, more listeners for traditional radio, more listeners for streaming, or do you track that? A. We do track it. About 25% of our listening audience listens on the stream. That's been as high as % of our audience streaming the station during the pandemic. But, generally speaking, it's about 25%. Q. And how about the podcasts? When did the ticket first start uploading podcasts? A. I mean, probably around 2009. Q. Mr. Catlin, you've got an exhibit notebook in front of you. A. Yes. Q. If you write there to your left, if you'll take that and open that up to Exhibit 11, I'll ask you to take a look at that for a second and ask if do you know how emails are. When there's multiple emails, sometimes you have to start at the bottom and work your way up. A. Yes, Q. If you're looking at that, Mr. Catlin, do you recognize that document? A. I do. Q. What is this document? A. This is an email to me from me to several ticket employees from October 9, 2019, regarding the use and distribution of content across the Ticket podcast channels. Q. And the date of the original email, October of 2019. A. Correct. Q. And I see is that defendant Kemp on the email chain. A. Yes, he is. Q. And just in short, what are you trying to convey in this email? A. I'm trying to make sure that the right Ticket podcast content is going to the right podcast channel. Q. And the podcasts referenced here, these are the same kind of 3 podcast channels you referenced earlier. A. Yes. Q. So we know that it's fair to say I think you said earlier that you started uploading podcasts in 2009. A. Approximately. Q. And we know that at least in 2019, you've got what looks like at least 3 podcast channels. A. Yes, Mr. Anderson, Your Honor, I'm going to try to save time today. We haven't really conferred with opposing counsel on the pre-admission of certain exhibits. I'll move to admit Exhibit 11 into evidence. The court, all right, let's do this. Let's stop the time. If there are exhibits by I have notebooks up here, one on behalf of a substituted one by the plaintiffs. It has a total of 37 exhibits. And the other one I have an exhibit binder on behalf of the defendants, and it has the same binder that was given to me weeks ago by the defendants. If you know which ones are agreed to for purposes of the hearing, and I think we should all agree to whatever the exhibits are for the hearing. But if you will state them by number and just offer them, in total, I offer. Listen, the court's talking. Okay. If you offer exhibits, I'm doing a hypothetical 1 through 26 on behalf of the plaintiff, and there's no objections. The other side will say no objections, and this will switch to them, and they'll be admitted for purposes of this hearing. Also, it's trial exhibit 2. If there are some that are agreed to but not all, then state the numbers. You have agreements to 1 through 13, 20 through 22, you'll say no objections, and they'll be admitted, and then you don't have to do anything further. Does that make sense, Mr. Anderson? It does, Your Honor. The court, do you know how many? So go ahead and offer those to which there's agreement. Mr. Pernini, well, Your Honor, we have not conferred. That's what he was saying, we have not conferred. Either side has not conferred with each other about which ones are objectionable or not. The court, then, have you given the exhibit binders? 2. Mr. Pernini, yes. The court, have you exchanged them? Mr. Pernini, we have. The court, do you have objections to any of their exhibits? Mr. Cawley, I do not have any objections to any of their exhibits, with the caveat that there are 2 exhibits that there's some hearsay in. I don't have a problem with the exhibit coming in, just to note that I think it's being the documents are being used for something other than to prove the truth of the matter asserted. The court, well, when those exhibits come in, you can make your objection. But and what documents are those? What numbers? Mr. Cawley, Exhibit 20, 21, and 23. And I don't have any objections to the remainder. The court, okay. So other than so at this time, plaintiff, go ahead and offer as exhibits, carving out those, and we'll do it in a nice, clean way. Mr. Anderson, Your Honor, at this time plaintiff move for admission of physical exhibits 1 through 37 and audio, exhibits A1 through 18. The court, I'm sorry, Mr. Anderson, well, there's physical exhibits of 37. There's audio. Are we moving to admit those? Mr. Pernini, there's audio, Your Honor, of the defendants speaking. So, whether that's an exhibit or just something to Mr. Anderson, we might just play it, Your Honor. The court, I'm going to hold off unless there are. As far as exhibits go, if you don't talk about it, you don't have a witness talk about a specific exhibit. This is what I do in my jury and bench trials. The witness actually needs to address them. Okay, so subject to a witness addressing or talking or reviewing very quickly or thoroughly, you're offering 1 through 37. And, Mr. Anderson, that's it for now, Your Honor. The court, excluding Mr. Anderson, Mr. Cawley, 21 and 23. Mr. Anderson, 21 and 23. The court, okay. Excluding exhibits 21 and 23, any objections to 1 through 37 at this time? Mr. Cawley, no objections, Your Honor. The court, admitted for this hearing. Plaintiff's exhibit numbers 1 through 20, 22, 24, through 37 admitted. The court, let's go ahead and take care of the defendant's exhibits. Same procedure. Which ones are you offering? Mr. Cawley, we're offering exhibit 1 through 27. The court only has 25 here. Mr. Cawley, 26 is an audio clip. That's on a flash drive. The court, all right, we got that. Mr. Cawley, and then I provided a paper copy of 27. The court, okay. and that was brought to my attention. Yes. Any objections to those? Mr. Pranini, I don't know that I got the paper copy of. Your Honor, from the point of view of authenticity, we have no objection. The court, I'm just look, you want to do it. The easy way, this is the way I do it. Any objections? Through 1 through 27 for the purposes of this hearing. And if there are objections, then we'll carve those out. If not, we're going to admit them. So both sides can do this as quickly and efficiently as possible. Mr. Pranini, just give me one moment on this exhibit. The court, I'll tell you what, is the only one you're worried about. Number 27. Mr. Pranini, yes, Your Honor. The court, how about 1 through 26? Any objections? Mr. Pranini, we do not, Your Honor. The court, all right. The court admits exhibits number 1 through 26. I think since 27 was a new exhibit, plaintiff's counsel are entitled, maybe at the next break, to look at it to see if they have any objections. So at this time, we'll go back to questioning the witness, and the timekeeping will begin. Defendant's exhibit numbers 1 through 26 admitted. The court, so continue. Mr. Anderson, thank you, Your Honor. Q. By Mr. Anderson, Mr. Catlin, so if I understand you correctly, there are 3 channels now that the ticket broadcast its podcasts. A. Correct. Q. Is that correct? Are there any other ways, avenues for a listener to get other podcasts from the ticket, or is it only those 3 channels? A. Those 3 channels, plus we have a YouTube channel as well. Q. On the do you know how long the tickets had a YouTube channel? A. Yes, I do. Since 2014. Q. And if we look at exhibits 4, start with 4. I'll ask if you recognize that. A. Yes. Q. What is that? A. That is a screenshot of the ticket's YouTube channel. Q. Okay. And is this representative of the YouTube channel you had since 2014? A. Yes. Q. And looking at Exhibit 5, see if you recognize that document. A. I do. Q. What is that? A. That is another screenshot of content that was uploaded to the ticket's YouTube channel. Q. And looking at some of these screenshots, the top left screenshot, do you see Defendant Kemp there? A. Yes. Q. Is that podcast related to the Hang Zone? A. No. Q. What is that? A. That's a podcast related to a Cowboys halftime show. We do a special podcast only, online only version of Cowboys halftime for every Cowboys game. Q. Is this one of the original content podcasts you mentioned earlier? A. Yes, it is. Q. How about the lower left corner, the hooded figure there? Is that Defendant McDowell? A. Yes, it is. Q. And do you have any understanding as to what that podcast relates to? A. Yes, that was an original content podcast uploaded to YouTube around a station event called The Ticket Compound. Q. Was this part and parcel of the Hang Zone show he did? A. No. Q. Were they the creation of these original content podcasts for the ticket part of the duties and responsibilities for Defendant McDowell and Defendant Kemp in connection with their employment? A. Yes. Q. They had to do that as part of their job for you. A. That's correct. Q. How far back can a listener go if they want to find podcasts that would have been published by the ticket? How far back can that listener find podcasts? A. Many years. I just did a research project the other day, and it went back. The podcast I looked for was from 2016 and it was still accessible. So I know at least as far back as, but probably before that. Q. Let's switch gears a little bit, Mr. Catlin. Have you ever heard of the word geofencing? A. Yes. Q. Can you spell that? A. Geofencing. Q. I was testing you. Good job. What is geofencing? A. Geofencing is something you can do online in a digital form to put a digital barrier around certain areas. Q. From a broadcasting standpoint, radio, podcast, streaming, whatnot, how does geofencing have any relation to those components? A. Yes, it does. Q. How? A. You could limit the ability of people to listen or watch programming based on a geofence that was set up. In fact, the ticket streams the NFL games, but we have to create geofencing to make sure that certain areas of the country can't listen to the games via the stream. Q. So it restricts access within certain geographic areas. A. That's correct. Q. In this kind of situation here, we're here about today, if the defendants were to create a podcast here in Dallas from their home and broadcast that, could geofencing be used to make sure no one in the Dallas-Fort Worth area could access it? A. Yes. Q. But listeners outside the Dallas-Fort Worth area could access it. A. That's correct. Q. And have you had experience? You have had experience doing that with football games? A. Yes. Q. Let's talk about Mr. McDowell and Mr. Kemp. How long have you known Mr. McDowell? A. Since 2000. Q. how about Mr. Kemp? A. Sometime after that, maybe 2003 or 2004. Q. How is it you came to know Mr. McDowell? A. I was the assistant program director of the Ticket and he came to town to interview for a job and at the Ticket and I met him at that time through that process. Q. Were you part of the process to hire him to the station? A. Yes. Q. Was he always a talk show host for the Ticket? A. Yes. Q. And how about Mr. Kemp? What was the nature of you first meeting him? A. He was an intern for the Ticket at that time. Q. And how about his job? Was he was an on-air talent at the time he left? A. That's correct. Q. Can you walk us through, briefly, kind of the different roles he had? A. Sure. He would have been an intern first and then we hired him as a part-time person, probably to run the board, maybe be a show producer. And then he was promoted to full-time, again, to run the control board. He was promoted again to host the Ticket Top 10, which is our nighttime show. He was then promoted again to be a board op during the weekdays, and then promoted again to be the producer of what was known at the time as the Bad Radio Show, Monday through Friday noon to 3 o'clock. And then, finally, in February of 2020, he was promoted again to be a co-host of what became known as the Hang Zone. He held that position until just a few months ago. Q. Fantastic job with clarity. I might ask that you slow down a little bit for the court reporter's benefit just to make sure that, A. Yeah. Q. We're able to get everything down. Okay. So at some point Defendant McDowell and Defendant Kemp began to do the Hang Zone together. A. That's correct. Q. And when was that? A. That would have been February of 2020. Q. And was there a predecessor show that Mr. McDowell's already a part of? A. Yes. Q. Is that the Bad Radio you talked about? A. Yes. Q. What was the Bad Radio? A. It was Bad Radio. It was an acronym for Bob and Dan Radio. It was weekdays, noon to 3 o'clock, with Dan McDowell and Bob Sturm. Q. Was there any circumstance that happened that led you to bring on Jake Kemp to partner with Dan McDowell for the show? A. Yes. We had another on-air talent at the Ticket retire, and so we had an opening. And at that time I moved Dan's current partner Bob Sturm to another daypart, creating an opening noon to 3 o'clock. Q. And Jake Kemp took that spot. A. Yes. Q. So when the show started, was it called the Hang Zone? A. No. Q. Was it still Bad Radio? A. Yes. Q. Why didn't it get called the Hang Zone from the beginning? In February of 2020. A. Because show names tend to come up organically. When a new show is put together, new personalities work together, they need time to evaluate and grow and see what show name would fit their show best. And so at that time they kept using Bad Radio. Q. Who made the decision to put Defendant McDowell and Kemp together? A. I did. Q. Now, have you been a part of the creating new shows and content in the past? A. Yes, I have. Q. And in your experience, how long does it typically take for a new program or show for the Ticket to kind of get up and running? A. I would say at least 6 months to a year, sometimes longer. Q. You mentioned it taking a while. Well, let me ask this. You said it took a while for the Hang Zone name to be used. Was the Hang Zone what replaced the name Bad Radio? A. That's correct. Q. Do you know approximately when that happened? A. Yeah. About almost a year later. Maybe January of 2021. Q. So if the show started in February 2020, for almost a year it operated as Bad Radio with Mr. McDowell and Mr. Kemp. A. That's correct. Among other names. Q. And then there were other names used in addition to Bad Radio. A. Bad Radio was one, Super Bad Radio was another. Q. And then how did the Hang Zone name came to be? A. It was just created, I'm sure, through those two defendants talking about it, consulting with me, getting feedback from other people. It was one of many names considered at the time for the show. Q. Let's look at Exhibit 12, Mr. Catlin, in your notebook. There. I ask you if you recognize that document. A. I do. Q. What is that document? A. That's an email from Dan McDowell to me, January of 2021, asking me to record a script for the Ticket's voice talent. Q. It's roughly 11 months after the show creation. A. That's right. Q. And I note that the attachment states Conrad, script Hang Zone January 18, 21. Do you see that? A. Yes. Q. And if we look at that attachment, the next page, what do you understand that attachment to be? A. That's a copy of script that we were going to have our Ticket voice talent record with various names for the Hang Zone that were under consideration. Q. All right. A. Including the Hang Zone and the Dumb Zone. Q. All right. Those were names that were I know. It was eventually called the Hang Zone. Were any of these other names used from time to time in connection with the show? A. Yeah. The dumb zone was used from time to time, from that point all the way through the conclusion of the show, just a few months ago. Q. How was the dumb zone used? A. As a joke, as a punctuator, as an on-air reference when any of the guys or someone on the show said something dumb, they would say the dumb zone. They would play this piece of audio that was recorded from our voice talent to make fun of it. Mr. Anderson, so we got an audio clip, Your Honor. I just want to play and see if this is the same thing he's talking about. Play A8. Plaintiff's audio exhibit 18 played. A. That's it. Q. That's what you were talking about. A. Yes. Q. And that would play during the broadcast of the hang zone. The dumb zone drop would happen. A. Yes. Q. All right. If we look at exhibit 14 and see if you recognize that document. A. I do. Q. What is that? A. That's the hang zone website. Q. In connection with that website, I note in the top left corner, do you see where there's a little banner that hangs down with the dumb zone crossed out? A. I do. Q. Is that from your recollection? Is that always the case? When the hang zone website, this website got put up, it had that dumb zone name in the background. A. Yes. Q. All right. Did Mr. McDowell and Mr. Kemp have any budget allotment for the nature of their work for the ticket? A. Yes, they did. Q. Can you elaborate on that? A. Yeah. They had what we call a show promotion budget, specifically for their show, but it was through the overall ticket programming budget through my department. And they could use that to spend on things like travel, regular guests, for their show, production value music, promotional items and giveaways, things of that nature. Q. Those are the types of expenses. A. Yes. Q. How about would cost for hosting websites be something that can be included within the budget? A. Yes. Q. How about expenses related to any social media to promote the show? A. Yes. Q. If the defendants wanted to get reimbursed for any such expenses, how would they do that? A. They would bring the receipts in, fill out an expense report, turn it in to me. I would sign it and approve the expenses and turn it into the business office and they would get reimbursed. Q. To the best of your recollection first, you'd be the person that would oversee or approve the expenses. A. Yes. Q. To the best of your recollection, did defendants ever seek reimbursement for securing or hosting the website for the hang zone or any cost related to the social media accounts for promoting the hang zone? A. Not to my recollection, no. Q. If it happened, you likely would be the person that would know. A. Yes. They would have turned it in to me. Q. Did they ever seek reimbursement for any other types of operational or promotional expenses related to the hang zone? A. Yes, they did. Q. What type of things? A. As I mentioned, production value music for the show, promotional items to give away to their guests and listeners, those kind of things. Q. And did the ticket reimburse them for expense? Reimbursements. A. Yes. Q. Does the ticket have confidential information that it deems proprietary and confidential to itself? A. Yes, it does. Q. What types of information does the ticket deem to be its proprietary and confidential information? A. Ratings information and ratings analysis, marketing plans, marketing and listener research, competitive analysis, those kind of things. Q. With respect to ratings, are those public? A. No. The ratings are only available to those stations or groups that participate and pay for the information. Q. And does the ticket pay for that information? A. Yes. Q. And then the reports the ticket gets with respect to ratings, who does it get those from? A. Nielsen. Q. And is it the report itself that a company deems confidential? A. No. The raw data is not confidential, but what is confidential is the way that data is interpreted and then used to help grow the radio station's listener base and the individual shows that are on the radio station. We analyze that ratings and help the individual shows grow. Q. Did the ticket provide any or all of that type of confidential information to the defendants in connection with their job? A. Yes. Q. Why? A. Because it would help them grow their audience. It would help them do their job and perform their job better and, in turn, that would help the ticket grow its audience and perform at its best ability. Q. Has any of that type of information that you just described as the confidential information that information that would have been shared with the defendants is that the type of information that the company would want a competitor to have? A. Absolutely not. Q. Why not? A. It's like giving our competitor the playbook and they would know the plays that we were going to run. Q. Would the disclosure of that type of confidential information by others outside the ticket, could that cause the company harm? A. Yes, it could. Q. How so? A. Well, it would give our competitors an unfair advantage to compete against us. Q. Let's talk more about the hang zone. I think we're going to touched on it briefly earlier. I just want to make sure. With respect to the hang zone show hosted by Mr. McDowell and Mr. Kemp were portions and segments of that available via podcasts uploaded by The Ticket. A. Yes. Every day we uploaded segments of their show and they were available as podcasts. Q. And with respect to the use of the hang zone content for the podcast, did that happen immediately when the show started? In February 2020 or sometime thereafter? A. Immediately that day. Q. Let's look at Exhibit 6. I ask you if you recognize that document. A. I do. It's a screenshot of the Ticket's podcasting platform from February of 2020. February of. Q. I see the top notation. Bad Radio Weekly Wrap-Up, February 28, 20. Do you see that? A. Yes. Q. By this point, is Bad Radio, is that the program that Mr. Kemp and Mr. McDowell were doing together? A. Yes. Q. Sort of the predecessor name to the hang zone. A. Yeah. That was when it was still being referred to as Bad Radio. Q. All right. So like you said, right out of the gate you were putting out podcasts available for download that included their content. A. That's correct. Q. Approximately, how many podcasts of Hang Zone content have been uploaded onto the Ticket's podcast platforms? A. 2,000. Q. Let's look briefly at Exhibit 9. I ask you if you recognize that document. A. I do. Q. What is that document? A. It's another screenshot of the Ticket's podcast platform. Q. So I look down and I note that about 3 entries down. Do you see where it says Cowboys NFL Draft Preview 2023, Episode 7? A. I do. Q. And underneath that, Tickets April 2023. And I see Mr. Kemp's name. Do you see that? A. I do. Q. Is that in relation to the hang zone? A. No, it's not. Q. What is that? A. That's an original content podcast that Jake Kemp and Bob Stern did leading up to the NFL draft earlier this spring in April of 2023. Q. Would that have been something that listeners could have heard the same thing listening to the radio? A. No. It was original podcast content only. Q. Are those podcasts still that we see on this page still available now? A. Yes, they are. Q. And let's look at Exhibit 7. Ask you if you recognize that. A. Yes. Q. What is that? A. It's an email from me to Jake Kemp and Bob Stern from February 12, 2020, asking those two guys to create some original content podcasts around the NFL draft. Q. All right. So this is original content for Jake. Original podcast content for Jake Kemp to participate and help create in February 2020. A. That's correct. Q. And if we look next at Exhibit 8, does that look to be about the same thing but for the next year, 2021? A. That's right. Q. And did Mr. Kemp participate in the creation of original podcast content for The Ticket in relation to these documents? A. Yes, he did. Q. Was that part of his job? A. Yes. Q. Did Mr. McDowell, I think we touched on this earlier, did Mr. McDowell create original content for The Ticket's podcasts as well? A. Yes, he did. Q. Can you summarize, then, the nature of the type of original content podcasts he did? A. Yes. He would have participated in our Cowboys halftime show. As I mentioned earlier, we do an original podcast at halftime of every Cowboys game. He would have participated in several of those. We also do original content podcasts around our events, such as the Ticket Compound. He would have participated in that. And then on the show, we also created podcasts and streams from special event broadcasts like Super Bowl or Cowboys Training Camp. Q. Was that part of Mr. McDowell's job duties for the company as well? A. Yes. Q. Do you recall any? Did you ever have discussions with Mr. McDowell and Mr. Kemp about the fact that original podcast content was needed from them and part of their job? A. Yes. Q. Can you elaborate on that? A. Yes. I would discuss this in meetings with them with other guys about what our plan would be and how we would execute it. Q. Going to the dumb zone, Mr. Catlin. You understand that the defendants have a podcast out today called The Dumb Zone. A. Yes, I do. Q. When did they leave their jobs at The Ticket? A. July 14th of 2023. Q. And when was the last time, to the best of your recollection, they did a Hang Zone episode? A. July 1st of 2023. Q. Do you know why they left? A. Yes. They couldn't reach terms on a new employment agreement. Q. Were you part of those contract negotiations? A. No. I wasn't part of it. I was just kept informed. Q. With respect to the Dumb Zone, how did you first learn about their podcast, the Dumb Zone podcast? A. I'm sure one of my employees told me about it. Q. When did you first hear about it? A. It would have been shortly after the 17th of July, sometime that week. Q. Have you listened to Dumb Zone podcasts? A. I have. Q. Multiple. A. Yes. Q. Let me ask you, have you tried accessing the Hang Zone? Mr. Anderson, scratch that. Q. Let me ask you this, with respect to the Dumb Zone podcasts you listen to, based on what you heard, would you characterize the content of what you heard on the Dumb Zone podcast to be the same, similar, or different to the content they did for the Hang Zone shows? A. I would say it's exactly the same. It's a clone of the show they were doing on the ticket. Q. Why do you say that? A. It's the same content, the same sports content. They do a news segment like they did on the ticket. They do a segment called This Day in History, which is exactly the same as they did on the ticket. They have produced Open. They talk about the news. It's the same show in podcast form as what they were doing on the ticket. Q. Is there, based on the episodes you've heard so far, is there anything in those Dumb Zone podcasts that you thought was false or misleading or painted the ticket in a negative light? A. Yes. I've heard a few things. Q. What's the first one that comes to mind? A. The first one that comes to mind is an episode where they had a guest on and a story was relayed about Jake Kemp not receiving a raise when he was promoted from producer to talk show host, and the defendants didn't do anything to correct that mischaracterization. It's absolutely false. Jake Kemp did get a raise when he was promoted from producer to talk show host, and that makes the radio station, the ticket, sound cheap and sound like it didn't value its employees. Mr. Anderson, we have an audio clip here, Your Honor. We'd like to play. The court, excuse me, Mr. Anderson, we have an audio clip we'd like to play. The court, go ahead. Identify it. Mr. Anderson, sorry. This is A1, the Akash Singh episode. Plaintiff's audio exhibit A1 played. Q. What about, do you recognize that clip? A. Yes. Q. Is that something you heard before? A. Yes. Q. Where was that from, a Dumb Zone podcast? A. Yes. Q. Did you recognize the voices? A. Yes. Q. Which voices did you recognize? A. Well, Jake Kemp and then the guest's name, Akash Singh. Q. Do you know who Akash Singh is? A. Yes. Q. Who is he? A. He's a comedian. Q. Does it sound like he was making a joke to you on there? A. No. Q. Is there anything about the dialogue that you disagree with? A. Yes. As I mentioned, I think it's not true. It wasn't corrected. I know that Jake got a raise when he was made a talk show host from when he was a producer. Q. Did the information, do you consider the information you heard on broadcast on that podcast to be false? A. I would. Q. In connection with podcasts involving defendants, are there any other content you can recall that you felt was false, misleading, or negatively directed at the ticket? A. Yes. Jake Kemp was a guest on another podcast and they were relaying a story about the radio station, the ticket, during COVID. At that time during COVID, as a lot of companies did, employees had to voluntarily take temporary pay cuts or employees had to do a temporary furlough, and that was the case of the ticket. But in this particular instance in the story he was relaying, he made it seem like the ticket was cheap and the ticket did not take care of its employees at that time, because Jake Kemp and Dan McDowell were forced to pay some other lesser compensated employees out of their own pocket, and that's not exactly true. There were several employees at that time that worked at the ticket that got together and pooled their money together, and all paid for those lesser compensated employees. It wasn't just the two defendants that did that, but in that particular episode, in that particular clip, they seem to take all the credit for that. And again, it's a position where it makes the ticket seems cheap and it makes the ticket seem like it doesn't value its employees and doesn't take care of its employees, and that's not the case. They participated in that with their teammates. It wasn't just those two. It's my understanding that of the 8 or so people that contributed money to those funds, Jake Kemp didn't contribute any money to it. Q. Well, I'm going to ask a follow-up question on that in a minute. I'd like to play an audio clip real quick and see if this is an audio that you've heard from the podcast. Mr. Anderson, can we play a 3, please? Plaintiff's audio exhibit A3 played. Q. So is that the clip you heard before? A. Yes. The court, let me stop. Just a technical evidentiary point. I believe on behalf of plaintiff, you only offered exhibits that were the hard copy exhibits, not the audio. Mr. Anderson, correct, Your Honor. The court, and do you want to do so? 'Cause I don't think they had objections to it. Mr. Anderson, I would love to move both the prior audio clip, A1, A2, and A3 into evidence. The court, did you have others? do you want to do all at once? Mr. Anderson, I would love to. I didn't know if you want to hear them first or if we, the court, no. I meant I think you indicated there were no objections. Mr. Cawley, I don't have any objections to any audio. Mr. Anderson, so plaintiffs move to admit. The court, so we'll offer them so they're admitted so. I don't have any issues on whether you I dotted all the I's and crossed all the T's. You want to offer them. Mr. Anderson, yes, Your Honor. Thank you. Plaintiffs, move to admit audio exhibits A1 through A18. The court, any objection? Mr. Cawley, no objections, Your Honor. The court, admitted. Plaintiffs' audio exhibit numbers A1 through A18, admitted. The court, continue. Mr. Anderson, thank you, Your Honor. Q. So Mr. Catlin, you said you've heard that clip before, A3. A. Yes. Q. And what about that you disagree with? A. As I mentioned, makes it seem like only 2 people participated in helping out some of the other employees at the ticket when in fact it was a larger group of employees that all should be getting credit for that. Q. And which voices did you recognize, if any? A. I heard Akash Singh, a guest again, and I heard Jake Kemp. Q. And with respect to Jake Kemp, is he the one that said, I'm not trying to be a white knight here? A. Yes. Q. That they take care of their employees? A. Yes. Q. Following up on a prior comment you made, what was it you said about your understanding as to when people pooled their funds together with respect to Jake Kemp? A. My understanding was that several ticket employees pooled their funds together to help the lesser compensated employees, and that Jake Kemp didn't participate in that at all. Q. And in terms of how that what impact that might have on the ticket, what impact would that have, in your opinion, if any? A. Like I said, it would make the ticket seem cheap. It makes the ticket seem ungrateful to its employees. It makes the ticket seem unfair and that they don't take care of their people. Q. Let me ask you this, does the ticket have competitors? A. Yes. Q. What would you consider to be a competitor to the ticket? A. Any radio station in Dallas-Fort Worth, any podcast, any audio company, any media company that's putting out audio content would be a competitor. Anybody that's trying to get the same listening audience that the ticket is trying to get. Q. So based on what you said, do you believe podcasts can compete with broadcast radio and streaming? A. I do. Q. How so? A. There's a very limited amount of time that listeners can spend listening to audio in their day-to-day life, and so that they're competing with that for that listener's attention and ear. Whether it's a podcast on demand or streaming or radio, we're all competing for the same attention and the same listener group. Q. Do you believe that the defendant's Dumb Zone podcast is competitive with the ticket? A. I do. Q. Why is that? A. Because it's a clone of the same show and it was being done immediately after they left the ticket employment. And it's going after the same audience, and it's the same format of the show that they were doing on the ticket. Q. Well, do you know whether the Dumb Zone podcast is it free? Do you have to pay for it? Or do you know? A. It's behind a paywall. Q. What does that mean for us novices? A. You have to pay to download the podcast to access it. Q. Gotcha. Is how about the ticket? Do you have to pay to access the ticket? A. No, you don't. Q. All right. Based on your experience in the industry, does the fact that defendant's podcast is available behind a paywall, a subscription fee, mean that it's not competitive with the ticket's freely provided content? A. No. I think it's all competitive. Q. How's that? A. I think that the customers, the listeners, are used to paying for content that they want, whether it's audio or video or anything else. They're used to paying that fee. It's a very low barrier for them. Q. Based on your experience in the industry, are the tickets, and specifically with the ticket, are the tickets listeners? I think we talked about this a little bit with the streaming aspect and whatnot. But do you track or know if the listeners are listening via radio or phones? First off, do you listen to the ticket? A. Yes, I do. Q. How do you listen to the ticket? A. I listen to it on the radio and on my phone. Q. Are you do podcasts? A. Yes. Q. You listen to podcasts? A. Yes. Q. All right. So based on your experience with the ticket, do you track in any way the level of the listener base that's listening via streaming, not streaming, but phones versus traditional radio? A. The only way we do track that is, as you mentioned, through streaming. We know that people that about % of our audience streams, and I would say that based on my experience, the great majority of that 25% are streaming on their phone, although you could do it on a laptop or a tablet as well, but most people do it on their phone. Q. I want to direct your attention to exhibits 29 and 30. Let's start with 29. and ask you to look at that. And of course, it's with the email thread that it is. Let's just focus on the bottom there. I ask you if you recognize that email. A. Yes. It's an email from a listener to me, July 20th of 2023. Q. Do you recall getting this email? A. Yes. Q. Was this immediately after the defendants left the ticket? A. Yes. Q. And kind of looking at that sort of last couple of sentences right above, regards, Jacob in Denver. Can you read that last, starting with, please make this work? A. As read, please make this work. I hate for the station to fall off every day after 10 a.m. And I don't want to have to spend $10 on a Dan and Jake podcast, but I would. Q. So do you have an understanding after reading that? Do you interpret this email as this listener being willing to leave the free content of the ticket and move over to the defendant's podcast even if he's got to pay for it? A. That's how I interpret it. Yes. Q. Is that consistent with your testimony earlier that a paid subscription podcast still competes with free radio? A. Yes. Q. Let's look at Exhibit 30. Looking at bottom email there, do you recognize that email? A. Yes. Q. Is this another listener? A. Yes, it is. Q. Email to you and Mr. Bennett, July 20th. A. That's correct. Q. And looking at that last paragraph, do you see where it says, as read? However, I haven't listened at all since Dan and Jake have been off the air, and I'll continue to go somewhere else for my sports talk until they return. I will follow them wherever they land next, even if that's to a competitor. Do you see that? A. Yes. Q. Is this also consistent with your testimony that listeners will leave the free content of the ticket to go follow the defendants even if they have to pay a subscription fee? A. That's correct. That's my interpretation of this. Yes. Q. Based on what you've heard so far on the Dumb Zone podcast, do you have an opinion on whether what the defendants are doing with that Dumb Zone podcast is the same as what they were doing in connection with their duties or responsibilities while at the ticket? A. Yes, I do. I do believe it's the same. Q. Can you elaborate on that? A. Yes. It's the podcast they're doing now, in the Dumb Zone is an exact copy or clone of the show they were doing on the ticket called The Hang Zone. It's the same content, delivered in the same way by the same two guys that has the same benchmark caught segments in there. The news, this day in history, they talk about the same sports content they would have talked about on the ticket, and other content as well. It's the same show. Q. Since the defendants have left the ticket, have you? And we've just seen a couple of listener feedback. Was that all the listener feedback you got? A. No. Q. You smiled there. A. I've gotten dozens, maybe 100 or more emails from listeners about this. Q. Were they positive? A. No. Pretty much all negative. Q. All negative. A. Yes. Q. How would you describe the ticket's fan base? A. Very passionate. Very involved. The court, how many of those hundreds of emails say they were negative because the defendants started up a competing podcast versus them no longer working for you? The witness, a pretty significant portion. I don't know the percentage, but more than half. The court, do you have anything you can show the court? Cause the one that was Exhibit 30 only shows that the listener was unhappy that they left the show. It didn't say, because they started a new show. It may or may not be competing. I'm now leaving your show. I mean, there's a nuance in there. So what of your hundreds of letters? I'm assuming you showed me the best ones. Mr. Anderson, we still have a few more, Your Honor. The court, okay. I'll be interested in seeing those. Mr. Anderson, yes, Your Honor. Q. Let's talk about more feedback. Let's look at Exhibit 25. Mr. Anderson, Your Honor, apologies to the court. There's some graphic language in some of these emails. Q. Looking at the do you recognize Exhibit 25? A. Yes. It's a listener email to me from July of 2023, July 19th. Q. Kind of focusing in on that last paragraph before he signs off. The way that Cumulus executives have handled this situation is a slap in the face to not only the P1's first off. What's a P1? A ticket passionate listener. Q. Okay, but the staff as well. For the ticket to be one of Cumulus' most valuable assets and not to have that reflected in the compensation of your employees is disgusting. Do you see that? A. Yes. Q. How did you interpret that as to, the compensation issue being relative to the defendants' podcast? A. I think that this listener listened to the same podcast episode of the Dumb Zone I did and heard the disparaging comments that were made and is now believing that. Q. Is this a situation where you interpret this as based on listeners hearing false information on the competing podcast they have written to you in disgust and anger? A. Yes. As he says, the more this drags on, the more listeners you will lose. Q. Let's look at Exhibit 28. And looking at that bottom email, I note that it says, it's to the ticket comments. Who gets those? A. The ticket comments email box goes directly to me. Q. Okay. So you read this email. A. Yes. Q. All right. And looking at, is this another ticket? Listener. A. Yes. Q. And I'm reading here that he writes, get your heads out of your asses and bring back Dan and Jake. Quit penny pinching and pay your talent a living wage. Do you see that? A. Yes. Q. It goes on to say, it would hurt to delete this app, but I stand behind Dan and Jake and will completely move over to Spotify out of principle. Do you see that? A. Yes. Q. Do you interpret this as this listener being upset based on compensation being paid to the defendants? A. Yes, I do. And that he's going to follow Dan and Jake wherever they go, Spotify being a podcast platform where you could listen to their podcast. Q. Well, has the ticket put out anything publicly about not paying its employees or specifically with respect to Dan and Jake about compensation issues? A. No. Q. So do you have any idea where this listener might have gotten the idea that you're not paying your folks? A. Probably from listening to the Dumb Zone. Q. The same one, the same episode you did. A. Probably, yes. Q. Let's go to Exhibit 27. Just looking, it looks like 2 emails, same day from, I think, the same person. Do you recognize that? A. Yes. Q. This is another ticket listener. A. Yes. Q. August 18th, 2023. A. Correct. Q. Less about the compensation issues here, but looking at that top email, I hope you keep filing lawsuits and continue to antagonize your listeners as well as your on-air personalities who genuinely care for Dan and Jake. You made this bed, company man. Do you see that? A. Yes. Q. How does it make you feel? A. That makes me feel bad. Q. Cause why? A. Because it's not true, and it's just very negative. Q. Have you put out anything? Has the ticket put out anything casting defendants Kemp or McDowell in any negative light? A. Not to my knowledge, no. Q. Would you authorize something like that? A. No. Q. These emails that we're looking at, does it appear to you that they're angry? Do you interpret these emails as folks being angry, just the fact that the defendants left, just the simple fact that they're gone? A. No, I don't. I take it as they're maybe upset that they left, but the fact that the ticket is being thrown under the bus is what's got them fired up and angry. Q. Well, let's look at Exhibit 31. Do you recognize that one? A. Yes. Q. Okay. So just directing you to a couple of spots here. But looking at that first paragraph, well, let's look at the opening paragraph. Read through the lawsuit and most recent filing against Dan and Jake and saw you guys have had an influx of hate mail. I just thought I'd throw one more email on that pile. Do you see that? A. Yes. Q. It says a derogatory thing about Cumulus. Do you see that? A. Yes. Q. And, to think that you have the right to control someone's life the way Cumulus does is a textbook example of corporate overreach. Do you see that? A. Correct. Q. Okay. So, again, like the other emails, how do you interpret what comes up for you in terms of that statement that you think you have the right to control someone's life? A. Yeah, I just don't think that's accurate. We don't have the right to control people's lives, but this negative feedback from listeners like this is just being fueled by what's being put out online and in the podcast. Q. By who? A. The defendants. Q. With the Dumb Zone podcast. A. Yes. Q. Another list. This is an example of another listener that you're losing as a result of the podcast. A. Yes. Q. Let's look at 33. Now, this is a lengthy one. We're not going to go through the whole thing by any means, but do you recognize this? This email. A. Yes, I do. Q. From another listener. A. Correct. From August 24th of 2023. Q. So kind of looking at there's a lot there about characterizing what the lawsuit between the ticket and defendants is sort of a divorce between the mom, the dad, and the kids. Do you recall that? A. Yes. Q. And so looking at that middle paragraph, I'm just going to read the sentence. And since the ticket has the money, we view you as the dad and view Dan and Jake as the mom. Do you see that? A. Yes. Q. Do you view it the same way? A. No, I don't. Q. Yeah. So look at that final paragraph. I, personally, will stop listening and do everything I can to stop other people from listening, just to prove a point. I have enough money and time to spend on social media to disparage Cumulus. I'm not sure how successful I will be, but I will not stop, that is for sure. Unfortunately, you and your on-air staff will be the only ones to suffer, and Cumulus will continue to be the big, shitty conglomerate that they are. Do you see that? A. Yes. Q. How did that make you feel? A. Terrible. Q. Can you elaborate? A. Yeah. Because, again, this is something that's being put out that this listener heard that is not true. It's the fact that Cumulus is being painted as cheap, or that it doesn't take care of its employees. Q. And where do you think this listener is getting that information? A. From the Dumb Zone podcast. Q. Do you feel threatened by this email? A. Yes. It's threatening my livelihood, my job. Q. He says he's going to go after and try to disparage you and get people to convert over. A. Correct. Yes. Q. All right. Now, let's talk for a second. We've seen a handful. Do you think we can be here all day looking at listener emails if we wanted to? A. Quite a while. Q. Are these the only emails you received? A. No. Q. Is the nature of the other emails you received similar and the same to the ones we've just gone over? A. Yes, they are. Q. Is that normal feedback from listeners in your experience at the ticket? A. No, it's not. We get feedback all the time from listeners, but the tone and tenor and the language of these emails is definitely different. Q. Well, you've had other on-air talent leave the ticket before to go elsewhere, right? A. Yes. Q. Do you get these kind of responses and those kind of scenarios? A. Not to this level, no. Q. What's different about this, if you know? A. These emails, like I said, the language being used, the threats, it's quite a bit different, quite a bit more negative. Q. What do you attribute as to the, if anything, as to the cause of why the content, the tone of these listener emails, being more egregious than typical ones in the past? A. Because the narrative. Mr. Cawley, I'll object to that as speculation. Mr. Anderson, how he interprets it, Your Honor. Mr. Cawley, and relevance, too. The court, rephrase your question, counsel. Mr. Anderson, yes, Your Honor. Q. These emails that we've gone over have a more, I think I forgot the word you used, but a more serious tone, a more negative tone, is that correct? A. Yes. Q. And they're saying more than just they're upset they're upset on things more than just that the defendants have left. Fair. A. Yes. Q. Issues of compensation and what you pay your employees and trying to control their lives. Those are the kind of things that have been mentioned. A. How they've been treated. Yes. Q. And have you gotten those kind of emails in the past when other talent left? A. No. Q. To what do you attribute this elevated level of tone from these recent communications after the defendants left? Do you attribute that to anything? A. Yeah. I attribute it to the narrative that the ticket has been cheap and the ticket was not compensating its employees, and that if it was a money issue with the defendants, and that if the ticket would have simply just paid them what they wanted, then they would have all been taken care of. Q. And where is that narrative coming from? A. I believe it's coming from the Dumb Zone podcasts. Q. Has since the defendants left and started this Dumb Zone podcast, has there been any negative impact on the ticket, to your knowledge? A. Yes. Q. And has it impacted the ability to start a replacement show? A. Yes, it has. Q. Can you elaborate on that? A. Generally it takes 6 months, a year, sometimes longer, to establish a new show. Even looking back at the start of the Hang Zone, it took them almost a year before they even settled on the name that they would have eventually used. That period of time is critical to build and grow a new show. And when we're trying to build and grow a relationship with the audience with the new shows that we've put in place in that time slot, to have the defendants immediately start a competing podcast doing a copycat of the same show they were doing on the air in podcast form really impacts our ability to launch and develop and grow a new show in much the same way that they had the benefit of in 2020. Q. Do you consider that harm to the company? A. Yes, I would. Q. Any way for you to quantify through monetary terms what those harms worth as you sit here today? A. I have no idea because there's no way to know. All this behavior is ongoing right now. It's not stopped. It's still happening, and there's no way to measure it. Q. Do you believe the ticket is losing listeners as a result of the defendants podcast? A. Yes, I do. Q. Do you believe that any of your listeners are leaving the ticket to go listen to the podcast The Defendants podcast instead of the ticket? A. Yes, I do. Just a few examples of the emails here, and the ones that I've seen, they say that. And there's no way to then quantify how many other people that feel the same way are exhibiting the same behavior but don't take the time to email in. Sometimes the emails, they can represent 50, 100, 150 people. I have no way to know that. Q. There's another question I forgot to ask earlier. With respect to, well, you said it great. Let me ask you this: do you track in any way, shape, or form? Do you track or quantify the? Can you let me rephrase it? Can you track or quantify the loss of listeners? I didn't say that very well. Can you track or quantify the listener base being lost that's leaving the ticket to go to the defendant's podcast? A. Yes, but only partially at this point. Q. How so? A. We have a Nielsen ratings reports that come out and we can see the loss of audience that we've had, but it's only first of all, it's already in the past and there's still ratings happening right now. But in the first ratings report that we saw for that time slot, noon to 3 o'clock, Monday through Friday, the ratings were down at that point 45%. But it's still an ongoing situation. We're still in ratings that are happening right now. Q. What is down 45%? A. From the prior month. The ratings for the prior month were down 45%. Q. For the whole. A. For the time slot noon to 3 o'clock, Monday through Friday. Q. How about for the ticket in general? A. The ticket was down 30% month to month, and that time slot was down 45%. Q. All right, let's talk about that for a second. If, let's say for the last 3 months, looking at the last 3 months, do you know the impact of ratings, or do you know what the ratings have been going from 3 months ago to today if they stayed for the station itself as a whole, have stayed the same, gone up, or gone down? A. They've gone down. Q. By what percent? A. About 30%. Q. And with respect to that particular time slot that the defendants did the hang zone, the 12 to 3 o'clock, that same time frame in the last 3 months, have ratings? Can you track ratings for that portion as well? A. Yes. Q. And have ratings gone up, down, or stayed the same? A. They've gone down. Q. By how much? A. About 45%. Q. So that particular time slot that defendants have a show has gone down significantly more than the decreasing ratings from the station as a whole. A. That's correct. Q. So 30% for the station, 45% for the 12 o'clock to 3 o'clock spot. A. That's right. Q. Do you believe that the defendants in their competing Dumb Zone podcast has had a negative impact on the ticket's goodwill or reputation? A. Yes, I do. The ticket has had a sterling reputation. It's the gold standard for sports talk radio shows across the country, and this is something that's been very damaging to the brand. Q. Have you seen that in some of the emails so far? A. Yes. Q. Can you put a dollar amount, if you had to sit here and fill in the blank, a dollar amount, dollars and cents to compensate you for the damage to your reputation? Would you be able to do that? A. No. I think it's impossible. There's no way to put a dollar figure on the damage to someone's reputation, especially a brand that's held in such high esteem as the ticket has been. Q. Wrapping up here, Mr. Catlin, as you sit here today, can you run the ticket, correct? A. Yes. Q. You were close with defendants, correct? A. Yes. Q. You oversaw them and supervised them in their day-to-day responsibilities for the company, correct? A. Yes. Q. With respect to their creation of a competing podcast, can you tell the court how you believe the defendant's Dumb Zone podcast is harming the ticket? A. It's the exact same show they were doing for the ticket that they're doing now in podcast form. It's a clone of the show. It's damaging to the brand and to the reputation of the ticket. It started immediately. It's competing for the same audience and listeners that the ticket has in using the same basic formatic elements that they used on the ticket to do. So, Q. You're aware that the defendants had a non-compete in their contracts? A. Yes. Q. Are non-competes for on-air talent like them important for the ticket? A. Yes, they are. Q. Why? A. Because it takes time to develop a new replacement show. So in the event an employee leaves employment, such as the defendants, then it becomes the ticket's responsibility to replace the time slot with a new show. And it takes anywhere from 6 months to a year, sometimes longer, to be able to grow an audience and develop a new show in that particular time slot to be the replacements. Q. So if an on-air talent like defendants left the employment of the ticket and were able to immediately start just carry over the same show or substantially same show immediately, would that hurt the ticket's ability to get a new show in place for the vacated time slot? A. Yes, because it would be competing for the same audience at the same time. Q. Is that, in part, the need for having a non-compete period in the first place? A. Yes. Q. Last thing, Mr. Catlin, just again, as you sit here today, we talked about a lot of different harms to the company. Is there any way for you to quantify the full measure of harm being caused by defendants' actions to the ticket? A. No, there's not, because I think it's still ongoing. It's been ongoing. And as I mentioned, the ticket's reputation has been great, and so this has been very damaging, and there's no way to know how damaging it's been across all of our business entities. Mr. Anderson, we pass the witness. The court, okay. Cross. Mr. Colley, Your Honor, would it be possible to take a restroom break real quick? The court, sure. Before we break, it's 10:30 right now. There's a set of restrooms down the hall on this floor. Let's go ahead and take a 15-minute break from 10:30 to 45. We'll pick up with the cross of this witness. Let me see if there's anything else I was going to add. Oh, question. Are you all comfortable as far as temperature goes? It was very cold when we came in, but I'm very cold-natured. They adjusted it a little bit. Are you all comfortable? Mr. Anderson, feels great to me. Mr. Colley, feels good, Your Honor. The court, I'm looking at the sole female that's on that side. Ms. Griffin, I'm fine, Your Honor. The court, let's go off the record. Court is in recess. The court, okay. We will pick up with cross-examination of this witness. Go ahead. Mr. Colley, thank you, Your Honor. Cross-examination by Mr. Colley. Q. Mr. Catlin, you talked at length about the fact that you believe that the what I'll call the cheap narrative about what you're getting emails is a result of stuff that was put on that was on the podcast. You remember that? A. Yes. Q. Okay. Well, first, you'll be glad to know I am AP1. Isn't it true that the hosts throughout the years have bagged on the ticket as being cheap? A. Possibly. Q. Yeah. And in fact, there's a particular drop, is there not? When somebody mentions something about the ticket, about somebody being cheap or poor, they play a drop that says a Cumulus station, right? A. Sure. Yes. The court, counsel, I hate to interrupt your flow, but I've got to understand all this. Mr. Colley, okay. The court, can you clarify what you believe the witness means by the hosts? Are you talking about the two defendants or just hosts in general, or please clarify? Mr. Colley, yes, Your Honor. Q. I'm AP1 and we talk the same language a little bit about the ticket lingo, but when the hosts are your employees that are the on-air talent, right? A. Yes. Q. And you'd agree with me that the ticket is sort of a sports and jocular type station. A. Yes. Q. And the hosts often get into topics that are not sticking to sports, right? A. That's correct. Q. And sometimes those topics talk about somebody who's cheap, or poor, or not doing well monetarily, and the person who lets describe what drops are. Drops are sound effects that somebody called a board operator plays through your system, right? A. That's correct. Q. And a board operator, one of the things that I think the ticket probably started. It's ubiquitous now. But one of the things is that the board part of the comedy is what audio the board operator will play, given a particular scenario that's being discussed by the host, right? A. Correct. Q. It's called a. The court, what's a board operator? Mr. Colley, yeah. Q. A board, I'll just ask you to explain it to the court. What's a board operator? A. A board operator is someone in the radio control studio that puts the audio from the control studio out to the transmitter through the control board. The court, thank you. Q. And one of the things, just to edify, Your Honor, one of the things that the board operators do, they're responsible for the sound, getting the commercials, all that kind of stuff, right? A. Yes. That's their primary responsibility. Q. Right. But the ticket has taken board operator jobs a little bit further, and they're sort of part of the show in terms of what kind of audio clips they play during the show, right? A. Yes. Q. And those are called drops. A. Yes. Q. And so something will be going on that's timely, and if you've got a good board operator, the board operator will think of an audio clip that's in your system that pertains to whatever the hosts are talking about, and they'll play that clip, right? A. They could. Q. And that's common, right? A. It's common, yes. Q. And the clip that I was talking about little earlier, a Cumulus station, that's a drop that's often used to make fun of the ticket for being cheap, right? A. Yes. Q. That's been going on since well before the dumb zone was even a thing, right? A. Yes. Q. I'm going to show you what has been marked as Exhibit 25 that Mr. Anderson showed you just a little while ago. Do you remember looking at this exhibit with Mr. Anderson? A. Yes. Q. And this is an exhibit that you testified was evidence of the fact that listeners were mad because of the cheap narrative being put out there by the dumb zone, right? A. Yes. Q. Do you remember the date of the first dumb zone episode? Made public. A. I don't remember the exact date. It was sometime the week of July 17th, I believe. Q. It was July 24th. What's the date of this email? A. July 19th. Q. That's before the dumb zone even came out as a podcast, isn't it? A. According to what you just said, yes. Q. So it's not possible for this email to be evidence of the dumb zone giving rise to that cheap narrative that you talk about, is it? A. I'm sorry, I don't understand your question. Q. Yeah. I mean, if it came out before the dumb zone did, if this email was sent to you before the dumb zone even existed, then the dumb zone clearly could not have been the cause of this listener's angst, right? A. I suppose. Q. All right. It's not possible, right? If you get this email on July 19th, but the Dumb Zone podcast doesn't come out for another 5 days, then the listener's complaint cannot be related at all to what they heard on the Dumb Zone, can it? A. Yes. Q. So when you testified earlier that you interpreted this email, Exhibit 25, from Travis Williams as evidence that the Dumb Zone's disparagement was causing harm to the ticket, that was just not true, was it? A. That's my interpretation, is that it was. Q. Well, if this person hadn't heard the Dumb Zone, which he could not have if he sent this email on July 19th, then this emailer's complaints could not in any way be related to disparagement on the Dumb Zone, could it? A. No. Q. Okay. Let's go to Exhibit 26. I don't remember Mr. Anderson showing you this one, but this is something that you guys, the court, defendants or plaintiffs Exhibit 26. Defendants. Mr. Cawley, this is Plaintiffs Exhibit 26. The court, plaintiffs. Okay. Q. This is exhibit submitted to the court by your attorneys, and it's an email from a Brian Thompson that simply says, pay them, right? A. Yes. Q. Does it look like that emailer is sending that email because he think that the ticket's cheap? A. Yes. Q. When did he send that email to you? A. July 20th. Q. Before the ticket the Dumb Zone came out, right? A. Yes. Q. So, once again, the Dumb Zone and any alleged disparagement that you contend existed on the Dumb Zone did not cause this person to believe the cheap narrative regarding the ticket, right? A. Yes. Q. So what you testified earlier to was completely wrong. Mr. Anderson, objection. Q. With regard to the Dumb Zone being the genesis of the cheap narrative of the ticket, right? The court, hold on. Mr. Anderson, Your Honor, I object. Mischaracterizes the witness prior testimony. He went through a number of documents earlier. The court, all right. Save the long objection. I do think it's argumentative. Remember, I'm not the jury. I've been on your side of the bench for years, so your point has been made. Continue, Mr. Cawley, and I don't want to belabor the point, Your Honor. The court, yes, you do. Mr. Cawley, caught me. Q. But I just want to make sure that it's clear, because you testified you blame Dumb Zone for the cheap narrative regarding the ticket. Exhibit 28. The emailer says, quit penny pinching and pay your talent a living wage. Is that the cheap narrative you were talking about? A. Yes, it is. Q. Again, what's the date of that email? A. July 18th. Q. Before the Dumb Zone ever came out, right? A. Before July 24th, yes. Q. Again, the Dumb Zone wasn't the genesis of the cheap narrative regarding the ticket. You'd agree with that, right? A. I would not. Q. You think the Dumb Zone was the genesis of the idea that the ticket's cheap? A. I'm sorry, I don't understand your question. Q. You think that nobody believed that the ticket was cheap until the Dumb Zone came along and told everybody? A. I can't speak for everybody. Q. Well, you talked about these emails that you were getting as some big example of the P1 listening public is now thinking that the ticket is cheap because of what Dan and Jake said on the Dumb Zone. You remember doing that, right? A. Yes. Q. And we just looked through these emails that you cited as examples for that, but they pre-existed the Dumb Zone, right? A. Yes. Q. All right. Let's talk about your podcast. You said that. Well, do you believe that the ticket is in the podcast space? A. Yes. Q. You talked about the thousands of podcasts that the ticket uploads, right? A. Yes. Q. The vast majority of those, would you agree with me, are repurposed on-air segments? A. The majority of them are. Q. The vast majority, right? A. The majority of them are. Q. We'll talk about that. And you put them into 3 channels. A. Correct. Q. You got the ticket top 10, right? A. Yep. Q. And that's a daily set of podcasts that somebody creates for all the segments throughout the day, right? A. More or less. Q. I probably wasn't artfully describing what it is, but it's somebody puts together kind of a best of the day, right? A. Correct. Q. Who puts that together? A. Various ticket employees. It changes. Q. And just generally speaking, what level ticket employee puts that together? A. I don't understand your question. Q. Is it a board op? Is it a producer? Is it a who what person does that? A. Generally speaking, it's the Ticket Top 10 show producer. Q. Is that an entry-level position at the Ticket? A. No. Q. Do you have a hand in selecting what is the best of that day to put on the podcast? A. Sometimes, yes, sometimes no. Q. How often do you do that? A. Periodically. It depends on the news of the day. Q. I'm probably not going to be able to tie you down on that, I can tell. But wouldn't you agree with me that the repurposed, on-air segments makes up more than 75% of the podcasts you guys post? A. I don't know the answer to that. Q. And in just for the court certification, when I'm talking about repurposed on-air segments, that as opposed to original content, right? A. Correct. Q. Original content is stuff that somebody sits down and does a dedicated podcast for, right? A. That's correct. Q. And the stuff we're talking about here is just somebody going and clipping segments of the host on-air shift. A. Yes. Q. So the host who created the content for the podcast isn't involved in creating the podcast itself, right? A. I'm sorry, I don't understand your question. Q. Well, you said it's put together by the top 10 producer, I think you said, right? A. Aha. Q. That person just goes back through the archive for the day and takes clips and puts them in a podcast, right? A. That's correct. Q. So the hosts don't go and sit in a studio room and create a podcast for you to put on the website, do they? A. They do from time to time, yes. Q. Well, that's original content stuff. Right now I'm talking about the repurposed on-air shifts. That's just the host doing their job and then somebody else takes that and puts it on your website, right? A. That's right. Q. Now let's talk about the original content. How often do you do original content? A. We do original content every day. That's what the Ticket does. Q. No, I mean original content podcasts. A. Can you restate the question? Q. Yeah, you talked about different types. The draft, right? A. Yes. Q. And that happens once a year, right? A. Yes. Q. And I think for 2001 to 2021 and 2022, you had Jake and Bob Sturm do the draft podcast, right? A. That's correct. Q. And you asked them to do it, didn't you? A. Yes. Q. You didn't demand that they do that, did you? A. Okay. I asked them to do it. Q. You said well, and what I'm getting to is you said that creating original content is part of the job duties and requirement of on-air host, right? A. Yes. Q. So if that's true, we're going to see original content, podcast creation in the job duties in their contract, right? A. I'm not familiar with every letter of their contract. Q. Well, their job duties are set out in the contract and that's what defines the terms of their non-compete agreement. Is that your understanding? Or do you know anything about that? A. I'm not sure I know what you're talking about. Q. But their job duties in the contract should encompass what they're required to do as a minimum, as in the minimum performance of their job, right? A. Okay. Q. And so if the creation of original podcast content is not in the job duties, then that's not formally a part of their job, is it? A. I guess that would be up to interpretation. Q. Okay. Fair enough. Do all the hosts do original content podcasting? A. I would think from time to time, yes, they do. And, yes, they have. Q. You talked about an email earlier where you were kind of chiding your employees because they were putting a podcast in their own feed channels, right? A. Aha. Q. Is that a yes? A. Yes. I'm sorry. Q. I'm not fussing at you, but the court reporters got to hear a verbal answer. A. Yes. Q. It was Exhibit 11th. And you're talking about your distinct podcasts, feeds, channels, and that's the top 10. Why Today Doesn't Suck, and the Bad Radio Wrap Up podcast, right? A. That in this email, that's what I'm talking about. Yes. Q. Okay. And I think you said you started doing podcasts around posting podcasts to the website around 2009. A. That's correct. Q. And this email's in 2019, right? A. Yes. Q. And you kind of chide yourself a little bit and said, you're disappointed in yourself you didn't have a better handle on what's going on. Did you pay much attention to the podcast channel before 2019? A. Yes. Q. But this just caught you off guard that they were doing it wrong. A. I would say that some employees were freelancing. Q. And what do you mean by freelance? A. They were making their own decisions about what content was going to go in what channel, and I wanted them to follow the distinct pattern. Q. And you talked about advertising on your podcasts. Is it your understanding that your salespeople pitch your advertisers on advertising in the podcast? A. That's not part of my job. I don't know. Q. So earlier when you were talking about I think, Mr. Anderson and the record will be reflected. But I Think Mr. Anderson asked you a question about your advertisers paying for podcast time. You don't know anything about that, do you? A. I'm sorry, I don't understand your question. Q. Do advertisers let me rephrase. Advertisers pay for time in your on-air broadcasts, right? A. Yes, they do. Q. Do you know whether advertisers pay for time during the podcast? A. It is my understanding they do. Q. And there's different types of advertising. There's passive advertisements on things like YouTube, right? A. I define passive advertising. Q. You can turn on a button and have ads automatically come on there. And if you get enough listens, you get passive, you get income from YouTube, right? A. I'm not aware of that, but okay. Q. Okay, you're not aware of that. Do you know how? You know how podcasts are monetized? A. Yes. Q. How? A. Well, you could sell ads or you can put them behind a paywall and get subscriptions. Q. And it's your testimony here today that the ticket actively solicits advertisement dollars specifically for its podcasts. A. I know that on our podcast channels we're required to put ad markers in the podcasts for clients. Q. Okay. Do you do that for original content podcasts? A. Yes. Q. Okay. The original content podcasts that we saw on your YouTube page, and let's pull that up. This is Exhibit 4. This is your YouTube page, right? A. Yes. Q. Do you do a lot to promote your YouTube page? A. Yes. Q. How many YouTube subscribers does the Ticket DFW have? A. 3.49K. Q. A little over 3,000 subscribers, right? A. That's what it says, yes. Q. Is that a lot? A. It seems like it is to me. Q. And on the views of the podcasts that are listed, there, you got one with 30 views, 41 views, 205 views, and 97 views, right? A. Yes. Q. Is that a lot? A. I guess it depends on your definition of a lot. Q. Those original content podcasts that people are doing there that are on your YouTube. Well, what before I do that? What's an RSS feed? A. My understanding of an RSS feed is something that you can copy and embed into a website so you can access that same content every day automatically. Q. What's an RSS feed with respect to podcasts? A. It's a way that you could subscribe to a channel, I believe. Q. Right. And so if you upload a podcast to an RSS feed server, it goes out to the various podcast platforms that are out there, things like Spotify, Pandora, iTunes. A. That's my understanding. Q. Okay. Do these original content podcasts that you're putting up here on YouTube, do those go get served? Do those get uploaded to RSS server? A. I don't believe so. Q. So these are just on YouTube, right? A. No. Q. Or Facebook, I think you also put them on. Right. A. Can you please restate your question? Q. Yeah. These original on Exhibit 4. A. Q. These things that we're seeing, these 4 cowboy training camp podcasts, those are not uploaded to an RSS server to be distributed out to the various podcast platforms, right? A. Not to my understanding, no. Q. Okay. So these are viewed only on the Ticket's YouTube page, right? A. That's incorrect. Q. Okay. Where else would they be? A. Facebook Live and the Ticket's Twitch feed. Q. Okay. And we'll get to Twitch in just a second, but they're not put on traditional podcast platforms, right? A. Not to my knowledge, no. Q. Okay. And I'm going to show you Exhibit 5 is another one you looked at. And these are original content podcasts for halftime of the Saints game or post-game, a Mavericks playoff game, the Compound, Sick, and 49ers halftime show, right? A. Yes. Q. Again, these aren't uploaded to an RSS server to be pushed out to all the platforms for live distribution, are they? A. The live distribution is through YouTube, Twitch, and Facebook Live. Q. But there are bigger. What are the biggest podcast platforms out there? A. I don't know that factually. Q. You don't know. Is Spotify a big podcast platform? A. That would be one of my answers. Q. Is Pandora? A. I don't know about that. Q. Okay. What about Apple Podcast? A. Yes. Q. These aren't, and those are the very biggest platforms, right? A. I would say so, yes. Q. And these aren't pushed to those, right? A. No. Q. Okay. And you could do that by just pushing it through the RSS feed, right? A. I suppose, yes. Q. All right. Now, I asked you if the sales team sells ad for podcasts, and you said to your knowledge, and then, at another time you said that's not really your area. You don't know what sales folks do you? A. I do. Q. I mean, you don't. Well, do you know what they sell? How? They sell it. Well, let me back up. Between you and Mr. Bennett, who's more knowledgeable about the sales aspect of the ticket? A. Mr. Bennett. Q. Oh, okay. We'll just wait for him then. In the do you know how many subscribers the Fan has on their YouTube account? A. What's the Fan? Q. You don't know what the Fan radio station is? A. There are many Fan radio stations, sir. Q. The one here in DFW. A. Can you please risk the question? Q. 105.3 The Fan. You know that station, right? A. Yes, I do. Q. It's your main competition. A. Yes. Q. In this market, isn't it? A. Yes. Q. You know who I was talking about. The Fan, right? A. 105.3 The Fan. Yes, I know who that is. Q. I'll make sure to use the 105.3. Do you know how many subscribers they have on their YouTube account? A. No, I don't. Q. 42,000. Do you keep up with that? A. Not directly, no. Q. Well, one of the things that you talked about in terms of confidential information that you give to your show hosts is that you give them information about strategy and long-term planning and how to compete, how to keep up with competition, right? A. Correct. Q. You don't do that on the podcast side, do you? A. Podcasts are part of that, yes. Q. You don't even know how many YouTube subscribers your main competition in DFW has, do you? A. No. Q. You don't know how many The Freak has, how many subscribers The Freak has on their YouTube page? A. The Freak. Q. The station that Mike Reiner started. A. I'm sorry, I don't understand your question. Q. 97.1. You don't know what The Freak is, Mr. Catlin. The court, well, counsel, let's not be argumentative. Mr. Colley, okay. All right, the court, and you know, perhaps the judge you're trying to make impression on doesn't know what The Freak is. Okay, so why don't you back off and, dumb it down? For me, then. Mr. Colley, certainly, Your Honor. The court, okay. Mr. Colley, I apologize. Q. The Freak is a sports radio station here in DFW, 97.1. Right. A. I disagree that it's a sports station, but, yes, it broadcasts on 97.1 FM. Q. What is it? So, A. The format of the station is Guy Talk, is what I would say. Q. Guy Talk. So you're drawing a distinction between The Freak and The Ticket because they're less sportsy. A. Correct. Q. Oh, okay. But for the judge's benefit, it's a competing station in the market. A. Yes. Q. Oh, okay. Do you keep up with what they're doing in there? Podcasts. A. Only limited. Q. What does that mean? A. I know that they offer all of their shows in a podcast form every day. Q. And so you've given the court your opinion that you believe that even though it's a behind the paywall podcast, that the Dumb Zone competes with The Ticket, correct? A. That's correct. Q. So that would be the same of any podcast out there. Understanding Mr. Anderson said in his opening that there's only so much time and that the pie is a certain size. The competition for the listener's ear, any behind the paywall podcast, according to y'all, is competition for The Ticket, right? A. I would say so, yes. Q. So if your employees have podcasts, that's competition. With you, your current employees, right? A. It depends on what it was. Q. Well, I mean, I've heard the reasoning being that because there's only so much time in a day that the amount of audio that a listener can spend listening to is limited. Right. A. Yes. Q. So would you agree with me that under that rationale, any podcast competes with The Ticket? A. Yes. Q. And I think I used the limitation behind the paywall. But any podcast would, whether it's behind the paywall or not, right? A. Yes. Q. Okay. One of your current hosts is a guy named Dave Lane, right? A. Yes. Q. He works for The Ticket right now. A. That's correct. Q. He's a show host. A. That's correct. Q. He has his own outside podcast, doesn't he? A. That's correct. Q. And he has an outside podcast that some of which is behind the paywall. A. Correct. Q. On Patreon, just like the Dumb Zone, right? A. That I'm not aware of, but Q. But he's monetized his podcast outside The Ticket, right? A. Yes. Q. Gordon Keith. Who's Gordon Keith? A. He's one of the co-hosts of The Ticket's morning show. Q. Been there a long time, huh? A. Yes. Q. He's kind of the station's golden child. Would you agree with me? A. Perhaps. Q. Well, let's just put it this way, when Mike Reiner started The Freak on 97.1, one of the things that y'all did was that you had Gordon Keith, the morning show host, go and sit in with other shows to try to increase their ratings, right? A. I disagree with the premise of that question. Q. You had Gordon Keith go to other shows and co-host with them for segments. A. among other employees, yes. Q. Okay. Gordon Keith currently operates a Twitch account, doesn't he? A. Yes, he does. Q. A Twitch stream. A. Yes. Q. And for the benefit of the people who don't know what a Twitch stream is, that's a live streaming video platform. Right. A. Correct. Q. And it's behind a paywall. A. It can be or it can be free. Q. Well, Gordon's is behind a paywall, right? A. That, I'm not sure of. Q. And Gordon does not post videos on demand on his Twitch. You're aware of that, right? A. I am. Q. Okay. And what that means is on the Twitch stream, on Gordon's Twitch stream, you have to watch it while he's doing it live or you don't get to see it unless somebody tapes it. A. Correct. Q. Okay. In other words, he doesn't put a VOD or video on demand option on his Twitch page for people to come back and look at, right? A. That's correct. Q. All right. And so anytime he's operating a Twitch stream, the people who want to catch that have to ignore other forms of video, audio, video listening or viewing, right? A. That's right. Q. When and I think we've established Gordon has this outside of the ticket, right? A. Yes. Q. And he's monetized it. A. Yes. Q. Just like the Dumb Zone, but he's a current employee, right? A. Yes, he's a current employee. Q. When he went to the Dumb Zone, I mean, to the Hang Zone to do the little co-hosting thing you did, he played that live on his Twitch stream, didn't he? A. I don't understand your question. Q. Remember when he went and co-hosted with Dan and Jake on the Hang Zone? A. On the ticket. Q. Yes. A. Yes, I remember that. Q. Isn't it true? And I think he did that for about 6 weeks. I'm not going to hold you to it, but it's somewhere around there. He went week after week for a period of time. Right. A. Yes. Q. Are you aware that when he would go on the Hang Zone, he would stream that live on his Twitch feed? A. I'm aware that he did that a few times. Yes. Q. And so when he was doing that, he was requiring the listener to go away from the ticket if they wanted to watch him on Twitch, right? A. If they wanted to watch him, but it was the same audio content available on both platforms. Q. Right. But they had to go away from the ticket radio station, didn't they? A. No. They could have listened to the exact same thing on the ticket. Q. Oh, simulcasting. A. Yes. Q. But wouldn't you agree with me that the idea for Gordon was to have people go to his Twitch stream and watch what they were doing, the fun and the hijinks? A. I would not agree with that, no. Q. But nevertheless, he was directing listeners to the ticket, to his live stream. A. Okay. Q. You agree. A. Not necessarily, no. Q. What's IJB? A. IJB is an acronym that stands for It's Just Banter. Q. And what is It's Just Banter? A podcast. Q. And who's on that podcast? A. To my knowledge, it's the defendant Jake Kemp and a co-host, T.C. Fleming. Q. How long have they been doing that podcast? A. I'm not really sure. I would say maybe over 10 years, maybe longer. Q. So Jake was doing the IJB podcast the entire time, well, for at least 10 years while he was at the ticket, right? A. Yes. Q. That's something you knew about, right? A. Yes. He came to me and told me about it, and I gave him permission because I didn't view it as competitive at the time. Q. So just back then you didn't think it was competitive, right? A. Back then, right. Q. But you think it's competitive now, right? A. It's not really competitive because it's not the same format. It's not the same content as what the ticket provides. Q. But I guess I'm confused. Mr. Catlin, I understood Mr. Anderson to say, and an expert is going to come up here and testify that the basis of your contention that the Dumb Zone competes with the ticket is because of the finite amount of time that people have to devote to audio, time spent listening, right? A. Yes. Q. So it doesn't matter the content, as long as it's an audio program that takes them away from the ticket, right? A. You're leaving out an important piece, which is the audience that these particular podcasts or radio shows or radio podcasts target. Q. Oh, okay. So you're saying that the topic I guess what I'm hearing you say is that the topic targets the same demographic, right? A. I don't understand what you're asking me. Q. I'm trying to understand exactly what you're saying. What you're saying is that the topic of the podcast is relevant because it defines the market you're going after, is that right? A. In part, yes. Q. Okay. And so if the market that they're going after is the same as the ticket, you believe that means that they're in competition with you. A. Correct. Q. Is the ticket entitled to immunity from competition? A. Absolutely not. Q. You got to earn competition, you got to earn customers. Right. A. Absolutely. Q. All right. and in all in these emails that you get. Aside from the fact that they didn't show the cheap narrative, they also wouldn't you agree with me that a lot of those people were angry? Yes, Q. That Susquehanna filed this lawsuit, right? Yes, Q. Not because of anything that Jake and Dan did, not because they went and started their own website. And even before they started the Dumb Zone, people were mad that y'all filed this lawsuit, right? Yes, Q. That's not Dan and Jake's fault, right? No, Q. Okay. And so part of some of the damages that you talked about from losing listeners, like the folks that we saw emailing you, is because they're angry at the ticket for the ticket's actions, not because of anything these guys did, right? I didn't understand the question. Q. Okay. You talked about the harm that's befalling the ticket because of these listeners who are abandoning the ticket, right? Yes, Q. Okay. And we just established that a lot of the reason for these people leaving is that they're mad at the ticket, right? Yes, Q. And so a lot of these losses that you were talking about are because of what the ticket did, not because of anything Dan and Jake did, right? Yes, Q. All right, the court, I want to make sure I understand your answer. Are you saying correct what he just said? The witness, I'm saying correct by the way he's asking me the question, Your Honor. The court, all right, thank you. Q. What's the Unticket? The Unticket is a fan website. Q. What's usave.it? Usave.it is a part of Unticket. Q. Okay. And when you say Unticket is a fan website, they post podcasts taken directly from the ticket, right? Yes, Q. They do exactly what y'all do, right, in terms of taking clips from your audio broadcast and putting it in a podcast, right? Yes, Q. Y'all don't pay them for that, do you? No, Q. That's another piece of competition out there for you, isn't it? No, Q. Same a minute ago you just told me that in addition to the time spent listening, all the finite amount of time in a day, all that stuff, in addition, the topic is important because it addresses the demographic that podcast is going after, right? Yes, Q. And if they're taking stuff directly off of your radio station, they're getting the exact same topics y'all are, right? It's the same content, that's why it's not competition. It's the ticket's content. Q. Okay. Well, I mean, it's competition in the sense that it takes time, that finite piece of time that people have to audio, right, and it directs it over to the Unticket instead of over to the ticket radio station, right? It directs them there, but in terms of the ratings credit that the ticket would get, depending on what time that was listened to, the ticket would get ratings credit through Nielsen from listening to that content because it is the ticket's content. Q. Okay. I didn't want to get too inside baseball, but you raised the issue. On these rebroadcasts of the air of the on-air segments, there's a way for you to get Nielsen credit for your radio station, right? Yes, Q. And that's if people listen within 24 hours of the airing of that content. That's correct, Q. And after that 24 hours, you no longer get any credit for that, right? That's correct, Q. And for you to get credit for that, I'll call it catch-up listening. Have you ever heard of that? No. I call it time shifted. Q. Time shifted. Okay. We'll go with that. When you get let's back up a little bit so that we can educate the folks who aren't understanding what we're talking about. The way Nielsen works is they have people who carry around PPMs, right? Yes, Q. Okay. And the PPM's a portable people meter. Yes, Q. And these people carry around, I think they put it on their belt or wear it somehow. And anytime they're interacting with listening to radio, there is a code you guys encode your audio so that when that PPM hears it, it knows what station that person is listening. That's correct, Q. And when you put these podcasts onto your website, does it have the encoding? Yes, Q. Okay. And that's how you get credit for your radio station, is if somebody listens to that podcast within 24 hours of the airing of the original content, you can get credit for that. That's correct, Q. Otherwise, you don't. Well, if you listen to it live, we also get credit for it. Q. Well, of course. Good point. So you can listen live, you get ratings credit, right? Yes, Q. Or you can listen to the podcast within 24 hours and get ratings credit for the radio station, right? Correct, Q. That's not ratings with respect to the podcast, right? I don't understand what you mean, Q. Well, is there a podcast rating system? No. It's all the same rating system, Q. Now, what you're saying is on the Unticket is that encoded as well? I don't know that, Q. So what you said a minute ago that you would get Nielsen credit for what goes on the unticket, that's not true. They don't encode that audio, do they? A. I don't know if they do. Q. Okay. Usave.it. What is that? A. As far as I know, it's a component of the unticket. Q. Well, let me back up and finish up with the unticket. So if you're not getting credit for it because they don't encode the podcast to allow the Nielsen PPM to pick it up, if you're not getting credit for it, it's competing with you, isn't it? A. I don't view it as competition because it's the same ticket content, it's ticket brand. Q. And you don't mind you call your broadcast your intellectual property, right? A. Yes. Q. And you don't mind that these people just take your intellectual property and use it for their own financial gain. A. I'm not sure they get financial gain from it. Q. That's why we'll move to usave.it. What does usave.it do? A. I think it's a radio DVR. Q. Okay. A. In layman's terms. Q. And they put the full broadcast day of the ticket on their site every day, right? A. They time shifted by 24 hours. Q. And it's because of the Nielsen stuff, right? A. Correct. Q. Okay. But within 24 hours of a day, let's just take today's broadcast. That will be up, today's full ticket broadcast from 5:30 a.m. to 7 p.m. That will be up on usave.it on Monday. A. I don't know the answer to that question. Q. Well, typically it is, right? They've got every single day. A. Sir, you said usave.it and I don't know the answer to that. I don't know that. Q. All right, but that's a subscription-based service, right? A. I think it's a radio DVR. Q. But you have to subscribe to it to listen to the radio. A. I think you do. Q. Okay. Yeah. So the usave.it is taking the ticket's original on-air content and making money on it, right? A. I don't know the answer to that. Q. Well, I mean, if they're making subscription, if they're getting subscriptions, they're probably making money, right? A. I don't know the answer to that. Q. Okay. You've never talked to the owner of usave.it. A. No, not to my knowledge. Q. Do you know his name? A. No. Q. You talked about ratings a minute ago. Did the tickets ratings normally have a little bit of a dip this time of year? A. Define this time of year. Q. You know, the May, June, July, August timeframe, and there's not many sports going on and the Cowboys hadn't started yet. A. That's incorrect. Q. It doesn't go down. A. Not by the way you asked me the question, sir. Q. Okay. Well, you tell me. I know there's a lot of ways to look at ratings. You tell me. Is there a time when you expect ratings to be lower than normal? A. The ratings month of July and the ratings month of December. Q. Okay. A. And the ratings month of March would be lower than typical months. Q. And you would anticipate that the noon to 3 o'clock time slot that the hang zone used to operate in with the new host is going to have, like you said, a 6-month, year, or maybe even more period, where they're not going to do as well, right? A. I don't have any way to know that right now. Q. Well, I mean, that's your experience, right? A. My experience is it takes 6 months or a year to grow a new show. Q. And so you would expect that those guys are going to have it Sean Bass and David Mino, right? A. What's your question, sir? Q. I stopped my question cause I want to make sure you know who I'm talking about. It's Sean Bass and David Mino, right? That are hosts. A. They are hosts, yes. Mr. Anderson, Your Honor, I'm objecting. I'm not. Sure, I'm asking for clarity. It's vague and ambiguous as to what Mr. Cawley is asking. Are you asking for the 12 to 3 o'clock time slot or what? I'm just kind of lost on the questions. Your Honor. Mr. Cawley, I'll clear it up. I stopped a question in the middle, so I understand. Let me clear it up. Q. The hang zone used to operate noon to 3 o'clock, right? A. That's correct. Q. I think you changed the times now, right? You got a 12 o'clock to noon or a 12 to 1 o'clock and a 1 to 3 o'clock now, is that right? A. No, that's not right. Q. Okay. How is it working now? A. How is what working, sir? Q. What are your day parts between 10 a.m. and 3 p.m.? A. 10 to 1 o'clock and 1 to 3 o'clock, weekdays. Q. Okay. And the 1 to 3 o'clock is sort of where the hang zone used to be, right? A. Partly. Q. Yeah. And so wouldn't it be natural for ratings to be a little lower for the new guys starting in that spot right now? A. My answer is, no, not necessarily. Q. Okay, Mr. Cawley, Your Honor, I pass the witness. The court, any redirect. Mr. Anderson, just a little bit redirect, Your Honor. Redirect examination by Mr. Anderson. Q. Mr. Catlin, just quickly. with respect to the testimony at the beginning of your cross where you talked about the on-air talent sometimes refers to the cumulus or the ticket being cheap. Do you recall that? A. Yes. Q. Does that is that intended to be in jest and fun? A. Yes, it's intended to be humorous. Q. And when you heard the commentary on the competing podcast, The Dumb Zone, about same kind of issues of payment and whatnot, did that appear to be funny to you? A. It was not funny to me, no. Q. Did it appear to be intended to be funny? A. No. Q. Very different than what was broadcast by your own on-air talent. A. Correct. Q. Okay. With respect to the podcasts, I think you were asked earlier about if you do it directly, is it RSS? A. Yes. Q. You were asked about just the specific ones that we saw here in these exhibits, I believe 4 and 5, these particular YouTube podcasts. But does the ticket push some of its other original content podcasts directly through RSS? A. Yes. Q. You talked about the notion of this, we're all competing for the same time, correct? Remember that. A. Correct. Yes. Q. And if another podcast that is a true crime podcast, still, because it's a podcast available in Dallas-Fort Worth area, can compete for time, correct? A. It can compete for time, yes. Q. Do you view that as competitive with the ticket? A. Not necessarily, because it would be trying to reach a different target audience than the tickets, with different content. Q. In other words, in your experience, if someone is trying to listen to a true crime podcast for the amount of time they want to listen to audio content for the day, are those the same folks likely to go try to listen to the ticket? A. Probably not. Q. So back on the when you have current employees from the ticket doing original content podcasts outside of the ticket, is the subject matter of those podcasts different than what they do for the ticket? A. Yes, it is. Q. And hence, not competitive with the ticket? A. Correct. Q. And lastly, Mr. Cawley asked you about when the listeners seem angry about Susquehanna filing the lawsuit, and you cannot blame the defendants for that. Let me ask you this, do you blame the defendants for their conduct that led to the lawsuit? A. Yes. Q. And so you feel you were compelled to file the lawsuit as a result of the defendants' conduct? A. That's correct. Q. So if the defendants are if the listeners are mad at the ticket for filing a lawsuit, that's a direct result of the defendant's conduct, correct? A. That's what I think, yes. Q. So they are at fault, correct? A. Yes. Mr. Anderson, pass the witness, Your Honor. The court, anything further? Mr. Cawley, just briefly, Your Honor. Recross-examination by Mr. Cawley. Q. I want to play you something a minute ago. You said that you wouldn't allow anything to go out over the air that was in any way negative towards Dan and Jake or the Dumb Zone, right? A. I don't recall what exactly I said. Can you refresh my memory? Q. Yes. Mr. Anderson asked you when he was trying to say that the Dumb Zone has horribly disparaged the ticket, and he followed that up with you would never do that, would you? Mr. Anderson, Your Honor, I need to object. This goes outside the scope of my redirect. The court overruled. Q. Do you remember? A. Can you please ask the question again? Q. Yeah. And I'm not trying to trick you here, Mr. Catlin. Mr. Anderson asked you a question along the lines, and I don't have the transcript here so I don't know exactly what was asked, but it was along the lines of you wouldn't allow any disparagement to go on with respect to Mr. Kemp and Mr. A. Correct. Q. Right. Okay, I want to play something for you and see if you recognize what this is. The court, what exhibit is it? Mr. Cawley, it is Exhibit 26. The court, of who? Defendants. Mr. Cawley, Defendants Exhibit 26. Sorry, Your Honor. I have the sound off. All right, let's start it over. Defendants Audio Exhibit number 26 playing. Q. Was that at all aimed at Jake and Dan's Dumb Zone podcast? A. No, it was not. Q. So all the free you don't have to pay a subscription, not behind a paywall, all that is just coincidental that's going on with them, right? A. Not only is it coincidental that promo was written, produced, and put on the air while Dan and Jake were still employed at the ticket prior to the Dumb Zone podcast. Dan's voice is in there at 24 seconds. Q. Right. He was I don't need to go into that. Mr. Cawley, that's all I have, Your Honor. Thank you. The court, okay. Anything further? Mr. Anderson, no, Your Honor. The court, okay. You can step down. I think you're supposed to keep the notebook there, right? Mr. Anderson, yes, Your Honor. The court, thank you. Call your next witness, please. Mr. Anderson, thank you, Your Honor. Plaintiff calls Dan Bennett. The court, okay. Mr. Bennett. Whereupon, the oath was administered by the court. The court, have a seat, and you may proceed when you and your witness are ready. Mr. Anderson, was he sworn in already? The court, yes. Mr. Anderson, I apologize. I was. The court, I know. Everyone's busy today. Mr. Anderson, thank you, Your Honor. Whereupon, Dan Bennett was called as a witness, and, having been duly sworn, testified as follows. Direct examination, by Mr. Anderson. Q. So, Mr. Bennett, will you please state your name for the record? A. Dan Bennett. Q. Mr. Bennett, what's your current title? A. Regional Vice President, Dallas, Houston Cumulus Media. Q. And who? A. Which is the parent company for Susquehanna, LLC. Q. You work for Susquehanna. A. I work for Susquehanna. Q. And oversee its stations, which would include the ticket. A. It includes the ticket, 6 stations in Dallas, and 1 in Houston. Q. How long have you been in this audio media industry? A. 52 years. Q. All right. And just briefly, what are your job responsibilities as a regional vice president? A. Well, I'm responsible for the license of our properties, ratings, revenue, employees. All of the department heads report to me. Q. How would you describe the ticket's listener base? A. Very passionate. Super target is 25 to 54-year-old men. Q. And do you know defendants, Mr. McDowell and Mr. Kemp? A. Of course, yes. Q. How long have you known Mr. McDowell? A. Since we hired him in 2003, I believe. Q. And how about Mr. Kemp? A. Or 2000. Maybe it was, I'm sorry. It was 2000. Q. Okay. And for Mr. Kemp? A. Well, I first met him when he was an intern, but he became an employee, I believe, in 2009. Q. Were you involved at all in the negotiation of any of their employment contracts, the defendant's employment contracts? A. Yes. Q. Let's look at Exhibit 1 in front of you. You have the notebook, Mr. Bennett. I believe this is Mr. McDowell's, the last executed employment contract he had with Susquehanna. A. Yes. Q. All right. And let me ask you this, do all employment contracts between the ticket and its employees have non-compete clauses in them? A. The on-air talent. Q. Mainly the on-air talent. A. Mainly on-air talent. Q. Was there any typical time frame? First off, you're responsible or take part in the negotiation for most of the contracts with the on-air talent for the ticket. A. I am, but I do have to get corporate approval before we finalize it. Q. You get final say-so from? A. Yes. Q. Okay. And who do you get final say-so from? A. That would be Dave Milner. Q. But you do most of the negotiating on behalf of the ticket. A. Yes. Q. Who typically executes the employment contracts on behalf of the ticket? A. It would be, well, the legal team, obviously, puts them together. Q. I'm sorry, who signs them on behalf of? A. Oh, who signs them? I sign them. Q. Okay. And this first exhibit, the McDowell Employment Agreement, you see it's dated June 2018, the very first page of Exhibit 1. A. Yes. Q. And if you just flip to the towards the back, you signed this agreement, correct? A. Correct. Q. Now, with respect to the non-competes in the employment contracts for the ticket, is there any typical time frame the company for the duration of its non-competes? A. Non-competes generally are 6 months. Q. Is there any rationale from the company's perspective as to why 6 months versus some other time frame? A. Mainly because when you start a new show, and Jeff Catlin alluded to it in his testimony, that it takes anywhere from 6 months to a year to get a new show up and going. And we feel it necessary to have that period without the former on-air talent being in any kind of audio media. Q. Let me touch on that. So from the company's perspective, what do you consider the purpose of the non-competes in your employment contracts? A. Well, the purpose of the non-competes is to protect our business, to protect our ratings, to protect our revenue. Again, to get us an opportunity to get a new talent up and established and create a bond and a connection to the listener. Q. And how does the non-compete provisions help you accomplish that? A. Well, it keeps the departing talent from appearing on another audio media. Q. For a period of time. A. For a period of 6 months. Q. During which time you develop that relationship with the listener base. A. Correct. Q. Let's look at the agreement here, Mr. McDowell's. Exhibit 1, Mr. McDowell's last known employment agreement. If you look at Section 1.1, it defines company business. Do you see that? A. I do. Q. It's the operation, promotion, and marketing of commercial radio stations. What can you define for me? Based on your 50-some-odd years in the industry, what's the definition of a commercial radio station? A. Commercial radio stations have certainly evolved It is terrestrial radio. It's streaming. It's podcasting. It's promotions. It's events. It's concerts. It's a variety of things that help us create revenue. Q. Those that list of different components and functions you just listed for a commercial radio station, is that what the ticket provides as well? A. Yes. Q. Does it try to monetize any of those functions? A. We try and monetize everything. Q. Fair enough, podcasts included. A. Yes. Q. How does the company try to monetize podcasts? A. What we do with our podcasts is we bundle them with other digital assets. And what we do is we bundle it, we charge the client a certain amount of money but it usually is in. We usually don't with our digital assets, we usually don't sell it separately. We usually bundle it with some other things. Q. Can you elaborate? What do you mean by bundle it? A. What I mean by it is combine it with other things. Q. So unlike a radio station, for broadcasting, and a commercial for a car dealership, for example. A. Yes. Yeah. Q. How might that look different in advertisement for podcasts? A. Well, what you do is you many times will combine it. You'll give them an on-air schedule. You'll give them streaming. You'll give them maybe an event, an appearance at a car dealership. It could be a variety of things. Q. And so if a listener's listening to one of the podcasts put out by the ticket, would it be typical for that listener to hear some sort of advertisement in that podcast? A. Yes. Q. Looking at 1.2, business area, in the next page. It defines business area as a 50-mile radius from the company's radio station KTCKM and the Dallas designated market area as defined by Nielsen Audio. Do you know what the Dallas designated market area as defined by Nielsen Audio is? A. Yes, I do. It is an 11-county metro area. However, the counties of Dallas, Tarrant, Collin, and Denton make up 88% of that coverage. Q. So the business area being within a 50-mile radius of that range. A. Yes. Q. All right, now, I want to turn your attention to the next section, competing business, 1.3. It's defined as any person, including employee, or entity carrying on a business that is the same or essentially the same as the company business. Do you see that? A. I do. Q. And company business, as we saw on the prior page, is that how you define all those various functions of radio, streaming, podcast, events, promotions, things of that nature. A. Yes. Q. All right. Let's look down at section 1.54, Mr. McDowell's employment contract. It's listed job duties. Do you see that? A. I do. Q. And we're not, obviously, going to read this word for word. But in here, do you see I'm going to say about a third of the way down, it's talking about working on show, preparation and production, including preparing and delivering live and recorded commercials. Do you see that? A. I do. Q. And then it goes on to say, cooperating with company to create podcasts. Do you see that? A. Yes. Q. Of employees on air shifts. Do you see that? A. Yes. Q. Okay. So part of Mr. McDowell's employment job duties were to help with the creation of podcasts for the company. A. Yes. Q. And then further on, later on it says, engaging in social media activities, posting social media content. Do you see that? A. I do. Q. All that was part of Mr. McDowell's job duties for the ticket, correct? A. Correct. Q. Now, let's look at section 7 with respect to the non-compete, which is on page 9. Do you see section 7? A. I do. Q. All right, so let's break this down. The big reason why we're here today, Mr. Bennett, this non-compete section, while employed by the company, and for 6 months, following termination of such employment, employee shall, which is Mr. McDowell shall not, directly or indirectly, engage in any activities the same or essentially the same as employee's job duties for any competing business located or selling advertising located or selling advertising within, or broadcasting to the business area. Do you see that? A. Yes. Q. And the job duties that we talked about earlier, and you heard Mr. Catlin's testimony today. A. Yes. Q. And part of Mr. McDowell's job duties would have been, not only hosting the Hang Zone but also creating podcast content. A. Yes. Q. And with respect to the 6-month time period, is that 6-month time period the same? Well, let me ask you this. Why was the 6-month term necessary for this non-compete? Or, why was it chosen? A. It was necessary because if they were to leave, which they made the decision to do that, if they were able to go to another audio platform immediately, it would hurt us. It could hurt us ratings-wise, and it could hurt us financially. Q. So using your definition we just looked at and went over, and given Mr. McDowell's job duties for the company, including the creation of podcasts, when you signed off on this contract, on behalf of the ticket, was it your understanding that when Mr. McDowell's employment came to a close, he would not be able to create podcasts accessible within the Dallas-Fort Worth market area for a period of at least 6 months? A. Yes. Q. And looking in that same paragraph, the next sentence, Mr. McDowell acknowledges that in the event of his employment terminates for any reason, he agrees he'll be able to earn a livelihood without violating the restrictions in this agreement, correct? A. Yes. Q. And if we look at section 11 at the bottom of that page, injunctive relief, do you see where it says Mr. McDowell was agreeing that with respect to that certain sections, including the non-compete we just looked at, were reasonable and necessary to protect the company's property and business? Do you see that? A. Yes. Q. And he's agreeing here that his breach of any provision, including that non-compete, that he was agreeing to injunctive relief. Do you see that? A. Yes. Mr. Kingston, objection, Your Honor. It's Mr. Anderson's time, but I'm not certain what the witness's opinion of contract is leading us to. The court overruled. Overruled. Just to let both sides know, I meant to tell you a little bit ago before this witness came to the stand. The plaintiff had taken approximately an hour and 10 minutes of his time and defendants approximately 45 minutes. So, this includes cross and direct. You can use your time however you want. Know that I read the contract. Okay, Mr. Anderson, yes, Your Honor. Q. Mr. Bennett, with respect to these provisions that we just talked about, did the ticket Susquehanna believe that these restrictions were necessary to protect its goodwill and business interest at the time it entered this contract? A. Yes. Q. All right, let's look at agreement number 2. This is A. I'm sorry, look at what? Q. I'm sorry. Exhibit 2 in the notebook, the next document. And this is Mr. Kemp's current version of the employment contract. A. Yes. Q. And it's dated April 1st, 2022. A. Yes. Q. Did you negotiate this with Mr. Kemp? A. No. I negotiated it with a representative that he had. Q. Okay, but on behalf of I apologize. On behalf of Susquehanna, you negotiated this contract. A. Yes. Q. You signed this contract. A. Yes. Q. Okay. If we look at company business at the bottom, this one actually includes podcasting in the description, correct? A. Yes. Q. But with respect to Mr. McDowell's, I believe your testimony was part of the definition of radio station or company business include the podcasting even in Mr. McDowell's contract. A. Yes. Q. Looking at section 1.5, his duties and responsibilities, do you see that same language about cooperating with the company to create podcasts? A. Yes. Q. Looking at section 7 on page 9, by and large, the same, or substantially similar non-compete provision as to Mr. McDowell's. A. I'm sorry, it took me a minute to get to page 9. What? Section 7. Q. Section 7, the non-compete. A. Yes. Q. Substantially the same as the provision for Mr. McDowell, as well. A. Yes. Q. Between Mr. Kemp and Mr. McDowell. A. Yes, the court, and, sir, you can also see it on the screen, right next to you, too. The witness, okay. Thank you. The court, both should be accessible. Mr. Anderson, thank you, Your Honor. The court, at least today. Q. And what I want to ask you there, Mr. Bennett, is same reasons on behalf of the company as to why this 6-month time duration was included in Mr. Kemp's non-compete. A. Yes. Q. With respect to the geographic location for both contracts, is it your understanding it was the intent to keep it restricted to the Dallas-Fort Worth market areas as defined by Nielsen? A. Yes. Q. So if they want to do a podcast down in Austin or Houston, Texas or Tulsa, Oklahoma, could they do that? A. Yes. Or a radio show, too. They could do it in an outside market from here. Q. As long as it wasn't accessible within the Dallas-Fort Worth market. A. Correct. Q. And same question with respect to Mr. Kemp. Mr. Kemp's contract. At the time you signed Mr. Kemp's employment agreement, did you believe that the non-compete provision was reasonable as to the time duration, geographic region, and activity to be restrained? A. Yes. Q. For both contracts. A. Yes. Q. And at the time you signed Mr. Kemp's contract, did you believe that the restrictions contained therein, specifically, including the non-compete provision, was necessary to protect the ticket's goodwill and reputation? A. Yes. Q. And business interest. And business interest. A. Yes. Q. Okay. If we can briefly look at section 6.6. Sorry. 6.3. At the bottom of page 8. Is this the provision pursuant to which you have an understanding that Mr. Kemp agreed not to disparage the company? A. Yes. Q. All right. With respect to you're aware the defendants have the Dumb Zone podcast. A. Yes. Q. Have you heard some testimony earlier about some angry listeners? A. Yes. Q. Did you receive any of those kind of emails? A. Yes. Q. Is it typical in your experience that when talent leaves, that you get angry emails from listeners? A. You'll get some, but this was more than I've ever received. Q. Can you clarify that? What was different about the kind of content or emails from listeners in this matter regarding the defendants versus typical emails you might get from listeners when on-air talent leaves? A. Much of it was profanity-laden, talked about us being cheap. I think they automatically assumed that we wouldn't pay them the money they wanted. Q. Based on your experience in the industry, I think the plus years I think you said, have you ever experienced this type of listener reaction on behalf of the company that you've been receiving since the defendants left and their listeners have chimed in? A. Not this negative, no. Q. With respect to the Dumb Zone podcast, what's your understanding as to the nature of what that podcast is? A. Well, my understanding and, again, I also rely on Jeff Catlin's opinion, who heads up content for our group, is that it is basically a reenactment of their radio show. Q. Reenactment of the Hang Zone they did for the ticket. A. Of the Hang Zone, yes. Aha. Q. Do you believe it's competitive to the Hang Zone? A. I do believe. Q. That it competes with the ticket. A. Yes. Q. Why do you believe that? A. It's relatively the same show. It can be accessed pretty much anytime. It can take time away from somebody who wants to listen to the ticket. Q. Do you believe that the Dumb Zone podcast being done by the defendants had any harmful effect on the ticket? A. Yes. Q. And please elaborate. What kind of harm? A. Well, there's two things that I look at, and I, obviously, look at the ratings. Jeff Catlin detailed what's happened on the ratings. The other thing I look at is I pay very close attention, obviously, to what's going on with our revenue. And in the month of June, before they left, our revenue for the ticket was pacing down 2% versus prior year. In July, which is the month that they really weren't on much, but for all intents and purposes, they were still employed until the 14th of July. So in the month of July, our revenue was down 2% versus prior year. Then August, it was down 4%. And then September, we were pacing down 12%. So when I look at those numbers, both ratings and revenue, it was a cause for concern. Q. You said ratings. Have the ratings dipped? A. Yes. Q. From the June through August time frame, do you know the drop in ratings? A. Yes, I do. Q. What are they? A. June from June to August, the radio station and, sorry for the industry speak here, but it's what we call prime, and that is 6 to 7 p, Monday through Friday. And in that period, with men 25 to 54, which is our target demographic, we were down about 30%. For the old Hang Zone time slot, which is noon to 3 o'clock, we're down 45%. Q. Does that have any impact on what you think the or in correlation to the harm to the company's business reputation and goodwill? A. Sure, I think it does. Q. Do you attribute any of that to the defendants' podcast? A. I can't sit here today and prove it, but it is very coincidental that we're losing both audience share and we are losing ground on our revenue. Q. And you saw it if we look at the emails that we went through with Mr. Catlin, you saw direct evidence that customers are saying they are leaving the ticket to go to the defendants' podcast. A. Yes. Q. So you do have evidence that listeners are leaving the ticket to go to the defendants' podcast. A. Yes. Q. Is there any way, as you sit here today, to and I appreciate how you describe the harm that the company's facing as a result of the podcast? From a dollars and cents standpoint, drop in ratings, revenue down, can you know how much of that revenue decreased or ratings decreased, that you can with any degree of certainty attribute, specifically to the defendant's competing podcast? A. I think it's hard to quantify. The other thing that we haven't talked about is our business reputation. I don't know how that's going to affect us in the future. Our reputation that we have with our listeners, it's hard to say how that's going to affect us in the future. I just know the early signs are signs that I'm concerned about. Q. And are those early signs indicative that your reputation is being hurt by their podcast? A. Well, it certainly makes us believe that it is. Yes. Q. And do the emails you've seen appear to corroborate that? A. Yes. Q. Is there any way from a dollars and cents standpoint, if you had to fill in a blank with a dollar sign to compensate the company for the totality of the harm being caused by the defendants, would that be possible? A. Today, it would not be possible, I don't think. Mr. Anderson, pass the witness. The court, okay. Cross-examination. Mr. Kingston, thank you, Your Honor. The court, and you heard me before that you used up minutes on this side, roughly. Mr. Kingston, I did, Your Honor. The court, and we have, I know you've got some witnesses you're going to call, so you can spend your time however you want. Go ahead. Cross-examination by Mr. Kingston. Q. Hi, Mr. Bennett. Can you see section 1.5 of Dan McDowell's contract on your screen? A. Yes. Q. It's Plaintiff's Exhibit 1 if you prefer to look at it on paper. The highlighting in Mr. Anderson's reading of this are interesting. Am I right in reading that it says, cooperating with company to create podcasts? That's the highlighted part. Right. A. Yes. Q. Is the next words of employees on air shifts. A. I'm sorry, I don't. What's your question? Q. Is the full statement that the employee's job duty is cooperating with company to create podcasts of employees on air shifts. A. That's what it says. Q. So that's not what the defendants are doing. A. If they are reenacting their radio show, then maybe that is what they're doing. Q. You don't think it's deceptive to highlight cooperating with company to create podcasts when it is then limited by of employees on air shifts. A. I'm not the one that highlighted it. Q. But it was not Dan McDowell's job duty to create podcasts. It was simply to cooperate with the company to put his on-air content on a podcast, right? A. On-air personality's job is to do a variety of things, and podcast is one of them. And they also do many other things for us. They do appearances and they do endorsements. Q. You said you try to monetize everything. The content that is published by the Unticket and usave.it is actually just taken by those operators and then resold with no revenue to the ticket, correct? A. We don't get any revenue from them, correct? Q. What was the revenue last year of the ticket? A. When you say last year, what year are you talking about? Q. Fiscal 22. A. It was right at $22 million. Q. What was net revenue? A. That's net revenue. We always go by net. Q. Okay. Given the trend you're seeing in revenue and ratings, will Susquehanna Radio, LLC, go bankrupt in the near future? A. I can't answer that. Q. What portion of Susquehanna's revenue is produced by the ticket? A. Are you talking about Susquehanna Dallas? Q. No. I'm talking about the employer review and the defendants, Susquehanna Radio, LLC. A. LLC. Q. The company we're here about today. A. What's that? Q. The company we're here about today. A. Yes, there's two different radio stations under that LLC. It is the Ticket and Hot 93.3. Q. Are you headed for bankruptcy? A. Not that I'm aware of, no. Q. Mr. Anderson directed your attention to both of the non-competes, both in Dan's contract and in Jake's contract. Why is Jake's contract different? A. It is a much more recent contract, and it's not uncommon for our legal department to change and modify over the years. Q. But you would agree that Mr. McDowell is under different restrictions than Mr. Kemp. Mr. Anderson, objection, Your Honor. A. I don't know that I would agree with that. Mr. Anderson, it's vague and ambiguous as to which restrictions. The court overruled. Q. Mr. McDowell's contract doesn't list YouTube, for instance, as a medium that he has to avoid during the period of his non-compete, does it? A. Not that I'm aware of. Q. So Mr. McDowell, his old-time slot is noon to 3 o'clock and we're at 12:15 right now. He could, if he didn't have this proceeding, he could be live streaming on YouTube or Twitch or any of the other video mediums that are out there from noon to 00 every day right now under his contract. A. I disagree. Q. What would stop that? A. Well, we are clear about other medium that compete with our company, anybody who is in a similar business to our company. And I think that would encompass that. Q. But there's actually a definition in here. It looks like competing business under 1.3 means any person, including employee or entity, carry on a business that is the same or essentially the same as the company business. Do you see that? A. Yes. Q. And if we look at what the company business is under 1.1, company business means the operation, promotion, and marketing of commercial radio stations. A. And I have explained what commercial radio stations do now, as opposed to 10 or 15 years ago. Q. So, A. They are into many more audio platforms. Q. So the change in the business of the employer over time changes the requirements of the contract regardless of whether the language changes. A. Rephrase your question, please. Q. If Cumulus or Susquehanna Radio or the ticket starts doing something new, that automatically becomes part of the non-compete that its employees must refrain from competing with. A. If it is part of the company business, yes. Q. So Susquehanna has a historical relationship with Pfaltzgraff. Are you saying that Dan can't go make China? A. We don't own Pfaltzgraff anymore. Q. So that would come out of his non-compete. He can now go make China. A. Yes. He can make China. Yeah. Q. Yeah. Let's look at something else you required, because I had a question about it for a while. Section 2.4. I think this is saying that the employees are required to use and operate the designated company-owned social media platforms in furtherance of the job duties. What company-owned social media platforms are there? A. Well, we have we were involved in Facebook, Twitter, where we have our air personalities use those different platforms. Q. Do you what platform is owned by the company? A. I'm not aware of one. Q. So if it was a requirement for the company to provide a company-owned social media platform to the employees for the furtherance of their job duties, that's something that the company has not done. A. I'm not aware that they have. Q. I mean, Susquehanna doesn't own a social media platform, right? A. I don't think so. Q. Okay. And so you're not, so it'd be impossible to provide the employees with the social media platform that you don't own, correct? A. Yes. Q. Have you listened to the Dumb Zone? A. I have listened to excerpts of the Dumb Zone, yes. Q. Approximately, how much excerpt have you listened to? A. Just various things that involve things that we were concerned about. Q. Could you estimate a number of minutes? A. I couldn't. I would say probably excerpts, probably a half an hour's worth. Q. Okay. And that half an hour's worth was enough for you to determine that it was a competitive enterprise. A. Yes. Q. Do you know what the ticket targets males 18 to? Correct. A. 25 to 54. Q. 25 to 54. A. But we'll take males 18 to 25. Q. Okay. What is the demographic of the Dumb Zone listener? A. I would imagine it's the same demographic. Q. Do you know? A. No. I haven't seen data on it yet, but since we feel that it is a reenactment of the radio show, we assume it would attract the same type of people. Q. Well, the judge is going to be able to listen to the radio show to her heart's content, because I think we've given her a lot of audio. You're saying she's going to listen to that and it's going to sound like a reenactment of the Hang Zone? A. Yes. Q. We'll see. You said ratings were down 30% overall and 45% in the midday day part. A. 30% in the month of August, specifically in that month, and it is down 30%, 6 a.m. to 7 p.m., Monday through Friday, with 25 to 54 men. Q. And I think Mr. Catlin said that the midday day part is down 45%. A. He did. Q. Okay. How many people is that? A. Well, we go by quarter hours of listening. We don't go by what's called a cumulative audience. The ratings, in other words, you can have a smaller cumulative audience. Let's say 000 people. And you can theoretically beat a radio station with 600,000 listeners because your people listen way more in terms of core hours. Q. Gotcha. But you used an example of 300,000 people. Am I right in thinking that the typical ticket segment has, over the course of time, somewhere between 100,000 and 300,000 listeners? A. When you say the typical segment. Q. I would say the median segment. I think you probably have more listeners in drive time, but over the course of the day, how many people are listening to the ticket? A. In any given 15-minute period, or Q. However you want to define it, Mr. A. Well, we reach around 350,000 people a week. Q. Okay. Have you seen how many listeners the Dumb Zone has? A. Yes. In terms of listeners, what I mean by that is I've seen how many people they have that have signed up for it. Q. And there's no other way to listen to it other than to pay for it, right? A. Correct. Q. Okay. So it's less than 5,000, right? A. Correct. Q. Okay. So the 30% fall off in the last month could equate to as many as 100,000 people. A. Could. Q. Okay. So where did they go? A. Well, I think you're missing something. The people. Q. I'm sorry. A. The people generally who will listen to a podcast, come to an event, get super engaged with our air personalities. They are the same type of people that have more of a propensity to fill out or to be a part of a Nielsen survey. So when you can get those very passionate, maniacal people, which I would imagine people who would sign up for a podcast are, they could be much more valuable than, let's say, a passive listener. Q. So the damage here is Dan and Jake have somehow managed to Find the special secret formula for recruiting ultra important listeners. A. Very well could be, yes. Q. That's not how Nielsen ratings work, is it? A. Nielsen actually, when you look at the total quarter hours of listening, it is the 80-20 rule. About 20% of your people account for about 80% of the listening. Q. I don't know. 5,000 seems like a lot less than 100,000 to me. Wouldn't you agree? A. It is a lower number. Q. Okay, let's look at the complaint real quick. Oh, wait, let me do one more thing on Nielsen. If a listener sends you an angry email full of profanity and says that they're leaving the ticket and they're never coming back, does that affect your ratings? A. It could. Q. The only way it could is if that person has a ppm. Correct. A. People meter, yes. Q. Okay, how many ppm users emailed you to say they were mad and never coming back? A. It is illegal for me to ask them if they are on a survey panel, so I have no idea. Q. Okay, thank you. Let's turn to the complaint. This is the last page of the plaintiff's original complaint that started this lawsuit. Is that your signature? A. Yes. Q. And when you signed that, did you mean to represent that the facts alleged in this document were true? A. Yes. Q. One of the things it says in here is that Dan and Jake are soliciting the ticket's advertisers to leave the ticket and support the dumb zone. That's one of the things that you swore to in this pleading, but you now know that not to be true, right? A. No, I don't know that to not be true. Q. What was the basis for you swearing that they are soliciting ticket advertisers? A. My director of sales, RJ Lane, sent me an email and said, it's very apparent that they're going after our listeners. We know that they contacted the Tito's client. We know they contacted Alamo Drafthouse. We know that they contacted Prosper Ford. The net result was $157,000 in losses that we saw almost immediately from that. And in that list, the director of sales, basically told me that he was extremely concerned, didn't understand why they were picking up the phone and calling our clients. Q. So your contention is not that they were trying to get advertisers, your contention is that they were interfering with your advertisers out of, what, spite? A. No, not necessarily. The Tito's client made a reference to the rep that he inferred that there was something about sponsoring their podcast, and he said that he wasn't going to sponsor their podcast because he thought it was too small of an audience. Q. But you're aware the podcast has no advertising. A. I am aware that they have no advertising at this point. It doesn't mean they can't in the future. Q. Well, I think you're going to hear from Adam Romo in a minute, who's going to say that far from discouraging him from advertising with the ticket, Dan actually encouraged him to keep advertising with the ticket. A. Well, that's great, Mr. Anderson. Objection, Your Honor. Is that a question? Q. So why would you swear to the opposite? A. Because of what my director of sales told me about how they were contacting our clients and how it was implied that they made some reference to the Tito's client about sponsoring a podcast. Q. I pulled up paragraph 13 of the complaint where it details the supposedly proprietary confidential information that was provided to Dan and Jake were their weekly show meetings where defendants and Susquehanna employees discussed content strategy. A. Jeff Catlin handled that. Q. I think you're going to hear testimony later today that there were very rarely all-staff meetings, but this says that there were all-staff meetings several times a year. Were you at those? A. When you say all-staff, do you mean programming staff? Do you mean the total staff? Q. I'm reading your complaint, sir, the one you signed. The court, counsel, I don't know how this relates to evidence that the court should look at. Mr. Kingston, we'll move along. The court, with respect to the issues before the court. So if you want to use up your time and you won't get any more time by going over a complaint that's not part of the evidentiary hearing but part of the record, you can do so. But I just want to let you know I'm scratching my head about it. Mr. Kingston, I'm going to take that direction to heart, Your Honor, and move on. The court, okay. Mr. Kingston, it was a credibility thing, just to explain. The court, okay. Q. You handled negotiations with Dan McDowell over his employment contracts for most of the time he was employed at the ticket, correct? A. No. Q. Did you handle his 2013? A. No. That was John Dickey, our coup of our company. Q. And you didn't have any involvement? A. Well, he was the one that did it with our agent. They had an agent at the time. Q. Is it fair for me to say, just to speed things along, that you did not consider Dan McDowell to be one of the more valuable hosts on the ticket? A. No, that's not true. Q. Did you ever try to get Bob Sturm, his show host, his co-host on his show, to negotiate separately from Dan McDowell for the purpose of reducing Dan McDowell's salary? A. No. What happened was in 2013, they got an offer from another company and we had a right to match. And our coup told me that we weren't going to be able to match both of them, that we would only match one of them. Q. And is it also true that the conclusion of those negotiations, both Bob Sturm and Dan McDowell took a pay cut? A. Not from what we were paying them. Q. I see. And you did not try 6 or 7 times to get Bob Sturm to negotiate separately from Dan McDowell? A. Well, the thing is that what we had talked to them about, and, again, you're talking about a very long time ago where there might be a situation where in order to make the money work, we would have to pay one more than the other, and we did talk to them about that. Q. Did you talk to Dan about that? A. No. Q. So this was just Bob? A. Yes. Q. Okay. And did you use words such as you should think of your family? A. I don't recall. Mr. Kingston, pass the witness, Your Honor. The court, okay. Any redirect. Mr. Anderson, just briefly, Your Honor. Redirect examination. By Mr. Anderson. Q. Mr. Bennett, looking back at the Exhibit 1, Mr. McDowell's employment contract, Section 1.5. It's the very first document of Exhibit 1, page 2, 1.5. Mr. Kingston was trying to make some points about the podcast part. Do you recall that? A. Yes. Q. And then the highlighting being, cooperating with company to create podcasts of employees on air shifts. Do you see that? A. Yes. Q. And then keep going. The next line down towards the end of that line, and other programming requirements. Do you see that? A. Yes. Q. Is part of what the ticket was doing at the time of this contract was creating podcasts. A. Yes. Q. And is creation of podcasts part of other programming requirements? A. Yes. Q. So under that description there, cooperate and other programming requirements that could and would include podcasts, the creation of podcasts. A. Yes. Q. Thank you, Mr. Anderson. No further questions, Your Honor. The court. Thank you, Mr. Kingston. Nothing, Your Honor. The court. Anything. Okay, sir, you can step down. We are going to take a break now. But stay seated. I've got a little bit of talking to do. Let me explain time management today. Okay. I would prefer to take as short a break as possible, which is now, traditionally, the lunch hour. I'm going to get input from both sides. You will have an opportunity to take a longer break at about 2:30 to about 3:15. Okay, so if you want or need a longer lunch break, it's not going to be something I think I told you last time that you needed to come prepared to if you need a snack or if you need lunch, to bring it. So my preference is to take a short break now, 15, 20 minutes. Maybe 20 minutes, it's 30, and then get going. Do you have at least one other witness? Right, Mr. Pernini. Yes, Your Honor. We're going to call both the defendants for cross-examination and then one other witness. The court. Okay, Mr. Pernini, my understanding is we have approximately an hour and 25 minutes left. Does that sound right? The court. About an hour and a half. Okay, and so we can also, I'd like you to talk among the two of you on whether it should be the defendants called by direct exam followed by cross. I don't much care. I'll have to think about it. Okay, so let's go back to the break question. Is there anyone that can't live that needs more than 20 minutes right now so we can keep going? Mr. Kingston. No, Your Honor. Mr. Cawley. I think 20 minutes is fine. The court. 20 minutes okay. And you each have your own conference rooms. So what we'll do is we'll break 4 minutes and then we'll go. Let's see. I don't think we're going to go all the way to 2:30, but we might. So we'll take another long testimony. Have your witnesses, yours. If they end up calling as adverse witnesses on their side, everybody's going to be able to ask their questions within their time frame. Then we'll take a longer break. And whether that means additional witnesses or closing, I have arranged for air conditioning to continue and security to continue past the usual close of business in this courthouse, which is around 5 o'clock or 5:30, and will go on, for I've got it reserved till 7 o'clock or 7:30 if we need it. Hopefully, we don't, but it's really hard to get that help when I ask at the last minute rather than plan ahead. So, Mr. Parson, on behalf of your crew, is the plan okay to take 20 minutes and then a longer one when I have my criminal sentencing? Mr. Pernini. Yes. The court. I'm sorry. Mr. Pernini. Mr. Pernini. Mr. Pernini. Yes. That's fine, Your Honor. The court. Mr. Anderson. Pernini. Anderson. That's fine with you all. Mr. Anderson. Yes. The court. And over here, Mr. Kingston. We're good, Your Honor. The court. You're good. All right. Then let me tell you real quick. The official timekeeper, and look, if you go a little bit over, I'm not going to be cutting you off mid-sentence or whatever. I want you all to have a general idea of where you are so we can end today. Okay, so my official timekeeper is roughly an hour and 20 minutes for plaintiff and roughly a little smidge over an hour for the defendants. And that's where you are. Is there anything we need to take up right now, before we take this 20-minute break? Mr. Pernini, not for plaintiffs, Your Honor. Mr. Kingston, no, Your Honor. The court, so it is 12:35 right now. Please be ready to begin again with your next witness at 12:55. One other thing while you're leaving. One question that I will be asking both sides is I have, somewhere on all the paperwork up here, the order that I signed off on about 3 weeks ago that you all prepared and gave to me, which was a kind of a limited injunction order. So one of the questions I'm going to have at the end of this is if that order, or some variation of it, would be something that the defendants would be willing to continue by agreement on, and you all as well. Okay, Mr. Pernini, thank you, Your Honor. The court, and so if you could, you are welcome to talk to each other. But that is the question I'm going to be asking you, and I'd like an answer today. All right, Mr. Pernini, thank you, Your Honor. The court, all right. Anything further? No, you're excused. Security officer, all rise. Court is in recess. The court, we're on the record. Whereupon, the oath was administered by the court. The court, and when the witness is ready and you can proceed. Mr. Kingston, thank you, Your Honor. Whereupon, Adam Romo was called as a witness and, having been duly sworn, testified as follows. Direct examination by Mr. Kingston. Q. Mr. Romo, full name and address, please. A. Adam Edward Romo, Jr., Dallas, Texas 75225. Q. How are you employed, sir? A. I'm the CEO of EBG, LLC. It's the holding company of the operating businesses of Yahtzees, Slowbone, and a few other entities. Q. Okay. And are you A in your profession? Do you advertise on the ticket? A. Yes. Q. How long has that gone on? A. Oh, God. Almost 10 years, almost. Q. Do you have an account representative that you interface with at the ticket? A. Yes, I do. Q. Who's that currently? A. Kevin Rachel. Q. Has he been your rep for a long time? A. Yes, almost since the beginning. Q. Okay. Has Mr. Rachel ever attempted to sell you podcast services? A. No, he has not. Q. When Mr. Rachel interfaces with you about what kind of advertising your business needs, what is he selling? You. A. Post sponsorship on the radio shows. Q. Are you also a listener? A. I've been a P1 day one. From the beginning. Yeah, day one. I'm a huge fan. Q. Are you still a listener? A. I am. Q. Have you also listened to the Dumb Zone? A. Only recently. I'm not. I noticed a change in the midday. Obviously, I was a huge fan of Dan and Jake, Bob and Dan before that, and all of the shows, actually. But I have never really listened to any podcast, to be honest with you, so I wasn't really sure what that role was like. And when I finally did, actually, it was just this past week I listened to a couple of shows, and it's a very different experience. Q. How so? A. I don't know how to describe it. It's not as visceral as the shows that they do at the ticket. Those are more theatrical. There they've got all the support teams with the board ops and the producers interacting. And here you have really, to me, the impression, at least on this one. I never heard any other podcast. But to me, the impression is you just got two guys talking. And it didn't remind me at all of the show that I heard at the Hang Zone and before that, Bad Radio. I mean, like night and day. So when I was kind of expecting to hear, the previous shows, but it just wasn't. It wasn't the same. Q. And did you become a ticket advertiser because of Dan McDowell? Do I remember that story right? A. Yeah, it was funny. Coincidentally, the way I met him is, after I came back, I moved back from California after working out there for about 5 years, and got re-engaged to the ticket, cause I don't think they were streaming back then. It was a long time ago. And I actually ran into I knew who Dan was and I knew what he looked like. He was actually at Yahtzees eating, and I stopped by and I pulled up a chair and introduced myself very obnoxiously, and I said, hey, I'm a huge fan, I love your show. I love them all, but I really like your show. He goes, oh, thanks. And we just talked for a minute. And he said, have you ever thought about advertising on the ticket? And I said, no, I actually never thought about it. He said, yeah, you'd be great. I love Yahtzees. We kind of had that connection, so once we got a couple more stores open and we have the scale to do that, I went ahead and signed on to advertise with them. Q. Did you speak to Dan after he left employment with the ticket? A. Yeah, I did once, and I was pretty upset when that went down. Well, actually, Kevin Rachel's the one that told me, hey, it's official, Dan's gone. So I didn't know that until Kevin told me, and I was shocked because I really in my gut, I thought that the two sides would reach a common ground. In my view, in all my years of business, it takes both sides to reach a common ground. Most sides have to give a little. Both sides have to give a little for it to be a good deal. And I was shocked, so to say the least. I was pretty upset. Did Mr. McDowell say anything about your continued advertising on the ticket? Well, he did. And it was in this context. So when my rep reached out to me, he explained to me, hey, look, we don't know who the midday is going to be. And I said, well, do you have any idea? And he said, no, but we are working on some big names, blah, blah, blah. And I just said, well, I don't think I have an interest in midday. I said I would, I had a really, really strong advocate for my brand. That's important to me. Spent a lot of money for that and I get a lot for it, so I recognize that. I said it'd need to be somebody morning or afternoon, one of the other big names. And he said, yeah, we can work that out. It'll cost you more, and I'm thinking, okay. So I just lost a person who is organically a longtime customer and a big advocate, and it came through in the ads. I mean, it was very apparent how much he really genuinely was a customer of my brand. So I lose that but now I got to pay more. I mean, it was like salt in the wound. And so that was and I think that was an early, mid-afternoon call. And that night, when I got home, I was thinking about the whole thing and how it was affecting me and my brand. And I just basically sent him an email terminating our services. Look, and I explained. I said, just lost this. The midday SA mess. Norm just left. Now, this, now I get to pay more. I mean, I said, I'm done. We can maybe discuss this again if you want. You guys figure this out. And he reached out a couple of weeks later. Then I spoke to Dan. I said, hey, I quit. He goes, you did? And he was shocked. And he said, I said, yeah, the whole thing is ridiculous. He goes, look, you need to do what's good for your business. Don't do this for me or Jake. He said, what I'm doing is good for me and my family, I believe. He goes, you need to do what's good for you and your business. And I was really surprised to hear him say that. I mean, that's the first discussion that we had about any of this in any depth. And so, I said, well, look, I appreciate it. Like I said, I was really surprised to hear that. And I said, okay, well, thanks for that. And so I guess Kevin reached back out to me maybe 2 or 3 weeks later, said, hey, I got a plan. Here's what I would do. Hold your rates steady. We'll do this. I said, well, how about this? I said, well, I got thoughts on another person. 'Cause I said this guy's he's a fan. I'm trying to get what I lost, right, somebody who's an organic, really zealot of our brand and that shops there already. So which is what Dan was. And so we talked about it and then I re-engaged. So yeah, and Dan never asked me to advertise. I didn't ask him about it. He didn't offer to me about again. This whole podcasting world is different to me, new to me. It's very different. I think it's a whole different world. It's just kind of interesting listening. I didn't realize what I hear I listen to the top 10. I don't actually. I asked this once a long time ago. Why it's not a podcast? Why do you guys call it a podcast? I go, it's just a replay of what's already transpired. So I was very confused as a, reading, as an avid listener and then, all forms of the media that they present. So that was new to me. So I never thought of it as a podcast because it's just a replay of the day's top 10 segments, if you will. Thank you, Mr. Romo. Mr. Kingston, pass the witness, Your Honor. The court, okay. Cross, Mr. Pernini, just short, Your Honor. Cross-examination, by Mr. Pernini. Mr. Romo, you said that you did host sponsorships on the Hang Zone. Yes. Okay. Well, I mean yeah, I was an advertiser. Right. I thought you said if I was wrong, please, correct me. The type of advertising you did was a host. Sponsorship. I guess I considered all those synonymously. I mean, whether you're a sponsor or an advertiser or you're engaging the hosts. I mean, it may not, the vernacular may be different. I don't know, you tell me. And that's one of the questions I have for you. So the host in this case of the Hang Zone was Dan McDowell, or one of them, right? Yes. And did he personally promote your business on the show? Yes, but he was paid to. Q. Right. That's what I mean. A. Okay. Q. It wasn't like you had an ad with a paid person coming on, saying here's my business. You had the actual host of the show. Promote your business, right? A. Yes. Q. Okay. And that's what you called a host sponsorship, right? A. Yes. Q. And that's what you were interested in selling for your business, right? A. Yes. Q. Okay. A. Yes. Q. You didn't ask Mr. Is it Rachel? A. Kevin. Q. Kevin Rachel. A. Aha. Q. You didn't say to him, I want to know every type of advertisements available, right? A. No, but he would offer me other things as well. Like, I've done some advertising on KSCS. They're the country station. I've done some spots on What's the Talk Radio, or the Mark Davis, I think, is one of the stations that you guys have, I think. So I've done some on their other. He's offered those. He's never offered a podcast or anything else. So I think he's the context is I'm always trying to give you as much reach as you can. So you may not be interested and don't feel pressured, but I'm giving you opportunities if you think they make sense for you. So those things with these other stations, I've done that. Q. Okay. You said you listened to their podcast last week. A. Yes. Q. Is that right? And that was after you've been asked to come and testify, right? A. Yes. Q. Okay. Which episodes did you listen to? A. Oh, I don't remember. I don't remember. It was one day in the last week. I can't remember. Q. Okay. You mentioned that when you found out that I had to pay to sign up, though. So, Q. You mentioned that when you found out that Mr. Kemp and Mr. McDowell were leaving the ticket, that you were upset. A. Very. Q. Okay. And I think you made the comment that, both sides have to get common ground, right? A. Yes. Q. It is fair to say that you don't know what happened in the negotiations between the ticket and Mr. Kemp and Mr. McDowell, right? A. No. But I've read the complaint and I've read. It's all online. All those threats of and these, the foul language. Yeah, I read all that stuff. Q. Let me make sure we're talking about the same thing. A. Sure. Q. So you said you were upset when you found out that the relationship between Kemp and McDowell and the ticket ended. A. Yes. Q. That they were no longer going to be on the show. A. That's correct. Q. And you said you thought that people needed to reach common ground for them to stay together as an ongoing show. Right. A. That's my philosophy in business, yes. Q. You don't know about what the negotiations were to try and keep them on the show that ended up not working, right? A. I think I have an idea. Q. Why do you think you have an idea? Did Mr. McDowell or Mr. Kemp tell you what happened? A. No. Q. Okay. And you didn't speak to anyone at the ticket, either, right? A. Just a lot of rumors are floating around. Q. Okay. Rumors. A. Yeah. Q. Anything other than rumors. A. No. Q. Okay. Mr. Pernini, that's all I have, Your Honor. The court, any redirect. Mr. Kingston, can he be excused, Your Honor? The court, not yet. Mr. Kingston, sorry. The court, any further questions? Mr. Kingston, no further questions, Your Honor. The court, let's go off the record. Off the record. The court, on the record. Counsel, off the record I brought up whether I can instruct the court reporter to strike the mention of Mr. Romo's hold on, sir personal address. Any objection to that? Mr. Kingston, no, Your Honor. Mr. Pernini, no, Your Honor. The court, okay. So, Madam Court Reporter, so, stricken. At this time does anybody object to this witness being totally excused? Mr. Pernini, no, Your Honor. The court, okay. You may go. Thank you, Mr. Romo, Mr. Kingston, and our thanks to Mr. Pernini. The court, I'm sorry, Mr. Kingston, our thanks to Mr. Pernini for the accommodation. The court, thank you. Call your next witness. Mr. Pernini, we call Jacob Kemp. The court, all right. Mr. Kemp, Mr. Pernini, for cross-examination. Whereupon, the oath was administered by the court. The court, please have a seat, and when the witness and you are ready, counsel, you may proceed. Whereupon, Jacob Matthew Kemp was called as a witness, and having been duly sworn, testified as follows. Cross-examination, by Mr. Pernini. Q. Good afternoon, Mr. Kemp. A. Hello, sir. Q. Can you state your full name for the record? A. Jacob Matthew Kemp. Q. And, Mr. Kemp, when you were employed by Susquehanna, originally, your goal was to be on-air talent, correct? A. Yes, sir. Ultimately, Q. And you wanted to have the opportunity to create a platform and create a following for a show that you hosted, right? A. Yes, sir. Q. Okay. And the ticket ultimately gave you that opportunity. With the show that turned out to be the Hang Zone, correct? A. I would like to think that I had a hand in proving myself worthy of that opportunity, but yes. Q. Sure, and that's fair. So you proved yourself the ticket, but then they gave you the opportunity, correct? A. Sure. Yes, sir. Q. And through being on that show, you developed a level of local celebrity. Would you agree? A. Perhaps, yes. Q. I mean, you're seen and noticed in public, that kind of thing. A. At times. Q. And you developed that as part of being on the show with the ticket broadcast, right? A. Yes, part of that. Q. Now, you understand that on-air talent at the ticket generally has non-competes, right? A. Yes, sir. Q. And you understand what a non-compete is, right? A. I know a lot more about it now than I ever wanted to know. But, yes, sir. Q. Sure. But even before this lawsuit, you were familiar with what a non-compete was, right? A. The concept, yes, sir. Q. Okay. And turn, if you would, to there's a notebook in front of you. A. Yes, sir. Q. And that Exhibit 2 is an employment agreement. The court, and it's also on your monitor to your right. The witness, oh, okay. The court, as well. It should be. Q. And I just want to, if you would turn to page 15, just to confirm that's your signature. A. Yes, sir. Q. Okay. And this agreement is dated the first day of April 2022, right? A. Yes, sir. Q. So that was just last year, right? A. Yes, sir. Q. Okay. Now, when you negotiated this agreement, at the time you were negotiating this, you were a host of the Hang Zone, right? A. Yes, sir. I had been for a period of about 2 years and 2 months at that time. Q. Okay. A. Yeah. Q. And your salary was upwards of, for the year of 2021 was, upwards of $140,000, was it not? A. Yes, sir. All total. I don't know if it was if that counts salary or everything, but, yeah, total comp. Q. That's correct. Total comp. A. Yeah. Q. And when you got this salary, you got an increase or, sorry, when you entered this new employment agreement, you got an increase in your base salary, correct? A. Yes, sir. Q. Okay. And when you negotiated this, you were represented, right? A. Yes, sir. Q. Okay. And you were represented by Mr. Randy Bowman. A. Correct, sir. Q. He's an attorney. A. Yes. Q. And also an entertainment agent. A. Yes. He represents a number of clients at the ticket, I'm aware of. I don't know who else he represents, but yes. Q. And he has great deal of experience in the area, wouldn't you say? A. Yes, sir. I assume. Q. Okay. A. I believe he once represented Vanilla Ice. Q. Okay. And you had a chance to negotiate the terms of this agreement, right? A. Well, some terms. I think it's understood that there are some terms that are non-negotiable. Q. Okay. Who told you that? A. Well, pursuant to our most recent negotiations, Mr. Bennett represented to us that certain things that we wanted to negotiate on were not going to be topics that would be negotiated. But I did in fact, obviously, negotiate the compensation and the duration of the term. Q. Okay. And one of it was the non-compete that was in this agreement, correct? A. Yes, sir. Q. And, in fact, you didn't try to negotiate that back in 2022, did you? A. No. Q. You didn't object to it, right? A. No. I mean, it's just kind of understood that there's no point in objecting to it because it's if you want to work there, you're going to have to sign that. Q. Okay. And but you did not object to it, right? A. No, sir. Q. You didn't say it was overly broad. A. No, sir. Q. You didn't say it was barred by the NLRB, right? A. I had no idea what that was at the time. Q. Okay. Now, let's look at that language. Mr. Pranini, can we pull up the page? A. Yes, sir. Q. And this is section 7. Now, you've read this before, correct? A. Yes, sir. Q. And you understood that you're agreeing not to use any activities that were the same or essentially the same as your job duties for any competing business within the business area. Did I read that correctly? A. Yes, sir. Q. Okay. And your job duties at the time you signed this included hosting a show with Mr. McDowell, right? A. Yes, sir. Q. That was being transmitted to listeners in the Dallas-Fort Worth area, right? A. Correct, sir. Q. And that's exactly what's happening with the Dumb Zone, isn't it? A. I would disagree with that. Q. You would disagree. A. Yes. Q. Are you hosting a show with Mr. McDowell? A. Yes. We are hosting a paywall podcast which accepts no advertisement, and the format of which is quite different. Frankly, it's not very good. So I would say that what we're doing now is different. Let's A. Nowhere in the company is there a subscription-based podcast service. So that's why I believe this is obviously why we're here today. My interpretation of it is what we're doing is different. Okay. So right now you're not doing a podcast that's available free. Is that your testimony? A. Yes, sir. Okay. In fact, after you left the company, you did do free podcast, didn't you? A. I believe we did maybe 2, possibly 3, episodes that were uploaded on YouTube. You still had to go to the Patreon website to access them, but they were not uploaded, I don't believe, to, like, Apple Podcast or Spotify or anything like that. I don't believe so. But you didn't have to pay to listen to them, right? A. I believe there were 3 that yes. Those 3, so every week you had 1 free podcast that you were doing, right? A. Yes, sir. In fact, it was your intent to continue doing that until this litigation came up, right? A. I don't know that we had many discussions about that, but we did put them on YouTube a few times. Okay. Let me ask it this way, the reason you stopped doing the uploading of the live, not behind the paywall podcast, is because of this litigation, isn't that correct? A. I would say that's accurate. However, I would also point out that they were never live. Sorry, you're correct. I said live. That is not correct. A. Which we were very intentional about. They were podcasts that were free. A couple of them, yes, sir. Once every week, right? A. I believe for the first 3 weeks. I believe, sir. So as I understand what you're saying, your view is, because it is behind a paywall, it therefore is not the same as being on the ticket, correct? A. Yes, sir. Is that the only distinction you have between what you're doing now and what's barred by the non-compete? A. I believe that's the chief distinction. Okay. A. But so yes, sir. Now, you said that you are not doing a live streaming, correct? A. Correct, sir. Okay. When you left the ticket, you did a YouTube episode, correct? A. Yes, sir. We filmed a short video just simply explaining that, we were no longer going to be employed there, and we ran that concept by Mr. Bennett before we did it. Okay. A. That we needed to say something. So you had a YouTube that you broadcast, right? A. It was not live, no, sir. It was not live. A. Yes. In fact, right now you're talking about streaming again, aren't you? A. Can you clarify that question? Sure. You discussed on the air that you were considering doing streaming, live streaming again, correct? A. That came up in mediation, yes, sir. I'm not talking about mediation. A. Okay. I'm talking about, have you told listeners that one of the things you're considering doing is live streaming? A. Very, very far in the future. Yes, that would be an idea that we would consider. Certainly not something we're doing now. It's not something you're doing now, but you've indicated you have an intent to do it, correct? A. Perhaps one day way down the road. Are you sitting here today saying you won't do it for the next 6 months? A. I believe that's probably a question for my attorneys, but I don't even know that we're technically capable of doing that right now, to be honest with you, sir. Okay. A. Pretty bare bones operation. You agree that your contract did provide that you could not work for other podcasters, right? A. That I cannot work for other podcasters. I suppose so, yes. But as mentioned in earlier testimony, I've been doing a small podcast on the side with a guy I used to work at The Ticket since 2010, and that was permitted by my boss at the time, Jeff Catlin. That's right. And that was A. It's just IJB, is that right? A. Yes, sir. I wanted to ask you about that. You did go to Mr. Catlin and say I'm doing this podcast. A. I believe I asked and right. A. Was yes, sir. And he said you could, right? A. Yes, sir. The reason you asked is because you knew that it potentially could compete with The Ticket, right? A. I suppose so. It was a very long time ago, but it was probably more just that I wanted him to be apprised of everything that I was doing. Same with if I go write for D Magazine or something like that. It's just an understood thing that you're going to run that by him. Well, D Magazine is a written article, not a podcast. Right. A. Correct, sir. Okay. So when Mr. Catlin said you could do this one-off podcast because he listened to it and decided that it did not have the same content that he felt was competing with The Ticket, correct? A. I can't be certain his reasoning I just know that he didn't object to it at all. Q. Okay. You would agree, though, while you worked at The Ticket, you were involved in a lot of podcasts, right? A. Outside of IJB. Q. Yeah. I mean, at The Ticket, part of your job duties included a lot of podcasts, right? A. I would say the term a lot, I'm not sure about. I think we did 3 years in a row, we did maybe 7 episodes, leading up to the NFL draft. Q. Okay. A. And I believe that's possibly the only ones I was ever involved in. Q. That's the original content ones, right? A. Yes, sir. Correct. Obviously, there's archival material. That is. Q. You heard Mr. A. part of our shows. Q. I'm sorry. You heard Mr. Catlin say that there's over 2,000 podcasts out there of the Hang Zone, right? A. Yes, sir. Q. You don't dispute that, right? A. I mean, I have no idea to know the number, but no. Q. Okay. A. Those are, like I said. Q. You also did. A. Segments of our show that get posted. Sorry. Q. You also did a YouTube channel recordings for The Ticket, right? A. Yes, sir. During Cowboys season, we would do halftime. It was about a 7-minute video that I would probably do 6-7 times a season. But those videos, like the content of that, was never posted on a podcast platform. Q. Okay. A. It was, I believe, YouTube and Facebook. Q. It was YouTube, right? A. Yes, sir. Q. Okay. Speaking of Facebook, there were some questions by your attorney about the social media platforms. You remember that? A. Yes, sir. Q. Okay. And Facebook is a social media platform, right? A. Yes, sir. Q. So is Twitter, right? A. Yes, sir. Q. You're aware that there's a Twitter account for The Ticket, right? A. Yes, sir. Q. You're aware that there's a Facebook account for The Ticket, right? A. I will take you at your word. I'm not a Facebook user, so that was never a part of my job. Q. You understood that those were company-owned platforms for The Ticket, right? A. I think we're getting into a distinction between the term account and platform. Q. Okay. A. I would think more of the platform being the actual business, right? Like X is now known would be the platform. The account, I would not consider the platform. But perhaps this is minutiae. I'm not sure. Q. Looking at your agreement, I want to point to another point. There's an Exhibit A. It's on page 16. A. Okay. Yes, sir. Q. Okay. And this is a quarterly bonus compensation, right? A. I think I'm looking at the wrong thing. Oh, we're back to. They'll all just look on the screen. Yes, sir. Q. Do you recognize this document? A. Yes, sir. Q. This basically said, as the ratings of The Ticket reached a certain level, you would share in profits, not share in profits. You'd get a bonus based on that, right? A. Yes, sir. Q. So, basically, the success of The Ticket was also a financial success for you, right? A. Sure. Q. And if The Ticket was less successful, then that also would affect you, right? A. Yes, sir. Q. So part of the goal in working for The Ticket was to develop the goodwill of the company, and so the ratings would go up, correct? A. My goal was to do a good show every day, and then, hopefully that works out in the ratings game. Q. Sure. And isn't part of the goal to make sure that the company's goodwill is increased? A. Sure. Q. And the listenership is increased? A. Yes, sir. Q. And then if it was, you were financially rewarded for that? A. At times, yes, sir. Q. And that's what this document shows, is that you were going to specifically be financially rewarded if the ratings went up, right? A. Yes, sir. Q. Okay. A. Over a 3-month period. Q. Right. A. So yeah. Q. Now, when you signed the non-compete back in 2022, a year ago, did you intend to comply with it? A. Yes, sir. I suppose it's just a matter of distinction of what exactly it would preclude, but yes, sir. Q. Okay. And, in fact, everything you said in this agreement, you believed was true at the time, right? A. Yes, sir. Q. Now, you know the non-compete was limited to 6 months, right? A. Yes, sir. Q. And you would agree with Mr. Catlin's testimony that it takes about 6 months to get a new show back on its feet at The Ticket, right? A. He would probably know that better than me. You know, I'm not in management. I might say it took us more than 6 months, but sure. Q. Okay. You certainly understood that that's why there was a 6-month period in the non-compete, right? A. I'm not sure that I ever really considered why that's why it's there, is to give a new show an opportunity. I never really thought about it, to be honest with you. Q. Okay. Now, and your last day at the U were last paid by the ticket on July 14th of 2023, right? A. I would have to check on that because I believe we actually earned a bonus for Q2 that was then paid later. Q. Okay. A. Even though we were no longer employed there because we we finished number 1 for those 3 months. Q. And part of the reason that you left the ticket is because you wanted to do your own show with Mr. McDowell, right? A. I think we wanted to expand what we were doing a little bit, very similar to what a lot of people who are currently employed there and under contract are doing. So if we perhaps wanted to do like a 1-hour interview show or something like that, we wanted the opportunity to do that. And, yeah, I mean, there are other people there that are profiting on their own side bits right now. Q. But you were not fired from the ticket. A. No, sir. Q. And you left of your own volition. A. Yes, sir. Q. And once you left, you and Mr. McDowell wanted to take the show you were doing and continue doing it, correct? A. I would not fully agree with that, sir, no. Because, I mean, the show that we were doing, we had the aforementioned drops that have been discussed, we had a producer, we had a crew, so it's different to me. Q. It's different in the sense you didn't have the producer around doing everything for you. A. Right. Or any production value, really, of any sort. Q. But you still did talk about local sports. A. Sometimes, yes. I would say less now. Q. Local politics. A. Maybe. I mean, I'm not. We kind of try to stay away from that a little bit. Q. Pop culture. A. Yes, sir. Q. Okay. You had some of the same sections as was in the hang zone, correct? A. Yes, sir. I would state that those are primarily just generic segments that every radio show or radio station in America does, like the news. Q. But you fully expected that the people that listen to the hang zone would start listening to your show, right? A. I don't know that I thought that through that much there. We just started talking to each other. Q. You just started talking to each other. I don't. A. Myself and Mr. McDowell. We didn't, I don't know that we thought too much about whether we were going to be getting the same audience or not. I mean, Q. Are you saying it was not important to you to have the same followers? A. I'm saying that I'm not sure that we ever had that conversation. Q. Okay. A. Obviously, it's going to be a much, much smaller audience, as has been represented in some of the testimony today. Q. Now, you actually started recording podcasts before you left the ticket, correct? A. We did sit down, and I would kind of describe it as more of like an audio diary because it was a very intense time. And he and I sat down and just talked and recorded it to kind of save for posterity's sake. But, obviously, we never published those. Q. And when you started the show, you didn't have to talk about the ticket, did you? A. No, sir. But I'd been there for 20 years. And it's a pretty huge part of my life, and it was all playing out very publicly, so we did discuss it. Q. Well, in fact, that was your intent to discuss the ticket, right? A. I think it's our intent to just discuss what is happening, kind of in our lives. That's kind of our job. Q. You intended sorry. Sorry. A. No, go ahead. I'm sorry. Q. You intended to talk about the ticket on literally every show, didn't you? A. I did not. I think it perhaps happens organically, but it's not something that we go into thinking that we're going to spend a bunch of time on. But I'm aware that it has occurred. Q. I'm going to play for you a clip, audio A7. Why don't you listen to it and tell me if you recognize the voices? A. Okay. Plaintiff's audio exhibit number A7 played. Q. Whose voice is that? A. Mr. McDowell's. Q. Do you recall him saying that on the Dumb Zone? A. I actually do not, but it's a common thing, I think, in media where I kind of forget what happened on that day's show every day. But, obviously, that's Mr. McDowell, yes, sir. Q. Okay. In fact, on the Dumb Zone, you talked about the ticket on every episode until this lawsuit was filed. Correct. A. I will take your word on that. Q. In fact, weren't some of your episodes the only thing you talked about was the ticket, correct? A. Again, I will take your word. I don't recall that, but I feel like every episode we do a mix of stuff, but perhaps I'm recalling that incorrectly. Q. And you did stop talking about the ticket once there was an agreement and an order from this court telling you to do that, correct? A. Yes, sir. Q. And if there had not been an order from this court, you would not stop talking about the ticket, correct? A. No, sir, probably not. It's my opinion that most of the things that we said were not necessarily wrong, that we were complimentary at times. Q. Okay. We'll come back to that in a moment. A. Okay. Q. when you set up the podcast, you didn't make any efforts to make sure that the same audience that was listening to the Hang Zone couldn't hear the Dumb Zone podcast, right? A. Other than the paywall. Q. Okay. But you're aware that you could have done that. There's such thing. You heard the phrase geofencing. A. I have now. I was not aware of that before. Q. Well, you're involved in sports radio, right? A. Yes, sir. Q. Okay. So you certainly heard about online gambling, right? A. Yes, sir. Q. Okay. So you're aware that online gambling sites are able to prevent people in a certain location from accessing that website, right? A. Yes, sir. Q. Did you do any looking in to see is there a way we can do a podcast that doesn't go into the Dallas-Fort Worth area as our contract requires? A. No, sir. I had never really put those things together, that same application to gaming sites could be applied to a podcast. That was news to me. Q. And part of the reason you didn't is because you wanted to start your show with the same listeners that you had at the Hang Zone, isn't that correct? A. I think we just wanted to start recording, but we did not engage in this geofencing, so. Q. You wanted to start with an audience, right? A. Sure. Yes, sir. Q. Okay. And that audience, the most likely audience for you, was the audience that you developed while the ticket put you on as co-host of the Hang Zone, right? A. Yes, sir. Q. And, in fact, you wanted the listeners who were listening to the Hang Zone to come listen to your show, right? A. Yes, sir. I suppose. Q. And if a listener's only going to listen to 2 hours of audio a day, you wanted those listeners to listen to the Dumb Zone, not to whatever the ticket's putting on, isn't that correct? A. I'm not sure that we ever thought that through, either. Very similar to the idea of guys who work at the station who were doing podcasts, I would think that would apply to that as well. Guys who were using Twitch video streaming during our show, I would think that would apply to that as well. So, sorry. Q. Okay. You said earlier we talked streaming and you said that you had plans to stream but you didn't know when you'd start, right? A. Yes, sir. Q. Isn't the reason that you're not streaming now because of this lawsuit? A. I don't know, like I said, that we're even technically capable of live streaming a show right now, but it's just not something we considered in our immediate future at all. Q. Did you recall being on a show called The Mom Game? A. Yes, sir. Q. What is The Mom Game? A. It is a podcast posted by two individuals, one of which used to work at our radio station, and the other one who works for the Texas Rangers broadcast. Q. Okay, we're going to play you a clip for you on that show. A. Okay, Mr. Pernini, and this is audio clip A12, plaintiff's audio exhibit number A12 played. Q. You said we're having to desist. You're referring there to the cease and desist letter that Cumulus sent you, right? A. Yes, sir. Of course. Q. So on that clip, you're saying the reason we're not doing live streaming is because we got a cease and desist letter from Cumulus, correct? A. I guess that's correct, sir. Yes, sir. Q. In fact, again, your goal is to start live streaming as soon as you can, correct? A. I'm not exactly sure how quickly that would even be technically possible, but perhaps one day way down the line. Perhaps. Mr. Pernini, play audio clip A14, plaintiff's audio exhibit number A14 played. Q. You recall that from the Dumb Zone? A. I do not, but obviously I just heard it. Q. Okay. It indicates that live stream is coming soon, doesn't it? A. I don't know that I said soon, but maybe I missed it. There. Q. That was the tweet that Mr. McDowell was going to send out, right? A. I don't know. I never saw that tweet. I don't believe that it actually was ever posted. Q. Now, you said before that you had given podcasts not behind the paywall until this lawsuit began, right? A. Yes, sir. Q. And it's your intent and desire to do that again, correct? A. One day perhaps way down the line. Q. One day perhaps way down the line. A. Yes, sir. I'm not. We have not discussed that matter. We've been a bit tied up. Q. Okay. Now, part of the reason you choose the name The Dumb Zone for the show, right? A. Yes, sir. Q. Part of the reason you chose that name is because you knew that people that listen to the Hang Zone would be familiar with that phrase, right? A. Yes, sir, in part, but also just that we're not smart individuals and it kind of fits our show quite well. But, yeah, I think we could have probably, I don't know. I will agree with your assessment, yes, sir. Q. That's my point. You could have picked any name in the world, right? A. Sure. Q. Instead, you picked a name that was developed while you were at the ticket, right? A. Yes, sir. Q. And you understand that listeners to the Dumb Zone consider it to have the same content or format as the Hang Zone, right? A. I do not agree with that. So how would I be getting that information? Q. Okay. Well, do you follow? You know what a subreddit is? A. Yes, sir. Unfortunately. Q. Can you describe for the court what a subreddit is? A. It's basically just like a message board on Reddit. Q. So where people can post things. A. Yes, sir. Q. And you follow the Ticket subreddit, don't you? A. I do not. Q. You do not. A. I have not looked at it in several months. It's bad for your health. Q. Do you follow any subreddits? A. No. Q. Well, I'm going to show you Exhibit 21. A. Possibly a Dallas Mavericks or NFL one, but I just don't really use Reddit as part of my daily information consumption. Though. Q. I'm going to show you Exhibit 21. Mr. Colley, this is one we haven't agreed on yet. Mr. Pernini, oh, I'm sorry. Okay. Mr. Colley, 21 and 23. Mr. Pernini, I would like to see if he recognizes it. If he doesn't, we'll move on. Mr. Colley, okay. Q. Do you recognize this? A. From the evidentiary filing, yes, sir. Q. Okay. You hadn't seen it before seeing the evidentiary filing. A. Absolutely not. I stayed away from it. Mr. Pernini, I'm done. The court, you're done with the exhibit. Mr. Pernini, I'm done with that exhibit. Q. You understand that your agreement had a specific provision that said you're not supposed to disparage. A. Yes, sir. Q. The ticket, correct. A. Yes, sir. Q. Or Susquehanna, correct. A. Correct, sir. Q. And when you signed that, you intended to abide by that. Correct. A. Yes, sir. Q. Okay. And that is section 6.3. A. Yes, sir. Q. And it says that you cannot disparage or encourage or induce others to disparage, correct. A. Yes, sir. Q. Now, you control what ends up in the podcast that you send out, correct. A. Typically, Mr. McDowell is the one who does the editing, but by proxy, I suppose so, yes. Q. You could say we don't want that in there, right? A. Yes, sir. Q. There's never been an instant where you couldn't decide what content is taken up, correct? A. Yes, sir, that's fair. Q. You heard the audio you heard earlier today, by the comedian. What was his name? A. Akash Singh. Q. Akash Singh. You heard that, right? A. Yes, sir. Q. By the way, that wasn't live broadcast, right? A. No, sir. Q. So in other words, that was recorded. You had the time to listen to it and you decided to broadcast it, right? A. That's correct, sir. Q. Okay. And when Mr. Akash said you had never gotten a raise, that was untrue, right? A. He misrepresented the duration of time. Because it actually is true that in February of 2020, that's when I became a host. At the time I was making $50,000 a year, and I did not receive a pay raise until July of 2020. So he said a year, which is incorrect, but it is true that I worked for a period of 5 months on my previous salary. Q. Well, we can play it again real quick because he also said, you didn't get a raise after that, right? Let's play it. A. Yeah. He's yeah. Mr. Pernini, so this is A1. Mr. Dysart, A1. Plaintiff's audio exhibit number A1 played. Mr. Pernini, pause it there. Is there a way to get back? Q. Did you hear where he said, and then they didn't give you a raise on the second part? A. Yes, sir. Q. Okay. And that's not true, right? A. I believe what he's doing is conflating two different negotiations. Because when my pay raised from the $50,000 a year to the $80,000 a year after 5 months, the next year I was back in negotiations and my initial offer was no raise on that one. Does that make sense? Q. It does. But my question is, what he said is not true, right? A. He is conflating two different negotiations, yes, sir. And he also absolutely misrepresented the duration of time, but, yes, Q. And you didn't correct him. A. No, sir. Q. And you chose to put that on your show. A. Yes, sir. Q. You could have made the decision not to talk about the ticket at all in that show, right? A. Yes, sir. Q. Now, your counsel made an issue that there is a loan reputation of the ticket being cheap. Do you remember that? Questioning. A. Yes. Q. Okay. And if you didn't start it, you certainly, by including this in your podcast, were throwing gas in the fire, weren't you? A. I didn't necessarily see it that way because again, like I said, I've worked there for over half my life and it's kind of always been a running joke. Q. You thought this was funny. A. No. I just mean the narrative that the company or the ticket is a little bit cheap. Q. You knew that having Mr. Akash on the show. Mr. Akash. A. Akash, yes. Q. Akash. I'll get it. A. Yeah. Q. You knew that having Mr. Akash on your show talking about you not getting paid would have a negative impact on the ticket, didn't you? A. I didn't know. I didn't necessarily think it through, but that is a fair assessment, yes, sir. Q. It's a fair if you had thought it through, you would have realized it would have a negative effect. A. Sure. Q. And yet you chose to go forward with it. A. Yes, sir. Q. Okay. And in fact, the court, all right. So, counsel, you read the definition of if we're going into. Mr. Pernini, sure. The court, 6.3. Employee agrees not to disparage, or encourage or induce others to disparage the company. You stopped, and the court has read this whole section. Mr. Pernini, right. The court, and disparage for purposes of. Section 6.3, the term disparage includes, and then I'm, skipping case is intended to, or can be reasonably expected, to, damage any of the company's parties. So I'm looking at whether either of the defendants intended to or can reasonably expected to damage, and you didn't focus on that, but that is the focus of the court, and I'm not seeing real evidence of an intention to damage. It's very specific how it's worded, so I just want to let you know where I'm heading. Mr. Pernini, I appreciate that, Your Honor. The court, and, putting words in his mouth, it's clear from observing the demeanor of the witness, is not advancing your cause on this section. Mr. Pernini, okay, thank you, Your Honor. I appreciate that. Q. You've had other in fact, you have indicated on the web on the podcast that you would like to bag on the company, right? A. I think I made a joke about that once I found out how non-disparagement clauses work when I was told that, essentially, it has to be something untrue. However, I made that joke obviously, I saw in the evidentiary filing we had not, gone through with that, I would say. Q. Okay. All right. Now you're saying you haven't gone through with that. But your testimony and we can play that clip, if we would. Plaintiff's audio exhibit playing. Q. So if you were told it's okay to bag on the company, you bag on the company. A. No, sir. I mean, we're doing jokes sometimes, so I don't believe that I've actually made any negative comments about the ticket because I still love it very deeply. And so it's not my intention. I have a lot of friends that work there and I don't want to make life any more difficult, or I did not have any intention to speak negatively about anybody at the ticket. Q. Okay. And you could understand why someone from the ticket hearing that might think that, in fact, you're planning to bag on the company, right? A. Yes, sir. Q. That's not unreasonable, right? A. I understand, yes, sir. Q. And, in fact, you made comments that you in this last period of time. So after there was an agreement that allowed you to continue broadcasting again, you had an agreement that you weren't supposed to speak about the company, correct? A. Yes, sir. Q. Okay. And, in fact, you made comments on the podcast that you are looking forward to this opportunity to speak about the company again, correct? A. I believe we were just looking forward to the opportunity to, at some point, produce content without, being too worried about how it could be taken by someone. Q. So, for example, if someone took the statements about a podcast the ticket being cheap as defamatory, you're trying to avoid that. A. Yes, sir. I don't. Yes, sir. Q. Now, you understand that this non-compete would only last for 6 months, right? A. Yes, sir. Q. Okay. And when you left, you didn't try to go to another market, right? A. No, sir. Q. You could though, right? A. I suppose I could move my family, yes, sir, but, Q. You didn't even have to move your family to go to another market anymore. You could broadcast remotely. A. I think that's probably pretty uncommon, I believe. Q. It is common in the industry to move from market to market, though, right? A. Yes. Q. I mean, that's what on-air talent does. It's not an unreasonable thing, right? A. Sure. Q. In fact, Mr. McDowell came here from Cleveland, right? A. Yes, sir. Q. Now, in your contract you said you were financially able to survive the 6-month non-compete, and I understand that's contract language. But, in fact, you've already said that you're financially able to take the risk on starting a new venture even if it doesn't turn out right. A. Yes. Q. And, in fact, you have a lot of other ways to make money, right? A. I right. Q. You right. A. Yes. Q. You get income from that. A. Very small amount. It's more of a passion project. Q. You could do broadcast with geofencing, for example. Correct. A. I'm now aware of that. Yes, sir. Q. Okay. A. I was not previously. Q. You have your other podcast that's not competing with The Ticket, The IJB. You can get money from that, right? A. Yes, sir. My co-host primarily keeps any revenue generated from that. Q. Okay. And you also went on the mom game and said that you're financially okay, right? A. Yes, sir. Q. Okay. And let's play that clip. Plaintiff's audio exhibit playing. Q. Let me pause that there. Mr. Pernini, why are we having this feedback problem? Mr. Dysart, it's the click share. Mr. Pernini, it's the click share. Mr. Dysart, just give it a second. It'll go down. Mr. Pernini, okay, try it one more time. I apologize. I don't know why the technologies. The court, that's okay. Plaintiff's audio exhibit playing. Mr. Pernini, can we just unplug it and play it from your computer and turn it up real loud? Mr. Dysart, this is as loud as it will go. Mr. Pernini, start from the beginning. Plaintiff's audio exhibit playing. Mr. Pernini, can you hear that? Can the court hear that? The court, well, you can pull the microphone next to it. Plaintiff's audio exhibit playing. Q. That was you speaking, correct? A. Yes, sir. Q. And so if you're asked or told by the court that you have to wait starting this podcast for just 6 months and can't disparage Cumulus, you can financially survive that, right? A. It would certainly be for anyone, I would imagine, difficult. But as I stated there, yes, I don't believe I would end up, destitute. Mr. Pernini, pass the witness, Your Honor. The court, okay. I guess you're direct. Mr. Colley, I am directing, yes. Thank you, Your Honor. Direct examination. By Mr. Colley. Q. Mr. Kemp, we don't have a lot of time here. Normally what I would do in the beginning of this is kind of talk to you about your background, your past, and all that kind of stuff to introduce you to the people making decisions about you, but we don't really have time for that. But I do want to just briefly touch on who you are and what you do. Are you married? A. Yes, sir. Q. Kids? A. Yes, sir. I have a 4.5-year-old and a month-old. Q. 11 months. Okay, and I didn't tell you I was going to ask you about this, but you had some issues with the birth of your son, health-wise, right? A. That is accurate. Q. He's all right now, right? A. He is. Mr. Pernini, Your Honor, if he needs to take a break. The witness, no, it's fine. I just was not planning on this. Mr. Colley, he's fine now. The court, are we back on the record? Q. Are you ready, Mr. Kemp? A. Yes, sir. Q. I didn't mean to spring that on you. I just thought of it when the questions were being asked about you being sidelined. A. Yes. Q. For 6 months and you'll be just fine. Do you have an 11-month-old who had some health problems that you had to take care of, right? A. Yes, sir. It was quite expensive. Q. Let's move on to your history at the ticket. Just briefly blow through your rise through the levels. At the ticket, would you? A. Yes, sir. I was hired as an intern shortly out of high school, maybe a couple of months out, in 2003. I interned for 2 years for the afternoon program at the time, the Hardline. Developed a lot of great relationships there. Then I went away for my final 2 years of school, and I came back. And I would say sometime within about a year and a half of me coming back, I was hired by Mr. Catlin to work overnights on the weekend and occasionally Sunday night, 6 o'clock to midnight, something like that. But it was. It's an entry-level position, but it was a dream. And then, from there I just sort of steadily did every single job at the radio station. I would do ticket tickers, which is our sports update. I would do producing, which is just helping out shows on the weekend. Eventually, my first full-time job was of the aforementioned Ticket Top 10, hosting a recap show at night. And then from there, was hired to be the afternoon board operator. From there, was hired to be the producer of the Bob and Dan Show. And from there, once the light-up changes that we talked about occurred, I was promoted to hosting a show in February of 2020. Q. Sounds like you held darn near every position they've got at that station. A. I believe I might be the only person who's done every single job there. Q. The only job you've ever had. A. Outside of, working for a small family business. Yes. Q. You want to be here today. A. Absolutely not. Q. If you had your druthers, you'd be still working at the ticket, wouldn't you? A. Yes, sir. Q. Do you let's talk about that? Why did you leave the ticket? It was your dream job, wasn't it? A. Yes, sir, it was. Q. Why did you leave? A. Well, there were a couple of different reasons that kind of came to a head at once, one of which was, as we've talked about, Mr. McDowell and myself had expressed a desire to possibly be able to produce some audio content, possibly video content akin to what other people at the station were already doing. And, we had some back and forth on that. I believe Mr. Bennett initially thought there was a chance that might be doable. That ended up being something that was just not really going to happen. Until the very, very end. There was kind of a vague offer with no details attached to it, but things had kind of broken down negotiations-wise at that point. And then the other thing that occurred during the time that we were negotiating, we had asked possibly about some raises for our crew, which ultimately I believe at the very end there were small raises agreed to for them. And the reason I brought up those raises is because I was made aware sometime in the last year that 3 employees making between $26,000 and $36,000 had signed compensation memos that included non-competes. And I never heard of that before, because I used to make that amount of money and I didn't have a competition, so I didn't have a non-compete. And that upset me, and I raised this issue with Mr. Bennett. He expressed shock that those restrictive covenants were in agreements for employees making $26,000 a year, so I don't know if he knew about it or not. He did sign the documents. He got back to us a couple of days later and said that he had spoken with legal for Cumulus and was told they didn't ask us not to put these in here. And I then asked those employees a series of times over the next couple of months if those restrictive covenants had been removed, cause I was told that they would be, and they, to my knowledge, had not been. And at that point probably the negotiations just got a little sideways and emotional, but I was no longer really comfortable working there. It's my understanding that those employees have not been notified that they no longer have non-competes. There was an insinuation by Mr. Catlin earlier today. I took it as Jake didn't contribute. That when the pandemic hit and everybody pulled their money together, Mr. Catlin said you did not participate in helping pay the staff. Is that true? No. So, essentially, we all signed salary reduction memos, and I definitely was a part of that. I think it might have been 25% off of our pay for 3 months. I believe the document might have been presented in one of our filings. But I definitely did that. Again, at the time I was still making my previous salary. So the guys, cause this was, maybe April, I would say. The guys told me, you don't need to chip in on this extra when we pool our money together. So that part is true, but I also definitely took a 25% pay cut for a period of 3 or 4 months. It's also the case that for a number of different occasions, Mr. McDowell and myself, I can't speak to what everyone else did, we would send people money during the pandemic. Anytime we ever receive a bonus, we pay our employees out of our own pockets. Proportionate to how much each one of us make, but we've always done that. Well, was that at a time when you were a show host making the same base salary as you did as a producer? I'd have to go back and look. I believe that's the case, but if not, once I got my pay bump, it went from 50 foot to 80, which is still vastly lower than what those other guys were making. So they kind of jumped in and said, look, you don't have to do this. But I did participate in the salary reduction. Okay, you mentioned and you've heard it in here before, and you talked about it with Mr. Pernini. You had a podcast called IJB, right? Yes, sir. Approved by the ticket, right? Correct, sir. And I think Mr. Catlin testified that he approved it, because at the time he didn't think it was competitive with the ticket. But at any you ran, you were working that podcast up till the day you left the ticket earlier this year, right? Yes. Did anybody in 2023 tell you you're competing with the ticket? Stop doing IJB. No. And you're aware that, and we've gone through it, and I don't want to spend the time doing it here. There are other employees at the ticket that do side podcasts for money. Side podcasts, video streams, the like. Yes. You're aware of competitors' employees who do the same thing. Yes. In fact, that aforementioned Mom Game podcast, Julie Dobbs, works for 97.1 The Freak. They have a couple of other employees that do podcasts, so it's not an uncommon thing. And I was going to ask you about that cause Mr. Catlin mentioned that The Freak uploads their podcast every day, right? I believe that's true. Okay. He made it sound as if they do a good job of podcasting their content. You agree with that, or do you even know? I don't really know, but I do believe they put their entire shows up, which is also a common practice. And Ms. Dobbs is an on-air talent at The Freak, right? Yes, sir. She hosts the afternoon show, I believe. And she does an outside podcast. Yeah. And, apparently, The Freak lets her do it, is that right? Yes, sir. I don't want to spend a lot of time on this disparaging thing, Jake, but have you ever intended to disparage the ticket or its employees? No, sir. Like I said earlier, it's been my whole life. And, the guys that got those jobs when we left they are some of my best friends, and I'm super proud of them. So it's not my intention. Mr. Colley, Your Honor, I pass the witness. The court, okay. Thank you. Any recross? Mr. Pernini, just 1 second, Your Honor. No recross, Your Honor. The court, sir, you may step down. The witness, thank you, ma'am or, Your Honor. The court, next witness. Mr. Pernini, we call Dan McDowell. The court, okay. Mr. McDowell. Ms. Griffin, Your Honor, can we take a short bathroom break? Mr. Kemp would like to run to the restroom. The court, it's probably a good idea. The only problem. Mr. Pernini, we have a 2:30 stop, right? Ms. Griffin, I'm sorry. The court, Mr. Kemp can exit and come back. Mr. Colley, thank you, Your Honor. The court, would that be okay with this group? Mr. Kingston, it is, yes. The court, there's no such thing as a 5-minute break but okay. I got to swear you in, whereupon, the oath was administered by the court. The court, please have a seat. And when you're ready, go ahead. Mr. Pernini, thank you, Your Honor. The court, let's go off the record. Off the record. The court, go back on the record. Go ahead. Whereupon, Daniel McDowell was called as a witness, and having been duly sworn, testified as follows. Cross-examination by Mr. Pernini. Q. State your name for the record. A. Daniel McDowell. Q. Mr. McDowell, how long were you employed by the ticket? A. Since 1999. Q. Okay. A. For those who got it wrong. Q. And you started your career in Cleveland. Correct. Your radio hosting career. A. No. Q. Okay. A. I started in Ohio. I bounced around the state of Ohio. Q. Okay. And ultimately landed up in Dallas. A. Yes. Q. That's not uncommon for radio hosts to move to different markets. Correct. A. I am not very sure, but I would say it's not too uncommon. Yeah. Q. And you've had non-compete agreements with Susquehanna since the beginning. Correct. A. Probably. I do not recall my first couple of contracts. Q. You agree that they're common in the industry for on-air talent, right? A. I would agree. Q. Take a look at Exhibit 1, which we'll also have on the screen. This is your employment agreement, and there's your signature on page 14, is that correct? A. I'm sure it is. Q. Okay. A. When you get down to it. Yes. Q. And this was at the time you negotiated this, you were the host of one of the hosts of the Bob and Dan Show. Correct. A. Yes. Q. Which was also called Bad Radio. A. Yes. Q. And your salary at that time was well in excess of 6 figures. Correct. A. I don't see it on there. Yes. Probably. Q. Even before. A. It was over 6 figures. Q. Even before you signed this, you were making over 6 figures, right? A. Yes. Q. Did you have an attorney to advise you on this? A. We did have an attorney look over this contract. Yes. Q. Okay. And so you had the opportunity for someone to explain all the terms to you, right? A. Yes. Q. And you understood the terms and intended to abide by them when you signed it, correct? A. Yes. Q. Okay. And when you negotiated this, you didn't challenge the non-compete agreement, correct? A. I did not. Q. Okay. You didn't discuss it with them, right? A. With the ticket. Q. Yes. A. No. Q. Okay. If you look at Exhibit A, not Exhibit A. Appendix A. This is similar to the agreement that you had with or that we talked about with Mr. Kemp, correct? A. Similar, yes. Q. Okay. And this basically says as there was more listeners and goodwill built up at the ticket, you'd get a bonus based on that, right? A. It does not say anything about goodwill built up at the ticket. Q. Okay. It certainly has listeners, correct? A. Yes. It just indicates if we get number 1 ratings, we get that. Q. Okay. Part of. A. So we could have less listeners, for instance. I think recently the ratings had gone down by a certain %, but they're still number 1. Q. Okay. A. So, Q. You agree with me generally, ratings rise as goodwill rises, correct? A. I do not understand that. No. Q. You don't understand that. A. No. Q. You don't think a reputation of a station has anything to do with how its ratings are. A. No. Q. Okay. Do you think the reputation of the station has any bearing on the company? A. I don't understand that. When you try to tie ratings with goodwill, Howard Stern got great ratings and a lot of people think Howard Stern is very vulgar. Q. Okay. A. And so his ratings didn't build up goodwill for that. Q. Well, Howard Stern is a show, right? A. The relationship we have with the listeners, I don't know. I'm just having understand, excuse me. I got to slow down. I'm having a hard time understanding the goodwill being related to ratings. Q. Let's work on that then. A. Okay. Q. Certainly the goodwill with its listeners, correct. You understand that concept. If a station has goodwill with its actual listeners, that will increase the number of listeners. And if that goodwill is harmed, the number of listeners will go down. A. I would also disagree with that in a way just because the goodwill thing feels very subjective. For instance, one of our what we view as a competitor are sorry. When I worked with the ticket, we would view the freak as a competitor. Q. Aha. A. They have great will. They're very nice people. They really do a lot for their listeners. They get a terrible rating. They're rated 25th in the market or 30th or something, so they had built up lots of goodwill. They're very friendly with their listeners, but it doesn't translate to ratings necessarily, so I'm not sure that there is any correlation. That, I apologize for, I'm just not understanding that that's a correlation. Q. That's fair. You agree that the reputation of the station is important. A. Sure. Q. Okay. When you were employed there, it mattered to you what people thought about the station, right? A. In a way. What mattered to me was getting good ratings. Q. That was it. A. Pretty much. If you thought we were garbage but we got great ratings, then I was pretty happy. Q. Okay. A. That's what I got paid for, to get good ratings. Q. Now, the non-compete you signed, that's in section 7. Right. Mr. Pernini, you can pull it up. A. Probably. Q. You understood you were not supposed to do the same job duties for a competing business, right? A. Yes. Q. And you understand competing business were commercial radio stations, right? A. That's correct. Q. And you understood that commercial radio stations in 2018 did both on-air live broadcasts through radio waves but also streaming and podcasts, right? A. Can you say that again, please? Q. Sure. In 2018, you're aware that commercial radio stations did broadcasts through radio waves, also did streaming, and also did podcasting, right? A. I took that to mean broadcasting. Q. Not my question. Did you understand that commercial radio stations in 2018 did streaming? A. Yes. Q. Okay. And did you understand that commercial radio stations in 2018 did podcasting? A. Yes, I guess. The definition of podcast is up for debate, I suppose. Q. If we use the definition of podcast as an audio clip that can be downloaded and listened to at any time, you were doing podcasts back then, right? A. If that is the definition, yes. Q. Okay. Do you have another definition of podcast? A. Yeah. I think generally people that listen to podcasts are listening for unique content and kind of like a full show, not like a downloaded clip that you can listen to at any time. That's Q. That's your A. As a podcast listener myself to different podcasts, I would say, hey, I listened to a podcast today, this the Joe Rogan podcast. If I listened to a clip from another radio station, I wouldn't say, hey, I listened to their podcast. Q. While you were at the ticket you helped create podcasts, right? A. Excuse me. Q. While you were at the ticket you helped create podcasts, correct? A. No. Q. It wasn't part of your job duties to prepare podcasts of your on-air shifts. A. No. I didn't do that. Q. Okay. That's in your contract though, right? A. Where does it say that? Q. Sure. Section 1.5. This is section 1.5 of your agreement. And you can see, about 5 lines down it says part of your job duties include cooperating with company to create podcasts of employees, on-air shift and or to visually record or stream such air shifts for distribution? Did I read that correctly? A. Yeah. Well, it says I would cooperate with the company. Q. Okay. And so part of your job duties was to cooperate with the company to create podcasts, right? A. Of our on-air shifts, I suppose. Yeah. Q. And so that's A. I just took that to mean I wouldn't complain if they took our on-air shift and made it a podcast. Q. That's not what it says though, is it? A. I think it is. Q. And it defines podcast there as podcast of on-air shifts. Right. A. Yes. Q. Okay. And you were just saying a moment ago you didn't think that would be a podcast. A. That's what my definition of podcast would be. Yes. Q. But the agreement you signed says podcast includes that. Right. A. Yes, it does. Q. Okay. And you had a chance to read this when you signed it in 2018, right? A. Yes. Q. Okay. And you did podcasts for or were on podcasts for the ticket while you were employed there, right? A. No. Q. You understood you heard Mr. Catlin's testimony that there were over 2,000 podcasts of the Bat Radio and A. Oh, I'm sorry. So repurposed show. Yes, then I was on a podcast. Q. If that's the definition of podcast, then you were on almost 2,000 podcasts, right? A. Okay. Q. When you got this contract, did you have any questions? Did you ask about what a podcast was? A. No. Q. You understood that the company also streamed their broadcast, correct? A. Yes. Q. Okay. Take a look, if you would, at Exhibit 6. And this is a listing of the various different podcasts of the Bad Radio Weekly Wrap-Up. Bad Radio is Bob and Dan, right? A. Yes. Q. You see on the left it says Playlists, Podcast, right? A. Yes. Q. Okay. Have you seen this before? A. No. Q. Okay. You were aware that these episodes were provided in podcast form for people to listen to, correct? A. Yes. Q. Okay. And if you look at the side, there's a download number there. Do you see that? A. Yes. Q. Okay. For the Bad Radio Weekly Wrap-Up of February 7th, 6.8K. Right. A. Yes. Q. That's downloads of that podcast. You understand, right? A. Yes. Q. And at that point this was actually the Hang Zone, right? Or the show that would become the Hang Zone. A. 2 to 7 no. 2 to 11 is when Jake and I started doing our show. Q. Okay. So the one right above it. A. Yeah. I'm sorry. I was looking at the bottom. 1. And this is something we just put together. This was not put together by the station. We paid the guy out of our own pocket to put that together just to try to promote the show. Q. So you paid a guy out of your own pocket to do these to create these podcasts. A. Yeah. Q. Okay. And that was at the time, right? A. Excuse me. Q. You did that at the time. A. Yeah. We paid a guy to just do the weekly podcasts. It's where he would take a bunch of segments from our show. To my knowledge, this isn't done for all the shows on the ticket. We did it to help grow our show and promote our show. So he would put together a lot of different segments of what we had done during the week and then would upload it through the ticket's website. Yeah. Q. Upload it in podcast form. A. Yep. Q. You talked about The Freak earlier. You're aware that the Freak radio station also has podcasts, right? A. I am aware that they repackage their shows. I think put them out full shows, or maybe segment by segment. Q. And you're aware that the Ticket also does original content podcasting, right? A. I am becoming more aware of that. Q. You knew your partner did that, right? A. I really wasn't aware of what he did. No. I wasn't. No. I learned a lot more in just the past month that I had no real idea that he did, like these draft podcasts. No. Q. And you did YouTube videos, right? A. That's a stretch. When we were broadcasting on location, I was pulled aside and asked, hey, do you want to record a video and say how the week's been? And I said, sure. But, apparently, they loaded that up onto YouTube. But I did not consider that doing a podcast. Q. Now, you left Susquehanna in July, right? A. June 30th, I think was our last day. Yeah. Q. You got paid through July 14th, correct? A. Yes. Q. And, again, that was your own volition, right? A. Well, my contract ended so I didn't leave. Q. Okay. You also weren't fired, is what I'm trying to say. A. That's correct. Q. The negotiations just didn't work out. A. That's correct. Q. And then after that, you started doing the Dumb Zone podcast, right? A. That's correct. Q. And you agree with Mr. Kemp that the Dumb Zone was a phrase that was used on the Hang Zone, right? A. Very early on, like you guys played an audio drop. I don't know that those drops were played much past the first, as we were trying to decide on a name, as you can see from that list you showed earlier, we were just throwing out a bunch of funny things. And the Dumb Zone was one of the funny things that we threw out. Q. The list that you talked about, that was developed while you were at the Ticket, right? A. Aha. Q. Okay. So those were names you came up and developed while at the Ticket. A. Yes. But, I don't think that would preclude us from using any of those in the future. Q. Okay. A. Or do you? Perhaps it would. I don't know. I guess that's for the court to decide. Q. Okay. Mr. Pernini, sorry. Just a moment. The court, I'm going to take a pause real quick while you're getting it up, off the record. The court, back on the record. Go ahead. Is there a question? Mr. Pernini, not yet. I was about to ask one. Q. If you look on your screen, you see section 15.1 of your agreement. A. Aha. Q. And this says that the property rights of every program, announcement, event, and promotion with which employee renders, and services, the titles and content thereof, including every format, idea, theme, script, characteristic, element thereof, belongs to the company. Do you recall that being part of your contract? A. Yes, I do now. Q. Okay. All right. And so, certainly, the names you thought up would fit under that, correct? A. So you're saying every comedy name that we thought like, even the 10th name on that list, that like, we can't ever use those. That's what's being alleged. Q. My question is, the Dumb Zone was one of the names on there, correct? A. It was, yeah. Q. And it was in fact on the website, wasn't it? A. I've learned that today. Q. Okay. A. It was crossed out, I guess, because of all the I guess. The guy who made our website must have. Q. Right. A. Heard our comedy segment on these are the names we're not using, but we are using the Hang Zone. Q. Okay. And the reason you picked the Dumb Zone was because it's a name that Hang Zone listeners would be familiar with. Right. A. I'll go with Jake's answer, which was we also think we're two pretty dumb guys. We just thought it would fit. Q. You didn't try to find a name that would disassociate yourself from the Hang Zone. A. Well, I mean, we would like to use the Hang Zone, but I was pretty sure we couldn't use the Hang Zone. Q. Of course you'd like to use the Hang Zone. A. Yeah. Q. Right. Because you want to have the same audience that you had at the ticket, right? A. Just the Hang Zone kind of describes two guys just hanging out, more than just because it would get us the same audience. Q. So it's not only cause it gets you the same audience, but that's one of the reasons. A. Well, no. I don't think it was one of the reasons, no. Q. Okay. Now, when you left the company, you wanted to do the same show that you were doing by podcast you were doing at the ticket, right? A. That is incorrect. Mr. Pernini, let's play audio A10. Plaintiff's audio exhibit number A10 played. Q. It feels good to do this again. That was his comment. Correct. A. Well, I think what he's referring to is making fun of me for not being able to pronounce something because I'm an idiot. Q. You think he stopped making fun of you when you weren't on air? A. What do you mean? Oh, no. He didn't stop making fun of me. He makes fun of me all the time. Q. So what felt good is to be doing the podcast. A. To be publicly making fun of me again. Q. Okay. On the podcast. Just like he was doing on the Hang Zone. A. Yeah. Q. Now, you got a cease and desist letter from Cumulus. Right. A. Yes. Q. And fair to say that you mocked that cease and desist letter on your show. A. I suppose the term mocked, we joked about it. Sure. Q. Okay. And would it be reasonable for someone to think if you're joking about it, that you weren't going to follow it? A. Well, I mean, if we were on the air broadcasting, reading it, then that indicates that we didn't follow it. Yeah. Q. Okay. And A. We didn't think it was valid. Q. Okay. Mr. Pernini, why don't we play A19? Plaintiff's audio exhibit number A19 played. Q. Do you recall that broadcast? A. I do now, yes. Q. Okay. You had a choice to put any content on that podcast, right? A. Yes. Q. That's what you chose to put on, though. A. That is, apparently, what I chose. Q. Do you have A lot of extreme consciousness talking? Yeah. Q. You would agree that a reasonable person would not consider that to be complimentary to the ticket, correct? The court, I think, really, you've been asking lay witnesses legal questions, and I just think that's inappropriate. I think it's for me to decide what is reasonable in light of the context of the contract, not with what you're doing on cross-examination right here. So that's the way I feel. If you want to keep asking this question, I just think it's improper. Mr. Pernini, I appreciate it. The court, I'm just being honest with you. Mr. Pernini, I appreciate your feedback. We'll move on. The court, let's go off the record. The court, back on the record. Go ahead. Q. Under your contract, you had a budget that you could use to pay for expenses for the Hang Zone, correct? A. Correct. Q. And it was 12.5 for you, correct? 12,500 for you, correct? A. Yes. Q. And that could be used to get reimbursement for any expenses related to promoting the Hang Zone, right? A. Eventually, that was the case, yes. Q. Okay. Eventually, at the time of 2018, that was the case, right? A. Not really, no. Q. Okay. Why do you say not really? A. Up until after the pandemic, the budget was only used for, like, if we got a weekly guest type thing. Or possibly we could use it for a roadshow, just to prove something, approved by my boss, Jeff Catlin. And that was pretty much the discussion, would be about those type of things, but not about anything else. Q. Turn to Exhibit 14th. And this is the website for the Hang Zone, correct? A. Right. Correct. Q. And this was developed after the Hang Zone was got its name while you were at the ticket, correct? A. Yes. Q. So this is after the pandemic, or I guess in the middle of the pandemic, right? A. I guess yeah. This probably didn't debut until 2021, I would guess. Q. And you could have sought reimbursement for this, right? A. I guess. I don't know. Perhaps at the time we did this, I was under the impression we could not. I'm going to have to look at a timeline. Q. Okay. And when you left the company and started the dumb zone, I'd like you to look at Exhibit 15. You for some time redirected. If someone went to the Hang Zone, they would be sent to this website that says the dumb zone, right? A. Yes. Q. And these have the links of all your different Patreon accounts, right? A. Our different social media accounts, yes. Q. So if someone said I want to see what the Hang Zone is and typed in www.hangzone.com, they would see we're now the dumb zone, correct? A. thehangzone.com. Q. thehangzone.com. A. It was not hangzone.com. Q. You would redirect them so that they would now be sent to the dumb zone, right? A. Yeah. We wanted to take off the audio that we assumed was intellectual property of the ticket. We didn't want to be posting that anymore. Q. Right. But the www.thehangzone.com you redirected, correct? A. That's correct. Q. I will ask you this because we don't know. Sometime it redirects, sometimes it doesn't. Have you made any changes to that since this litigation began? A. I have not, but I know what you're talking about. Q. Okay. A. Cause I went there a few days ago and I saw the audio, and then I went there last night and I saw this. Q. And if you go. A. So it. Q. Sorry. A. It might have to do something with our guy in Austin who hosts the server. I don't know. Q. Okay. And if you go to the Twitter account listed on the Hang Zone, that link will lead you to the Dumb Zone Twitter account now, right? A. The name of the account is now the Dumb Zone, yeah. Q. Okay. And that's an important point. The name of the account is the Dumb Zone, but it's still the account that was the Hang Zone account, right? A. Yes. Q. So there were followers to the Hang Zone Twitter account. A. Well, it's my personal account that I would use to promote the show I was in. Q. Okay. And you called it the Hang Zone, right? A. Yeah. Q. That you acknowledge is the intellectual property of the ticket, right? A. I acknowledge what I did on the air was the intellectual property of the ticket, sure. Q. So you're denying that the Hang Zone is that. A. That the Twitter account was. Q. The name the Hang Zone. A. Using that on the air for sure, yeah. Q. But when you decided to switch names, you didn't want to just start a new Twitter account. You wanted to have the Hang Zone at thehangzone.com followers, the people who were following that Twitter account now be following the Dumb Zone, right? A. Well, it was my Twitter account. Yeah. Q. When you say it was your Twitter account, the name on it was the Hang Zone, right? At the Hang Zone. A. That's right. Q. You could have gotten reimbursed for it, but you didn't ask, right? A. It didn't cost any money. Q. Okay. So it didn't cost you any money to have it. You just set it up using thehangzone.com. A. Yes. No one asked me to set it up. Q. Okay. And let's. Mr. Pranini, do we have audio on that? Plaintiff audio exhibit playing. Q. Your goal there was to not lose the followers, right? A. Yeah. Correct. Q. Not lose the followers of the Hang Zone. A. Right. Q. Okay. A. Of that account, sure. Q. Right. And you also changed the Facebook page for the Hang Zone to the Dumb Zone, right? A. Yeah. But the Hang Zone Facebook page was set up by me, for sure. Jake is not on Facebook. Again, probably when we first started to call it the Hang Zone. But that was, then, the last day I touched it until we started the Dumb Zone. So, Q. And, A. I didn't do anything to promote that, ever. In fact, it might have been dark. It might have been dormant. I'm not even sure it was active. Q. If you look at Exhibit 16, A. Okay. Q. This is the Facebook page that's been pardoned. The Facebook thread for that has now been changed to the Dumb Zone. A. Okay. Q. You see how it still has Hang Zone content on it. A. Yeah. Promoting the movie, yeah. Q. Okay. Cause that's what. A. That must have been, like, the only thing I did on there. Q. Is to switch the name. A. No. I mean, like, whenever I set this up, we might have tried promoting one thing and then I totally lost interest. I don't know. Q. Okay. A. So yes. Q. You were trying to capture the same audience, right? A. We wanted those people to know where, like I said, I didn't think we had an audience on Facebook. Q. You wanted, generally, the audience to know, the people who were listening to the people who used to listen to the Hang Zone to know to come listen to the Dumb Zone, right? A. Yes. Q. Okay. And let's show you Exhibit 36. The court, okay. Counsel, it's clear that we're not going to be finished with this witness by 2:45, which is when I have a criminal sentencing scheduled. We're running late on that, so I'm going to recess this until after my sentencing. Let's go off the record for a second. Off the record. The court, back on the record. Let's go and finish the cross-examination. Go ahead. Q. Okay. Exhibit 36. This is a tweet from a Stephanie Mills that you respond to. You've seen this before. A. I saw it last night. Q. Okay. A. Apparently, I saw it on August 12th. Q. On August 12th. And Ms. Mills, is it Mills? First of all, do you know Ms. Mills? A. No. Q. Okay. She tweets, gutted about the Hang Zone. I need to know where your podcast is. It's totally fed up my day and I need my noon to 3 p.m. kick back. Did I read that correctly? A. Yes. Q. Okay. And she's basically saying I am missing the Hang Zone. Where is your podcast? And you respond by tweet and say, come to the Dumb Zone. That's where it is, right? A. Yeah. Q. So you knew this was a listener of the Hang Zone that wanted to find your podcast and you were happy to have her join on. A. Yes. Q. Now, your non-compete is for 6 months, correct? A. Yes. Q. Did you ever consider just waiting for 6 months to start this endeavor? A. The podcast. Q. Yep. A. No. Q. Did you ever consider podcasting it not in the Dallas area? A. I never heard of that before today. Q. You never looked into it, right? A. I don't think it exists. Q. Okay. And you've been. A. I don't think it's a real thing you can do with a podcast, but I don't. Q. You have no idea though, do you, sir? A. Yeah. I never heard of a podcast that does that, no. Q. And you've not looked into it, right? A. Have you heard of a podcast that does that? Q. Sir, I'm the one asking the questions. A. Oh, sorry, I have not. Q. Okay. My question was, you didn't look into it, right? A. I did not look into something I had never heard of. Q. And at the time, did you do? Mr. Pernini, strike that. I pass the witness, Your Honor. The court, okay. Let's go off the record. Off the record. The court, back on the record. Counsel, we are going to take a recess in this case. We'll pick up with the direct examination of Mr. McDowell. I believe we'll be ready to go at 3:30. You're excused. Security officer, all rise. Court is in recess. The court, Mr. McDowell, I believe, is on the stand. If you can come back. And we're still in the process of doing cross. Right. Mr. Pernini, no. We passed the witness, Your Honor. The court, you did pass. Mr. Pernini, yes. The court, okay. It's too late on Friday. Have a seat. We'll go on the record. Go ahead. Mr. Kingston, thank you, Your Honor. Direct examination. By Mr. Kingston. Q. Full name, Mr. McDowell. A. Daniel McDowell. Q. Who are your immediate family members? A. My wife Kathy. My daughters are Ava and Eden. Q. What do Ava and Eden do? A. They are in college. Q. And college is famously affordable these days, correct? A. It is very expensive. Q. Are you the primary breadwinner in your house? A. Yes. Q. Let's talk a little bit about how you got to Dallas and some of your negotiations over the years with the ticket. You came in 1999. Who hired you? A. Bruce Gilbert. He was the program director back then. Q. And you came here to start a new show with Bob Sturm, is that right? A. Yes. Q. So at that time, the two of you negotiated your contracts, with Mr. Gilbert working together. A. Yes. Q. What did Mr. Gilbert give you any advice about contract negotiation? A. We were a new show starting out together. His advice was, I want you guys to have the exact same contract because it's very important, in his opinion, for what would you call it? I don't know if it would be morale or just he had seen in the past or heard in the past about other, radio shows where one guy made a little more than the other guy or one guy found out, that it would cause friction between them, which would spill over onto the air and affect the product in a negative way. So he thought it just best overall, he said, you guys should have the exact same contract and work that way as you go into the future cause this is a 50-50ths proposition. You both are working just as hard on the show. Q. Did the ticket's attitude toward negotiating jointly change after Mr. Gilbert departed? A. Yeah, I guess. Just in the sense that it was referred to earlier but my partner over the years would tell me that he was pulled aside on a number of occasions and offered the chance to negotiate on his own without me because it would be more beneficial to him in the long run financially. Q. Can you take us through what happened in the 2013 contract negotiation? A. At that time we had an agent, and I believe he was talking to the owner of the company. And at that time, our initial we had been on the air together now, Bob and Dan, for 14 years, and he apparently, our agent was told our offer was a pay cut from the year prior, and the explanation was, I know both of these guys have, young kids, in school, they're probably not going to want to pick up and move out of the market. I don't believe any of the other stations in the market would offer them anything, so, we don't need to offer them a raise of any sort. Q. Is that when you went to speak to the fan? A. Yes, that's when we went. We actually called both of the other bigger stations in town that the ticket considered their competition. It was the Fan and ESPN Radio. We contacted both of them and met with them. Q. And did you get an offer from the Fan? A. Yes, the Fan offered us a contract. Q. How did it compare to what you were being offered at the ticket? A. It was quite a bit more, probably would average about $100,000 a year more. Q. But you didn't leave. Why was that? A. In the end, during the negotiation our agent, apparently, told the ticket or the owner of the station that we had this offer. And he was told, if you present the offer to me if you guys sign the offer, we will match one of them. And it was told to Bob behind the scenes, we'll match your contract. We'll match you, so we'll sign you to that offer. I have in my contract, I have a right to match. Cumulus has a right to match. So they just, we viewed it as a threat that, they knew we liked working together and we wouldn't want to break up, so I'll just match Bob so Bob will make that money. He'll work here, and Dan, you can go work over there by yourself. The other station probably didn't want just one of us, they wanted a show, so it was certainly a threat that, worked. Q. The contract you ultimately signed in 2013, what was the pay compared to the year before? A. It was a pay cut from the year before. Q. Have you heard a lot of employees remaining with an employer after receiving a pay cut? A. Can you say that again? I'm sorry, I didn't catch it. Q. You ever hear stories of people staying at an employer after they get a pay cut? A. No, I can't say that I have. Q. What was the structure of that contract? Didn't it have different compensation for years going forward? A. Yes, it did have pay increases. The court, hold on. A. Each year. Mr. Pernini, Your Honor, he's talking about the 2013 contract. I know we sort of let a lot go this late in the day. I don't know what the relevance would possibly be for. The court overruled the objection. Mr. Pernini, that's fine. Q. I think I'm going to try to. I think Mr. Pernini has a good point. We can try to move this along if I don't ask such open-ended questions. That contract was a 3 or 4 year contract that had higher pay in each succeeding year, correct? A. Yes. Q. But the pay was dependent on the station hitting certain revenue goals. A. Factually, there was higher pay on the base salary each year. The first couple of years, yes. I believe starting in year 3, then the station would have to meet a certain revenue goal in order for the contract to go up. And so I guess it didn't go up after that cause we never, or we were always told the station did not hit those revenues goals. Q. Did you ever receive any kind of accounting for whether the station had hit the revenue goals? A. No. We would just receive a letter that said, for example, your contract said we have to hit million this year and we hit 21,900,000. It would always be they had fallen somewhat short. Close but short. Q. So you mentioned earlier that they continually tried to negotiate separately with your co-host Bob Sturm. At some point, did you feel the need to meet separately with Dan Bennett to explain to him what you do? A. Yes. In 2017, so before signing this most recent contract that's been shown, my 2018 through 2023 contract, Bob, I guess, had been talking to people in higher management. He was getting the intimation or the direct word that, Bob and Dan together, the inference was that I wasn't viewed as valuably as Bob was, and that, in the event Bob ever wanted to be in drive time, that probably wouldn't happen. Drive time is, when more cars are on the road, so it's morning and afternoon. Midday is when there's less vehicles on the road. And I guess in drive time, cars on the road equals more listeners usually. So there are more listeners morning and drive and afternoon. So that's kind of a progression sometimes in radio people want to work. If I work middays, I would want to work in drive time because there's more listeners and more money. But I guess the word Bob got was that, you're not going to go to drive time with Dan. So I wanted to, although I had worked there 18 years. I thought it was important to, I just didn't feel like Dan Bennett knew me very well. I didn't think he knew what I did behind the scenes, and he was the guy that we would be talking contract with the following year. So I asked him for an off-site meeting. We did. We went and met, and I just basically pitched him myself. Told him what I, put into the station, what the radio meant to me. I just did not think he knew me at all and understood what I brought to the show. So I just had an off-site meeting just to kind of tell him how important radio was to me and how much I did for the show and for the station overall. And just kind of trying to pitch myself so that, moving forward, they would want to continue to keep Bob and Dan as a show. The court, all right, let me pause here. We'll go off the record. The court, go back on the record. I believe I interrupted your questioning, so go ahead. Mr. Kingston, that's just fine, Your Honor. Q. Let's see. The court, do you want your last question read, or are you good? Mr. Kingston, oh, I think he answered it, Your Honor. The court, well, I just needed to know if you needed me to remind you where you were. Mr. Kingston, no, thank you very much. The court, okay. Q. Dan, can you see this on the screen? It's Defendants Exhibit 3. A. Yes. Q. Do you recognize this document? A. Yes. It looks like a redline in our current most recent contract negotiations, a redline version of the contract. Q. Well, in the 1.3 appears to be identical to the competing business definition that you have in your contract. It appears they're trying to add more things that were competing businesses, correct? A. Yes. Q. And do you see the note there from Olga, whose last name I'm not going to attempt, and the indication that they, Cumulus, will not agree to limit competing business definition to terrestrial radio? A. Yes. Q. That was, and she wrote that because your previous contract definitely is limited to terrestrial radio, correct? A. Well, that appears to be what she's intimating. Not intimating. Saying. Q. The other thing I think you said, and Mr. Kemp said, is that there are aspects of these contracts that really, the ticket refuses to negotiate. You've seen a lot of email and text from me. I don't think I super often capitalize both letters of no when I'm answering your questions, do I? A. You do not. That would indicate being very firm. Q. One other thing I needed to clean up. Mr. Kingston, I'm pulling up 27, counsel. Your Honor, this is the exhibit that we added, and so we just needed them to sign off on it. I wanted to give them a chance to say whatever they need to do. The court, go ahead and offer it and tell me if they have any objections. Mr. Kingston, we offer 27 defendants, 27 for the record. The court, any objection? Mr. Pernini, no objection, Your Honor. The court, pardon. Mr. Pernini, no objection. We were trying to find it on the table. Mr. Kingston, sorry about that. Mr. Pernini, that's all right. Defendants Exhibit number 27 admitted. Q. Dan, you've seen this email before, correct? A. Yes. Q. I'm just trying to clean up what seems to be a hard thing to nail down. When did you quit? A. Well, we thought our last day was June 30th. I believe that's a Friday. I believe Friday is June 30th. So that is what we thought our end date was. Q. Okay. A. We were asked after going through negotiations continuing to negotiate, we thought we had come to the end of the road on Monday, July 17th. And we called Dan Bennett and said we don't, think that this isn't going anywhere and we're ready to be done. And he asked us to send in a formal resignation. So I thought that was kind of weird, but we did it because he asked us to. Q. Okay. Let's talk about your plan for the Dumb Zone. When did you start planning to publish a podcast? A. Let's see. So Monday, the 17th, is when we were asked to send that resignation. Later in the week, the ticket actually talked about it, some on the air, and we felt that was then officially official if the ticket is acknowledging it publicly. And then probably that weekend we decided to let's record something and call it the Dumb Zone. Q. You described to me your attitude in creating the Dumb Zone as your desire to be cool. What did you mean by that? A. Well, I thought based on my contract, I was able to do a lot more than just what we were doing. But, Q. Like what? A. Like I feel I could have started a video streaming show every day from noon to 3 o'clock on YouTube. I thought I could have worked for a podcast company that podcast in Dallas. I mean, podcasts just get submitted everywhere. But I have talked to a few podcast companies, and that sold advertising, because my contract does say I can't solicit advertisers from the ticket. So I thought it would be just fine to do a podcast with ads. But I, again, didn't do that for a couple of reasons. 1. I feared litigation because, Cumulus has anyway, it's a thought that they might, come after us even if we got an advertiser that wasn't solicited. But also I had a lot of friends that work at the ticket. I worked with Cat for so many years. Jeff Catlin, I'm sorry, his nickname is Cat. And Dan Bennett. I didn't want to have even the impression that we were attempting to compete with them or to harm them in any way. If I might, I don't know if I should even say this. This is why I didn't want your talking about our contract negotiations. I asked for our this hearing date, to be pushed back to do mediation first because I didn't, when getting into all this legal stuff, I didn't realize all this is on the record. Everything is very public, and I don't want to be saying things. I have gone to great lengths to not say anything negative about the ticket, even if I have some negative thoughts. As we said in our goodbye video, the week of the 17th, I love the ticket. I want people to keep listening to the ticket. That's what we said on the video. That's what we said publicly. We said don't be upset with management, don't be upset with the station at all. This is just a business thing. We made the decision, they made the decision. I don't want to be up here saying how I was treated during negotiations. That's part of the being cool. And part of it was, look, let's just go podcast behind a paywall. It won't affect their customers. Their customers are advertisers, our customers are direct consumers. So we're not messing with their customers. We're not messing with their revenue at all. We're not messing with their ratings, because we publish at various times. We're not live streaming. I could live stream. I'm not going to live stream. That was my goal going in, and it continues to be today. That's not in the plans, the immediate plans. 6 months from now, who knows what we'll do. But, yeah, I don't like that we're here. Well, the court, hold on. Mr. Kingston, yes, the court, come on in, off the record. The court, will go back on the record. Please proceed. And I apologize. Mr. Kingston, thank you, Your Honor. What are the differences between the shows that you produced at the ticket and the Dumb Zone? Well, the show on the ticket was very good. I think it was just a big sounding show. There's a lot of sound. There's more voices. It sounds like a well-produced, machine. It's formatted in a certain way. You have to take breaks every, let's say, approximately 20 minutes or so throughout an hour. You have to start the show at the very same time. You end the show at the very same time. It's live, so anything can happen type of a thing. The content, as far the content is different as well as far as, you own the ticket. Our boss would have us, like the first big segment of the day is we would consider 12:30. We have to have a big sports story of the day there. There has to be big sports story of the day. And then, the news would be at exactly 1:30 and then 1:35 or so, then the we had to go back after the news, had to be another sports segment type of thing. So, it was sports-based and it was pretty much, like I said, formatted. Whereas now, we have no format at all. We have no clock. We could go as long or as short as we want. We are just two guys. There's not a lot of sound and not a lot of production value. Let's see. We might start like, hey, let me give you a couple of birthdays that are today, and we do that for 3 minutes, and then we'll go on to a news story I saw. And then, we'll go on, there is no format, is basically the answer. And then the paywall's a significant difference in how revenue is generated. Sure, yeah, And to be clear, you have had, well, let me ask you, have you had people offer to advertise on the Hang Zone? Yes, I mean, the Dumb Zone. My apologies. Sorry, yes, And those advertisers are not ticket advertisers. That is correct. Did you have an experience with an all-staff meeting at the ticket? When would those occur? A variety of times throughout the years. It might be, for we have some big events coming up and we want to brainstorm for that, or it might be because a new competitor has hit the scene. So when, and let's all have a big meeting and talk about that. So when the Freak started broadcasting, did you have one of these meetings? When the Freak started, yes, for sure. What was the content of that meeting? Just letting us know there is a new competitor featuring Mike Reiner. Mike Reiner, he's the guy who started the ticket back in 1994. So he was a longtime Dallas broadcaster who started the ticket. And he was a legendary. He's a Radio Hall of Famer, legendary broadcaster. He retired in 2020. That is what set the events in motion, which had, Cat moved, Jeff Catlin, my boss, moved my partner, Bob, to the afternoon drive show. He moved Jake from producer as our show up to co-host of what would become the Hang Zone. Anyway, Mike Reiner retired back then, left radio, but then, apparently, he came out of retirement to start another radio station called The Freak last year, I believe, in the fall sometime, October, November. And, yes, that caused us to have an all-staff meeting so we could talk about the fact that Mike is over there now and it's to be taken seriously. And let's tighten our act up and make sure that we're just doing everything we can just to reiterate all of the things we'd always talk about that, we want to make sure we're putting out the best product we can so that we can defeat this competitor. Q. Well, radio legend Mike Reiner also started a podcast in 2020, didn't he? A. He did at some point, yes. Q. Was there an all-staff meeting about that? A. No, there was not. Q. Has the station ever given you an indication that it considered podcasting to be competitive? A. No. Never had a meeting because a podcast has jumped on the scene. Q. So, in your mind, the things that you did to create a separation between the dumb zone and your work at the ticket were intended to protect the ticket. It's part of being cool, right? A. Yes. I wanted to protect the ticket and avoid litigation. Q. How is that going for you? A. You can see. Q. Okay. Let's talk about a few of the things that plaintiff has said that you either violated or in danger of violating. It's a little unclear on some of these. One of the things that they say that they have done in order to extract from you the promise of not competing is to give you a bunch of confidential information. What would that be? A. I don't know. Q. Do show hosts receive a lot of confidential information from the ticket? A. In my opinion, no. Q. Did you have a password where you could access non-public files? A. No. Q. Is the planning that show hosts do for the ticket like trade secret or is any of that material kept confidential? A. No. Q. Another thing that they said that they gave to you in order to get these restrictive covenants back from you was goodwill. Where do you think goodwill comes from? A. Again, we talked about goodwill a little earlier. I'm fuzzy on really what goodwill means. It's very subjective, so I don't know where goodwill comes from. Q. Let's put it this way. Did the ticket give you your audience? A. I would not say so. I think we built the audience ourselves there, our radio show did. Q. So if goodwill is somehow related to audience, it's basically generated by the on-air talent. A. Okay. Again, I'm fuzzy on what goodwill really means. If you can actually quantify what goodwill is, but if it is a thing you can generate, then, yes, I would have to agree with that. Q. The other thing that they say they gave you in order to extract these promises from you was training. What kind of training did you receive at the ticket? A. I don't feel I received training at the ticket. Q. There wasn't periodic continuing education. A. No. Q. Did somebody teach you how to make that big sound that you referred to in your Hang Zone program? A. No. I got hired in 1999. I had already been doing a talk show for a few years, 4 or 5 years in various different areas. I think I was hired because I could do a show. Q. What would you like going forward, Mr. McDowell? A. I supposed to be just left alone to kind of keep doing what we're doing, and that's it. I want to leave them alone and they have us be left alone. I don't feel like we're doing anything that competes with the ticket. I certainly don't want to take any of their revenue away. I want my friends who work at the ticket to continue to be successful, and I feel like we're learning about a whole different area, a whole different medium. Just even the feel of doing a show, it's like we're learning how to do a show in a podcast medium. It's just a different thing, and I want them to continue to do their thing and succeed. And, hopefully, we can succeed as well. Mr. Kingston, pass the witness, Your Honor. The court, thank you. Anything further? Mr. Pernini, yes, Your Honor. The court, questions on your part. Go ahead. Mr. Pernini, yes. Recross-examination by Mr. Pernini. Q. Just a few questions, Mr. McDowell. You said that at the end you just want to be left alone, right? That's what you just said, correct? A. Yes. Q. Okay. When you started the podcast, you started talking about the ticket immediately, correct? A. We did talk about the ticket, yes. Q. In fact, you heard the testimony in Mr. Kemp's case that was on every episode until this litigation began, right? A. I don't know if that's true. I do know that, every time we talked about the ticket is in evidence, right? Q. No, just the parts we played. A. Oh, okay. I'm sorry. I thought it was 5 or 6 times. We talked about the ticket, but I don't know how many episodes we did before. Q. You had entire episodes talking about the ticket, isn't that true? A. That is not true. I heard when you said that earlier. I was thinking no. When we had Akash on we talked a lot about the ticket, but we also had a good amount of talk about his history and how he became a comedian and what it's like to do that. Q. Okay. And you have indicated that you want to talk more about this litigation on your podcast, right? A. I would like to, yes. It's just very interesting going through this process. For sure. I think people are interested in hearing about it. Q. All right. The only reason you haven't been talking about the ticket is because of this litigation at this point. A. Yes. We've been told not to. Q. You said that you think you built the audience, correct? A. I think I had a good hand in that. Yes. Q. Sure. Of course you did, and part of the reason you were able to build an audience is because the ticket gave you a platform and allowed you to broadcast in the Dallas-Fort Worth area, right? A. I am being paid was being paid. I'm sorry, to broadcast on their platform, yes. Q. So both. A. They didn't give me yeah. Q. Both of you benefited from it, fair. A. Yes. Q. You got celebrity, you got a following, the ticket also got a following, correct? A. Yes. Q. Okay. You have a confidentiality clause in your agreement, right? A. I don't know. Q. Okay. Let me rephrase that. You said you don't know if you got confidential information, correct? A. I don't feel that I have. No. I can't think of anything. That would be. Q. Did you got ratings information, correct? A. Yes. Q. And you were told what the station's strategy was to do with those ratings, correct? A. I'm fuzzy on what that exactly means. Q. Okay. Well, let me. A. Strategy on what to do with those ratings. I mean, they would talk about things, but our main goal was just to go out and create a good show every day. Q. Okay. And you got feedback on that show from you. Called him Mr. Catlin. A. Yes. Q. He would give you feedback on the show as it went along. Correct. A. Sure. Q. You didn't consider that to be training, though, in your mind. A. No, I don't. Q. Okay. But it is feedback that was provided from the station to make the show better, correct? A. Sure. We worked together to try to make the show better. Yeah. Q. And you said that you tried to put the show behind a paywall. You heard Mr. Kemp's testimony. The show is not only behind a paywall, right? A. That's right. We would put one out on YouTube. Q. And you still intend to do that, right? A. I would like to do that. Yeah, Mr. Pernini, no more redirect, Your Honor. The court, anything further? Mr. Kingston, just a brief, Your Honor. The court, go ahead. Mr. Kingston, sorry, redirect examination. By Mr. Kingston. Q. We need to clean this up because I think Mr. Catlin tried to say that ratings are private or confidential. Our ratings, all over the internet all the time. A. I know that at least some version of it usually is posted by one of the tickets, our coworkers, would post that on Reddit, that we've already referred to Reddit. Right, yeah, I believe in some form they're available, yeah. Q. And if you did well in a month or in a quarter, you might actually really advertise what the ratings are. A. Sure, Mr. Kingston, pass the witness, Your Honor. The court, anything further? Mr. Pernini, no questions further, Your Honor. The court, Mr. McDowell, you can step down. The witness, okay. Thank you. The court, I believe you have one more witness. Mr. Pernini, yes, Your Honor. The court, please call your next witness. Mr. Pernini, we call Larry Rosen, Your Honor. Mr. Rosen is going to provide expert testimony regarding he does surveys, and I've spoken with opposing counsel. They basically are not objecting to his qualifications to testify for this preliminary injunction hearing, but they want to reserve the possibility if it goes to trial. The court, I'll let them articulate their objection. So what you called him to the stand? Raise your right hand, I'm going to swear you in. Whereupon, the oath was administered by the court. The court, okay, take the stand, and let's just start asking questions. If there's an objection, they can state it as opposed to you articulating what their objection is. Mr. Pernini, I was trying to cut through the laying of the foundation of him being an expert, so I'll start. The court, you have 27 minutes left, but if you want to articulate on the record what your agreement is, you can do that. But, if you're reserving the objection, I'd rather you tell the court what you're reserving. Mr. Cawley, yes, Your Honor. The court, go ahead. Mr. Cawley, I will stipulate to his qualifications to testify as an expert on the limited topic of his research. I reserve the right, and just to move this along, I reserve the right to object to his qualifications. I mean, not to his qualifications, to the reliability and the relevance of his opinions. I believe his opinions are not relevant, they don't. There's an analytical gap between the opinions he's going to give and the issues in this case. But for the purposes of moving this along, I want, Your Honor, to hear his I understand you. The court, all right. Will you succinctly state your objection? You have no objection to the qualification of this witness, and if you have any further objections, you are reserving them. Mr. Cawley, yes, Your Honor. The court, is that right? Mr. Cawley, that is it, Your Honor. The court, ask your questions. Mr. Pernini, thank you. Whereupon, Larry Rosen was called as a witness, and, having been duly sworn, testified as follows. Direct examination, by Mr. Pernini. Q. Can you state your name for the record? A. Larry Rosen. Q. Mr. Rosen, what is your position? A. I'm president of Edison Research. Q. What is Edison Research? A. We're a survey, research, polling, market research company. Q. And how long have you been with Edison Research? A. I'm their co-founder. We started in 1994. Q. Okay. What kind of polling does Edison Research do? A. We do a broad variety of different things. We are best known as the company that does the exit polls for the National Election Pool, which is a consortium of ABC News, NBC News, CBS News, and CNN, which has contracted with us for over 20 years to provide election night, election day, and night polling. The exit polls that you see on those 4 networks, they're also on newspapers around the country. We also do the vote count for those 4 networks, so we tally the votes. So all the data you see on election night comes through us on those 4 networks. And then we do many other kinds of polling and survey research, but we have a very strong concentration in anything to do with the world of audio. Q. Okay. So you do audio polling. A. Of various kinds, yes. Q. How long have you done that? A. Since our founding in 1994. Q. Okay. And do you currently have a survey that you do what you call share of ear? A. Yes. Q. Okay. And can you tell the court what that is and when you started it? A. Yes. So share of ear is, to the best of our knowledge, a unique survey where we're trying to measure the entire audio sphere, all the different ways people could listen to audio. We've been doing it since 2014. It's a diary-based study. We draw a random national sample of Americans age 13 and older. We recruit them to, like I said, represent the U.S. population, and we ask people to keep a very detailed diary of all their audio listening in every form for 1 day. Q. I'm going to interrupt you there. I'm going to put up what's been marked as Exhibit 37. And this is from Edison Research, correct? A. Yes. Q. And this gives some of the examples of the methods you were just talking about, correct? A. Yes. Q. Okay. What is the ultimate goal of this survey? A. To understand everything that people are listening to in terms of audio. And of course to transit over time to look at the changes that have happened. Q. Okay. And you've been doing this since what time? A. Since 2014. Q. Okay. Who subscribes to this report? A. Many of the biggest companies in the audio world. So big radio companies like iHeart, Odyssey, Cumulus, Hubbard. All the major streamers, Apple Music, Amazon Music, Google, Spotify, Pandora, SiriusXM. A number of advertising agencies, some financial firms. We have a broad list of clients for this data. Q. How is this different than Nielsen ratings? A. So Nielsen ratings are measuring local listening in markets around the country, including, of course, here in Dallas, and doing it at the station level. So how many people are listening to one station or another? We're doing a much more global look at the entire world of audio. So we're measuring radio, but just radio, not individual radio stations. We're measuring nationally, not locally. And then we're able to compare total listening of radio to listening of other forms of audio like SiriusXM or People's owned music or podcasts, audiobooks, anything. Q. Has your survey shown an average amount of time that people listen to audio? A. Right. So people keep this very detailed 24-hour diary, and we go through lots of methods to make sure it's representative, like I said. And we total up how much listening they record over the course of a day. Some people record very little, some will record a lot, of course. And on average, our estimate is 4 hours and 11 minutes of listening per day among all Americans 13 and older. Q. Has that changed? Well, let me put it this way. During the course of the survey, have you seen whether that amount stays the same? Is it growing? Is it lessening? A. It certainly changes a little bit every time we update it, but in general there's not been significant changes in the amount of listening. In fact, our current estimate is exactly the same as what it was the first time we reported in 2014 or within, a tiny little differential. Our current estimate is 4 hours and 11 minutes, like I said. The first time we recorded it, it was 4 hours and 17 minutes in 2014. There has been some variation over time, but it's traded within a very narrow band. Q. Is there any evidence that the total use of audio was growing? A. No. Like I said, it's really stayed relatively stable. Over the course of time we've done the survey. Q. Is there a difference between measuring the amount of time looking at audio and looking at video in terms of how much it can grow? A. Well, we're not measuring video in our survey. But I think significant difference between audio and video is in video. I monitor a lot of the research there, and there's a phenomenon referred to as a second screen. Maybe some people here engage in this behavior. They'll have a big screen, TV perhaps, in front of them in their living room that they're watching, and at the same time, they might have their phone or a tablet or something that they're also, using in some fashion. Looking up information about what they're watching or just texting or whatever. So there are cases of sort of a second screen phenomenon, even people watching two different things. The football game here while they're watching a TV show there. So, there is sort of a cumulative world in video that really doesn't exist in audio. The human brain doesn't work that way. You can't listen to one thing in your left ear and one thing in your right ear simultaneously. So there's no real second screen phenomenon in audio. Q. Turn if you would to slide number 4, and this shows the current results of share of ear. A. Correct. Q. And can you just explain to the court what it shows? Generally, A. So, like I said, we total up all the listening that people do, and this is our estimate, our current estimate of listening by platform. So you can imagine this like a clock or what have you. How many minutes in an average hour are going to each of these types of audio? So starting on the left, the big blue, the biggest section, the blue section is listening to broadcast radio content, whether it's over the air or streaming. That's percent. A little over a third of all listening right now goes to the radio. And then if you go clockwise around the circle, you see our estimates for all the other different kinds of audio. So, streaming music, that's from the what we call the peer plays, Spotify, Pandora, Amazon Music, Apple Music, etc., is 18% of all listening. YouTube. And YouTube, we're looking at very specifically just listening to music or watching music videos on YouTube. It's a big factor. 14%, and then on from there, owned music, people's CDs or digital file, 7%, SiriusXM, 8%, podcasting is 10%, TV music channels, that's like Music Choice, is 3%, audiobooks, 3%, and then there's lots of little things that make up another 1%. Q. And have you been able to track over time whether the growth of one audio source has affected the strength of another audio source? A. Right. So, on the Q. This is A. Next page of our document. As I said, we've been doing the same survey the same way, using the same methodology, since we started, and we continuously roll the data forward, if you will, and you can see the changes over time. So year by year you see that listening to radio has declined. It was more than half of all listening when we started in Q, and just to speed things along, we're focusing mostly on podcasts here, as you've heard. A. Right. So you see that radio has declined and podcasting has grown dramatically. It was 2% when we started. It's grown 5-fold. It's now 10% of all audio consumption per our estimates. Q. Do you have an opinion as to whether this shows that podcasting has taken listeners away from radio? A. Yes, certainly. There's to me, really no doubt that podcasting has taken away from radio. It's not the only reason that AM, FM radio has dropped. As you can see, other things have grown as well, but it's certainly one of the reasons that AM, FM listening has dropped. Q. And turn, if you would, to looking back go back to slide 5. What percentage of growth has there been for podcasts over the past 9 years? A. So it's grown 5-fold, like I said. It was 2% of all listening and now it's 10% of all listening. So, let me do that in my head. That would be a 400% increase. Q. Okay. And has any other platform grown that much? A. In terms of percentage point change, YouTube has grown the same number of percentage points. But in terms of percentage growth, what I just calculated, no. As you can see, it's by far the biggest percentage growth of any platform. Q. Okay. Now, certainly if someone could listen to make sure we understand what the survey is showing, it is possible that someone could listen to more than 4 hours of audio a day, right? A. Many people do. As I said, that was the average. That's the middle made up of people listen more and people listen less. Q. But is there any indication that people are actually doing that, listening because they're listening to more podcasts? They're still listening to the radio at the same amount. A. I'm not sure I understand your question. Can you ask it again, please? Q. Is there any indication that, as the podcasts have grown, that it hasn't affected how many people listen to radio? A. On the contrary, there's evidence that as podcasting has grown, that listening to the radio has gone down. Q. Turn to slide 6, if you would, and can you describe to the court what this slide is showing? A. Yes. This is the same information that we were looking at on the previous couple of pages. It's just collecting together all sort of online audio sources from So It's Music Plus, podcasts from sort of the big players, Amazon, Apple, Spotify, Pandora, etc. And it's mainly collected this way to show that the combined total of these online companies and online services has surpassed the listening to radio. Q. Okay. So more people are listening to the audio online. Right. A. Yes. From these online audio sources than over the air radio. Q. Which, A. Or streamed radio. Q. Which would allow them to listen to podcasts. Right. A. Podcasts is part of that. Absolutely. Q. Is there a difference in the age? Let's turn to paragraph or slide 7. A. Yes. That would be a surprise to many people, but there's a significant difference if you look by age groups. Somewhat conveniently, the U.S. population right now is almost in equal thirds, 13 to 34-year-olds versus 35 to 54-year-olds versus plus. And if you just look at the comparison of radio to these online services, in total, as you saw, it surpassed percent to 46%. But you see the huge difference by age. So young people 13 to 34-year-olds overwhelmingly listening online. Interestingly, 35 to 44-year-olds are exactly the same as the total, the 46 to 54. And then 55 plus, again, probably not surprisingly, more legacy-type behaviors. Doing what, has existed for a long time. Some switching to online, but big majority to AM, FM radio. Q. And for the age group that we're talking about at the ticket, which was, I think, age 22 to 55, what is the majority of them listen to radio or online services? A. So I think they would say men 25 to 54. And for that group, it's definitely already made this majority is happening online as compared to radio. Q. So it's certainly easing them making the switch over from listening to the ticket to a podcast, correct? A. Well, certainly, yes. Q. Is there any distinction in your report for podcasting being behind a paywall? A. No. If someone's listening to a podcast and following the instructions of our survey, and we test them a lot, they would just put all of that under podcasting. We don't ask them to make such a distinction. Q. Okay. Do you have any reason to believe that something being behind a podcast behind a paywall would change the amount of time people would listen to it? A. No. Change how they access it, but it certainly wouldn't change how they'd listen to it. Q. Okay. Describe for the court what slide 8 is showing. A. Right. So we're asking lots of questions about what they listen to. Up till now I've been showing the platform, if you will, that they're listening to. We also say, what device are you listening to that audio on? And what you see here is the biggest chunk of listening is now on, essentially, the phone, mobile device. This would also include tablets, but it's overwhelmingly the phone at 37%. The AF/FM radio receiver, as distinguished from what I've shown before, is any listening to AM/FM radio, whether you're listening over the air or through the stream. But the receiver itself is 32%, and then you can go on around the circle as well to see the other devices that someone might be using: a computer, a Sirius XM satellite receiver as compared to a terrestrial radio receiver through their television, smart speaker. It's something like Music Choice to the audio channel, CD player, and other. Q. Okay. And, again, did you going to the next slide? Have you seen a trend on this over time? A. Yes. There's been a dramatic shift in the device that people use over the 9 or so years that we've been doing the survey. As you can see, and because of changes that we made in the survey, we date this one to 2015 where everything is exactly consistent. And as you can see, the radio receiver had well past double the amount of listening on the phone, and the phone has grown by quite a bit every year. And just last year surpassed the radio receiver for the first time and keeps sort of galloping forward, and now has a 5-point percentage margin on listening to a radio set or listening to over-the-air radio. Q. And from a practical point of view, one of the main differences on the phone, you can listen to a podcast or you can listen to streaming of a radio station, correct? A. Or many other things as well, but, yes, absolutely correct. Q. Versus only AM radio receiver where you couldn't listen to a podcast. A. AM/FM radio receiver, you can only listen to AM/FM radio. Q. And the trend shows that that's a shrinking area, correct? A. Correct. Q. Go to slide 10. Can you explain to the judge what is shown in slide 10? A. Yes. So every graph we've looked up till now is looking at function of time. How much time do you spend with these different platforms of audio? This is a percentage of people, not on this graph. So, this is what percentage of people who filled out this diary recorded at least some listening on their single day of recording to each of these platforms. So for instance, percent of all respondents say they listen to the radio at some point on their diary day, 39% to streaming music, and then a quarter to podcasts, and on down the list. Q. And, again, have you tracked this over time? A. Yes. Q. Is that shown on slide 11? A. Yes. Q. And what does slide 11 show us? A. It shows that the reach, or what I was talking about, the percentage of people say they listen each day for radio, and this will be total radio, including over the air and their streams, has gone down, as you can see, from just about 74% to just over 63% of people. Meanwhile, podcasts has really surged forward. When we first are tracking this data from 2015, it was 5.5% and has grown quite a lot, now over 24%. Q. So this indicates that the trend is that more people are listening to podcasts and less people are listening to the radio, correct? A. On a daily basis, yes. Q. And turn to slide number 12. And can you explain to the judge what this shows? A. Yes. So this is another one of the really big sort of megatrends that we've seen in our data, which is track putting together everything that would be considered a linear form of audio. In other words, kind of like any sort of legacy media, like television or radio, where you tune in and you just consume whatever happens to be there at that time versus on demand, which would be podcasts, to be sure, or, say, Spotify's premium service where you can say, I want to hear this song right now. Podcasts, I want to listen to this show right now, whatever it might be. You can see the convergence of these two lines. In 2015, it was a 38 percentage point gap between linear and on demand, and the gap is close and close and close. And then just for the first time in our most recent report, the two lines crossed, actually, and so now by a tiny margin, a majority of all listening is happening on demand as compared to linear. And I think I always hesitate to project into the future, but I think it's a very safe bet that these two lines will continue in this direction, and perhaps 7.5 years from now, you'd have a 38-point gap in the other direction. Q. So currently more people are listening to on-demand items, like podcasts, than are listening to live streams or live radio. A. Correct. Q. And that trend has been continuing since you started the survey. A. You can see the trend has been consistent. And like I said, I think it's likely to continue into the future. Q. Based on your survey results and the time you've done, you've heard the defendants say that they think because they were doing a podcast, they weren't taking listeners away from the radio station. Did you hear that testimony? A. Yes. Q. Does the survey results support that position? A. No. Like I said earlier, you can't listen to two things at the same time. So if someone's listening to a podcast, almost by definition they're not listening to the radio. And you can see from our data that listening to podcasts in general has taken time away from listening to the radio. We can also look at things more specifically in our survey. About among the things they tell us is, were you listening to music or were you listening to, essentially, spoken word content? And radio used to have an overwhelmingly dominant percentage of spoken word content, and that gap has closed very dramatically with podcasts taking that time. And we can look even more specifically at the spoken word content being news or what we call talk or personalities or sports. And in all three cases, podcast has grown dramatically, and radio has declined dramatically. Q. And there's no indication that people are listening to that or increasing their total audio listening time to listen to more podcasts. A. Correct. They're shifting their time. They're not increasing the amount of time. Mr. Pranini, pass the witness, Your Honor. The court, okay. Any questions? Mr. Cawley, yes, Your Honor. Cross-examination by Mr. Cawley. Q. Just so I understand exactly what opinion you're giving us, you're giving us the general opinion that from a time spent listening standpoint, because podcasts are becoming increasingly popular, and there's a finite amount of time people listen to audio, then therefore podcasts compete with radio. Is that a fair summarization of your opinions? A. Yes. Q. Okay. Strictly on a time basis, right. A. That's what we're measuring in our survey, is time. But we're also, like I said, measuring reach on those couple of graphs that you saw was true for that as well. Q. Okay. And it's very general. You're just taking all of broadcast radio, every format within broadcast radio as compared to podcasting, correct. A. You're speaking of format as in like a country station versus a rock station and things like that. Q. exactly. A. Yes. Q. Okay. So would you agree with me that there are certain formats within radio that are declining more rapidly than others? A. Again, I see some Nielsen data. We don't have that in our surveys. Q. Okay. A. But I've seen Nielsen data that shows, and it's been true by history of radio, at any given time some are going up, and some are going down. Q. So just so I understand, you're not comparing specifically podcasting versus sports radio, for example. A. Right. We win. Q. Okay. And you're specifically not comparing podcasting to the ticket. A. Correct. Q. Okay. So, for example, you're not saying that the dumb zone actually competes with the ticket, are you? A. I don't have specific data that speaks to that. I think it is clear from our data that all podcasting competes with all other forms of audio, so certainly in this case with radio. Q. Well, I mean, you don't break it down by category by format, i.e., sports versus top 40 versus country versus NPR type talk, is that correct? A. Correct. Q. And you don't break it down by market, Dallas-Fort Worth versus New York City versus Chicago versus LA, right? A. Correct. Q. And you don't know the history of the ticket and its ratings in the DFW market, do you? A. No. Q. So your very general opinion that podcasting is cutting into radio broadcast radio listenership may or may not apply specifically to the ticket in Dallas, Texas, correct? A. Correct. Q. All right, Mr. Cawley, no further questions. The court, I think you could have stipulated to the general. I mean, okay. Any further questions? Mr. Pernini, no, Your Honor. The court, any further witnesses? Mr. Pernini, no, Your Honor. The court, okay. You can step down. Mr. Pernini, can he be excused? The court, why don't you grab that notebook and hand it back to counsel? Mr. Pernini, can Mr. Rosen be excused? Mr. Cawley, yes, Your Honor. The court, okay. You may go. Thank you. The witness, thank you. The court, thank you. Let's go off the record. Off the record. The court, let's go on the record. Counsel, I changed my mind about something. Usually I don't really have that many evidentiary injunction hearings. It's pretty rare. I mean, maybe one every couple of years. But I have bench trials and I have jury trials, and usually my practice is if you don't talk about an exhibit through a witness, it's not going to be considered. Cause, on those bench trials sometimes I'll get exhibits, this high-end room's full of them, notebooks filled. And if you don't explain it to me, I'm not going to go through. But your exhibits are 2 manageable binders and some audio. And so I put you on a pretty strict time limit. So I will consider, and I have considered some. I have the notebooks, except for an update, for a while now. And there's no big surprises in there. Even though I believe I said they won't be considered unless a witness discusses it. It's a bench, it's a mini bench trial, as far as I'm concerned, and I'm sure nobody has an issue with that cause both sides didn't talk about all their exhibits. We good? Mr. Pernini, yes, Your Honor. The court, yes. Mr. Cawley, yes, Your Honor. The court, so for those that each side offered and was admitted, those will be part of the record. All right. Let's start with your full closing, and it's not going to be set up like it's a trial where there's rebuttal time. Just give me your best shot. You have up to minutes, but it's okay if you take less time. Okay, Mr. Anderson, thank you, Your Honor. Your Honor, it's been a long day, and based on the evidence put forth so far today, throughout this day with both the testimony of the witnesses and the documents presented to Your Honor, I believe the ticket has met its burden and established its right to a preliminary injunction. On that, I'd like to start with the claim on the breach of the covenant not to compete. The covenants not to compete at issue in this case are, we've established, both through the documented evidence, the contracts themselves, and in the testimony of Mr. Catlin and Mr. Bennett, that the covenants not to compete in Mr. Kemp's contract and Mr. McDowell's contract, they are ancillary to or part of an otherwise enforceable agreement. Here, they're employment agreements. The non-compete provisions, although slightly different between the two defendants, are substantially the same, and they both deal with have reasonable time, geographical area, and scope of activity to be restrained. Provisions within it. They're reasonable and, in fact, they're very narrowly tailored. We'll start with the time component. As Your Honor's aware, it's 6 months, as the documents show. And as the witnesses have established, both Mr. Bennett and Mr. Catlin, the 6-month window is a very reasonable time frame. It's very short in any non-compete case. That time provision, as Mr. Catlin testified, is necessary to let them get a replacement show up and going to give them time to solidify the relationship with their listeners so that when Mr. Kemp and Mr. McDowell come back to the market to compete, after the 6 months, that they will, the ticket will have had time to strengthen its relationship with the listeners before that competition takes place. So the time component, extremely reasonable at just 6 months. And in fact, it's even more an injunction here. Makes even more sense, Your Honor, because the 6 months won't even happen because the if you take when their final date of employment with the ticket is in mid-July, 6 months takes them to mid-January. This court will have conducted a full trial on the merits by then. So a preliminary injunction granted today would even give less than the 6-month time provided for in the employment agreements for the non-competes. The geographical area is also narrowly tailored, Your Honor. It's basically the Dallas-Fort Worth market area, surrounding counties. It's basically a 50-mile radius around Dallas-Fort Worth. Why? Well, that's the specific nature of that is because, as Mr. Bennett and Mr. Catlin testified, that is where the tickets listener base is. They're not trying to restrain defendants from other markets and globally or all throughout Texas. In fact, even under the non-competes as scripted, the defendants could go do whatever they want to in terms of Austin and Houston, other local markets or beyond, but just not Dallas-Fort Worth. Not in content that's accessible within the same Dallas-Fort Worth market area in the contract. So that provision, the geographical area, extremely narrowly tailored and reasonable. And just to add on to that, we heard testimony today from Mr. Catlin about the possibility of geofencing and how they could not even have to move to another town. They could create their podcast here and in their homes in Dallas and have it broadcast in other markets and, with geofencing, have it restricted to where it's not accessible within the Dallas-Fort Worth area. Again, for the 6-month period. These restrictions, Your Honor, are no more than what's necessary to protect the goodwill and the business interest of the ticket. You heard that from both Mr. Catlin and from Mr. Bennett today. The contracts themselves are the best evidence of the reasonableness of the provisions and the testimony of Mr. Catlin and Mr. Bennett. So the provisions themselves are reasonable. Now, I want to talk about the fact that the defendants are in violation of those provisions. You heard a lot of testimony today, Your Honor, about whether or not podcasts compete with radio. You heard from Mr. Catlin the fact that the station is losing listeners. We saw emails from angry listeners that they are leaving the ticket to go to the defendant's competing podcast. So we know it's happening. Do we know the full measure? No, nor can we, right now, but we know it is happening. So we know the podcasts are competing with the ticket. We know that the defendant's podcasts are competing with the ticket. Not only do you have the expert saying podcasts, Mr. Rosen saying podcasts are competing with radio, but you have the best evidence at all, the listeners themselves. The listeners from the Hang Zone emailing the station and saying, "Hey, ticket, we're leaving you to go follow Mr. Kemp and Mr. McDowell wherever they go, even if we have to pay a subscription fee." That's an important piece, because we've heard from defendants today that, well, we can't be competing because we have a fee subscription-based podcast behind a paywall. That doesn't matter. That's irrelevant because the customers are going to go there regardless of whether or not they have to pay. So that's more of a red herring what we've heard today. It's not just that they're doing a podcast, but, as we heard from the testimony from Mr. Catlin today, and just hearing some of the clips from the podcast of the Dumb Zone itself, it's the same show. It's the Hang Zone, but just called the Dumb Zone. The only difference is they don't have a production crew supporting them now like they did at the ticket. But you heard from Mr. McDowell and Mr. Kemp and the recordings from the audio recordings from the Dumb Zone that they're just trying to take that show and keep it going. They want the same listener base. They're targeting the same listener base. They've changed the Hang Zone website to you know, from Hang Zone to Dumb Zone. The Twitter feeds, and the all social media apps to just changing the names so they can keep the same subscribers, the same listeners that they had when they were at the ticket. They are competing, and all the evidence today from Mr. Bennett and from Mr. Catlin, from the audio recordings of the defendants themselves, the emails from the customers, all of this point to one thing: this podcast, the Dumb Zone, is directly competing with the ticket. And another significant point today, Your Honor, is that the defendants were doing podcasts while they were at the ticket. Part of that in terms of the non-compete provisions, they are engaged in activities that are the same or substantially similar as the activities they did in connection with their jobs at the ticket. How do we know that? Because the contracts themselves, there's been some testimony today from the defendants. Okay, well, maybe Mr. McDowell's doesn't say podcast in the description of what a commercial radio station is, but the fact that it doesn't include the word podcast in the description of commercial radio station is of no import, really. You heard the testimony from folks that run radio stations that know who know best about what a commercial radio station is. Dan Bennett, Jeff Catlin, and on and in their testimony, Your Honor, they testified that a commercial radio station is not just terrestrial radio, as defendants would have you believe. It's much more. It's podcasts. And this is for the past decade. It's podcasts. It's streaming. It's promotional shows. It's events. It is commercial. It is terrestrial radio as well, but it's so much more. And that was the case at the time Mr. McDowell entered his contract, certainly the case at the time Mr. Kemp entered his contract. And when you look at the description of their job duties in Section 1.5 of the employment agreements, for both Mr. McDowell and for Mr. Kemp, you see that podcasts are a part of their job duties and other content that the station requires them to do. And as we heard Mr. Catlin say in his testimony, that was one of the things he required of both Mr. McDowell and Mr. Kemp as part of their job duties was help with the creation of podcasts. So it was so them doing a podcast now is the same or substantially similar to the activities they did as part of their job duties for the ticket. So they're in direct violation of the non-compete provisions of their employment agreement. And they didn't wait 6 months before they did this, they did it immediately. So their employment ended in mid-July, and within a week or so, they had their first podcast released. Their podcast is accessible to listeners within the DFW market. In fact, it's geared towards them, as reflected in evidence by the emails from the angry listeners we've seen today, and those are just some. Those listeners are willing to leave the ticket to go listen to defendants' podcast even if it means paying a fee. I think, Your Honor, based on all that, we have established a likelihood of success on the merits for our claim for breach of the restrictive covenant or breach of the non-compete of their employment agreements. And Mr. Pernini will get up in a few minutes and explain to Your Honor the likelihood of success and the merits for the claim for conversion and disparagement. I'd like to, last, address the irreparable harm piece. There were a lot of testimony on that today from Mr. Bennett and from Mr. Catlin, Your Honor, that the damage is being done to their reputation and their goodwill of the station. There's no way to put a price on that. What we've seen is this. You heard Mr. Bennett testify that ratings have dropped in the past 3 months since defendants have left the ticket to start this competing podcast. We've seen revenues go down, ratings go down, and we've seen emails and evidence from angry listeners saying we're leaving to go to the defendants' competing podcast. So there's damage to the relationship with the listeners and there's damage to the reputation and goodwill of the business. And you heard both Mr. Bennett and Mr. Catlin testify that there's no way that they know of that they can sit here and quantify the full measure of damages in terms of dollars and cents to compensate them for the harm being caused by the defendants. It's irreparable. It's happening and it's happening now and it's been ongoing, and we're asking the court for an injunction to prevent the defendants from continuing their podcast for a period through trial, and for them to not be able to put up a podcast, whether it's behind a wall or anything else, any podcast or audio content that was the same or similar to what they did for the ticket that is accessible within the DFW market. They should not be able to do now through trial, Your Honor. Here, Your Honor, I'll pass to Mr. Pernini. The court, okay. Thank you, Mr. Pernini. Thank you, Your Honor. I'd like to address 2 separate areas. First, the conversion claim regarding their use of the hang zones, social media, and the website in order to lead people to the dumb zone. And, Your Honor, it's very clear the hang zone was clearly the name of the show developed at the ticket. Section 15.1 of their agreement says that intellectual property developed while they're at the ticket remains the property of Susquehanna. The only argument they really made in this regard, first of all, the evidence shows that so we have the hangzone.com. As soon as they left, they changed it so that anybody who went to the hangzone.com will be transferred over to the dumbzone.com. They did the same thing with the social media account. So when it says the Twitter account for the hangzone, those people will be sent to the dumbzone. Again, this is all part of, as Mr. Anderson talked about, them trying to get the same audience pulled over to the dumbzone. Their main argument they've made in their briefing, Your Honor, is, well, that's intangible property. But, Your Honor, the case law is very clear that when you take intangible property, you tie it into a website or you tie it into a social media account, that becomes subject to property, subject to conversion under Texas law. There are 2 cases I'd cite to Your Honor that we have cited in the papers. The Domain Protection v. C. WASP case is probably directly on point. That's 426F. Sup. 3D. 355. They say the same argument. They said that intangible property is not convertible, but when it was merged into a website, like when it's merged into a document, it becomes convertible. Similarly, Your Honor, the McGuire-Sobrino case, which is 2020 WL 458-1649, involves the same thing, doing a change to a website and to social media accounts. The evidence is really undisputed that that's exactly what they did. They took these websites, they took these social media accounts. As soon as they left, they said, if you wanted to go to the hang zone and find out about the ticket, we're not letting you go there anymore. We want you to go to our show to develop our audience. And the evidence has clearly shown that we've done that, and they're continuing to do that. And there's no way to track how many people go or how many people have been fell through for that. So there's no way to determine what damages could be caused by that other than those people are being lost in the way that is uncalculable. Sick. I'd like to switch also, Your Honor, to the disparagement claim. Now, Your Honor made out the point that you did not feel that Mr. Kemp was by his testimony was meaning to hurt the ticket. And, Your Honor, I appreciate the court's view on that, and, obviously, you're the fact finder, but I would make 2 points. First of all, the agreement itself does say that, as it reads, it says any public statement that is in case intended to or can be reasonably expected to. So intent is certainly an object, but it's not required. So if, in fact, what he does is reasonably expected to disparage the ticket, then that would meet the category. And, Your Honor, to this point I would say that Mr. Kemp's actions speak louder than his words on the stand today. If he really didn't want to harm the ticket, there's a simple answer. Just don't talk about the ticket. But they wanted to talk about the ticket, and that's what the evidence has really shown. Today, they didn't just start a competing podcast. You heard that Mr. McDowell say on the podcast, we're going to talk about the ticket every single time. We really want to talk about the ticket. They brought in guests to talk about the ticket. When those guests misspoke or materially misstated what was happening at the ticket, they didn't correct them, they didn't edit it out. They still played it. Mr. Kemp himself said he was looking forward to bagging on the company once he's told it's okay. Now, on the stand today, he said, well, I was kind of joking. But you heard the language. It didn't sound like he was joking. It doesn't seem like a joke. So they have disparaged us. They have indicated they want to continue to disparage us. So we have a likelihood of success on the merits on that claim against Mr. Kemp. I think similarly, Your Honor, it's impossible to determine the amount of damages that would be calculable to that. It goes to our reputation. They're calling us cheap. They're calling us treating our people bad. How does that affect our goodwill with our people? How does that affect our reputation in the community? That's something that cannot be developed and shown. And with that, Your Honor, one of the other things that Texas law allows you to look for irreparable harm is, are they taking off the common celebrity of the parties? And that's exactly what has happened here. The reason that people know about Dan Kemp and Dan McDowell and Jacob Kemp is because they're on the ticket. So the ticket gave them a platform, and they used that platform, the ticket, and them together to grow the show and to get celebrity. Now, they went to go someplace else. That's fine. But we are not what the law say is we can say you can go someplace else, but we have a chance to get our celebrity back. We have a chance to basically build up the show. And that's all we're asking for, is 6 months to see will our new show work, and then they can come in with the celebrity that they earned while on the ticket and see if they can compete with us. If they can, good on them. They've done their job. What the law does allow us to do is provide some protection as we build up these people together and build their fame and build their goodwill. But they cannot then just leave and use that goodwill against us. And that's what has happened. Here, they have presented this case originally as these poor guys that being attacked by the big company. But the evidence has shown is, they're very well compensated individuals, represented by counsel at the time that they reached this agreement. They knew what they were agreeing to. When they left, they took the show that they were doing and went and did it on a podcast, the same show. And, while they did it, they decided to go ahead and attack the ticket. And while they said we wanted to be behind a paywall, in fact, the evidence has shown that they weren't behind a paywall. They did at least one show a week not behind a paywall, and they want to do more shows not behind a paywall. So, Your Honor, it's taken us a long time to get here. But the evidence, I think, is undisputed that what has happened in this case is they're taking a show that they did on the ticket, doing it on the podcast, and listeners are leaving the ticket to go there. That is exactly what the non-compete law in Texas is created to prevent. So we would ask the court for the reasonable relief of having a preliminary injunction to prevent them from doing that, so we can go to trial on this and get a permanent injunction if necessary. But in that meantime, if we don't have further damages cause, it will never be redressable. The court, okay. Mr. Pernini, thank you, Your Honor. The court, thank you very much. Closing on behalf of the defendants. Mr. Cawley, yes, Your Honor. Susquehanna just doesn't want competition. That's what this case boils down to, Your Honor. They think a non-compete is designed to protect them from competition. That's not the purpose of the non-compete. The non-compete is an exception to the general rule that any agreement in restraining a trade is illegal. It's an exception. The Non-Compete Act is. And the Non-Compete Act is not designed to protect a competitor from competition. It's designed to protect competitors from grossly unfair competition. And here, we have a situation where we've got two different contracts. And what Susquehanna's doing is, they're attempting to use an overly broad, unreasonable, and vague contract as a cudgel to keep these guys from working anywhere in the audio-video communications industry. I say audio and video because in Jake's contract, it says that he's not allowed to work in television. So while we've been talking about the audio industry in this trial today, they don't even recognize that they snuck in television into Jake's contract. So Jake can't work anywhere in the audio-video communications industry at all. What's even more pernicious is the use again. The Non-Compete Act is designed to be an exception to the general rule that you can't limit somebody's employability. Then the statute lays out certain parameters that there's got to be reasonable limitations in time, in scope, and geography. And it's got to be narrowly tailored as much as possible. What they've done is they've got vague and ambiguous terms in this contract that they used to increase the scope of the non-compete. For example, Dan's contract simply says that the company's business is operating a commercial radio station. But now they say commercial radio station doesn't mean commercial radio station because the industry has changed, you see. And so commercial radio station now means everything that goes along with that, including streaming and podcasting. So the point there is, how is a person who signs that agreement supposed to know how it's going to evolve over time if the industry changes? Well, that's not what these agreements are designed to do. They're supposed to be definite. They're supposed to apprise the employee of exactly what they're giving up post-employment. And what they want to do is say that in radio commercial radio station now means a podcasting business. Or really anything that competes for the time of the listener. Audiobook business. I mean, according to their expert, time spent listening to any form of audio programming competes with broadcast radio. So if Dan and Jake wanted to go and start reading audiobooks for blind people, under their rationale, that would be prohibited because time spent by people listening to an audiobook cuts into the time they have available to listen to the ticket. That's not what the Non-Compete Act is designed to do. We were talking. Mr. Catlin on the stand said that creating original content podcasts is part of the job responsibility of an on-air host at the ticket. Well, the Non-Compete Act says that the employee will be prohibited from engaging in activities the same or essentially the same as the employee's job duties. I'll go ahead and pull this up. Job duties is capitalized, meaning it's a defined term. So the job duties as defined in this contract create the contours, the outer limits of what can be subject to the non-compete agreement. And let's look at what job duties means. And I'm going to pull this up. Hopefully, it's kind of hard to read, but in the job duties I've got them side by side, Dan McDowell's and Jake Kemp's. The only difference between the job duties in Dan's contract in 2018 in Jake's contract in 2020 is the stations. They added the FM frequency to the stations, KTCK and FM and AM stations on, and so forth. There's no substantive difference between the job responsibilities, the job duties of Dan McDowell and the job duties of Jake Kemp. The only mention of podcast in the job duties definition is that they are supposed to cooperate with the company to create podcast of their on-air show. They're not required to podcast at all. They're not required to do anything except for cooperate in the snipping of their on-air stuff and putting it on the ticket's website. There's nothing in here about creating original content. Sure, Jake did some original content by agreement with his employer. He did it as a good soldier and a good employee. But the fact that he voluntarily did something he was not required to do under the terms of his contract doesn't mean that the station gets to then prevent him from working in the area that he volunteered to do. The analogy I draw to that Your Honor, is if Dan and Jake had agreed to, as an accommodation, to go pick up guests from the airport to bring to the radio station to do an interview, could then the ticket then preclude them from driving for Uber at the termination of their employment because they did that? No, of course they couldn't. Same here. The fact that Dan and Jake Dan never did any original content podcasting, but the fact that Jake agreed to do it at the request of Mr. Catlin doesn't mean that all of a sudden now podcasting is part of his responsibilities. It never was. It's not in the definition of job duties under the contract. Now, here's a side-by-side comparison of competing business. And in one of the things I want to point out also, Your Honor, is Mr. Anderson said that the provisions in the contracts were slightly different. They aren't slightly different. The Dan McDowell contract defines a competing business merely as any person, including employee or entity, carrying along a business that is the same or essentially the same as company business. And that's commercial radio station in Dan's contract. I will point out that I believe that the or essentially the same facially invalidates this provision. Because what they're saying there is you can't work in the same business, same industry as the ticket, or a different one, but they're essentially the same. They're two different things. And so they're saying not only can you not work in our business, but in a different business if we determine that it's essentially the same business. That's, number one, overbroad. And number two, it's wholly indefinite. It doesn't apprise an employee about what business they can or can't work in. It's up to them at the time that they decide they want to file for injunctive relief whether they believe that the offending business is essentially the same. But what's more important here, Your Honor, is you see Jake Kemp's competing business. Now it is. It has in the 2-year period between the signing of these two contracts, it has expanded to include, without limitation, so this isn't all-inclusive list. All commercial audio outlets such as radio stations, radio networks, television stations, cable operators, podcasters, internet/streamed audio and internet/streamed programs, programming, and other current and future audio platforms. Now, remember that it's the scope of the job duties of the employee that creates the outer limits of what they can be precluded from doing post-employment with the ticket. So in order to expand the definition of a competing business the way that you see here, it would stand to reason that the job duties must have changed, because it's the job duties definition that tells us what competing business is being targeted here. But as we saw just a minute ago, the job duties didn't change. They remained the exact same. Radio hosts, but somehow over time, all of a sudden there's all these other industries and businesses that Mr. Kemp cannot be involved in. So my point there is, number one, Mr. McDowell did not breach any contract. There is nothing in his contract that prohibits him from working in the podcast space. Nothing. The non-compete does not address podcasting, period, end of story, with respect to Mr. McDowell. The analysis is a little bit different with respect to Mr. Kemp. Mr. Kemp, they've got this gigantic litany of businesses he can't work in. So technically, according to the literal words in his contract, he's not supposed to go work on a podcast. But that's why the Texas Non-Compete Act requires judges to look past the wording in the contract and to look at the reality of the situation to determine whether the non-compete scope and time and geography are reasonable. And in this case, it's clearly not. Like I said, in the job duties definition, there's no difference from when Mr. McDowell started as a host and when Mr. Kemp started as a host. The only difference is the words they put in the contract to prevent competition. That's the only difference. They did. Dan McDowell and Jake Kemp did the exact same thing day after day, but somehow a bunch of words got put in Mr. Kemp's contract that precludes him from making a living. The words in the contract don't matter. It's the reality of the situation that matters. And under the job duties definition, it's exactly the same. There is no justification for the wildly expansive application of company of competing business in Mr. Kemp's contract, as opposed to Mr. McDowell's contract. So Dan didn't breach the contract at all. Jake's contract is wildly overbroad in scope, and it's vague and ambiguous with respect to, or essentially, the same business. I thought this was particularly instructive, Your Honor, Exhibit 3 that Mr. Kingston addressed with Mr. McDowell. In that talking about that very same topic, the definition of competing business. This is Mr. McDowell's proposed contract here in his latest round of negotiations, and we know that first sentence was the only thing that was in it in the past, and the plaintiff is wanting to include that long list of things that they put into Jake's contract. Mr. Kingston is negotiating a deal and he takes it out, and the lawyer, Olga, and I'm not going to try to pronounce her last name, either the lawyer for Cumulus or the ticket group, says, no, the language should stay. Competing businesses to Cumulus are no longer limited to just terrestrial radio. And then the last sentence is, Cumulus will not agree to limit competing business definition to terrestrial radio. Right there, their lawyers saying the definition as it existed under Dan's contract in 2018 applies only to terrestrial radio, and so the attempts by Susquehanna to somehow expand the application of the non-compete agreement outside of terrestrial radio into podcasts under the auspices of the radio station commercial radio station, the definition has changed. Because the industry has changed, that's a courtroom contrivance. In negotiations they understand that Dan's contract only applies to terrestrial radio. Only when they come into the courthouse do they change that argument. I want to address there are 3 claims, as I understand it, that are subject to the hearing today. It's the breach of the non-compete agreement. It's non-disparagement by the court. I'm going to tell you, though, you only got about 10 minutes. Mr. Cawley, okay. The court, actually, less. Mr. Cawley, I will hurry it along, Your Honor. The court, all right. Mr. Cawley, irreparable harm. They wholly fail to satisfy their burden on irreparable harm. They have to establish that the damages are not hard to measure, not difficult to measure, immeasurable. And if the damages are not immeasurable, they have to prove that they're in danger of financial ruin. There hasn't been any evidence of that. In fact, what's different about this case, Your Honor, and in why sometimes I was pulling my hair out doing a research on other cases is because there's something in this case that doesn't exist in most industries. Ratings. These guys know exactly how they're doing. They know exactly when their business is dipping. They see it on these ratings. They've got Nielsen ratings to look at every single month. And I think they even get them on a weekly basis in some circumstances. And they closely monitor that. All this stuff about, we just can't figure out how we've been harmed by the fact that these guys are operating a podcast is just litigation contrivance. They know exactly where they are in ratings, and they know exactly how much money they make. You heard Mr. Bennett get up here and talk about 2% down in August, 4%, or in July, 4% down in August. They know how to crunch these numbers. They know how to figure out what's going on. I think the real issue is they can't pin that on Dan and Jake. That's what I got Mr. Catlin to admit on the stand. When he was going through all those emails, the listeners are mad. See, this is all this irreparable harm. These listeners are mad at us. But he couldn't say that they were mad at what Jake and Dan did. He admitted that they could be mad at what Cumulus did. Filing a lawsuit was wildly unpopular. They put in, like they said, they just put in a smattering of the tweets and the Reddit posts. If you wanted to go down a rabbit trail and jump on Reddit, you could see tons of posts of people just angry that this big company is attempting to use a non-compete as a cudgel to prevent Mr. Kemp and Mr. McDowell from operating a little podcast behind a Patreon paywall. That's got people really upset. And I think Mr. Catlin admitted that on the stand. I think he was candid in that. The point is, they haven't shown that the harm is immeasurable. We don't have it in the exhibit, but in their brief yesterday, that they filed yesterday, they linked to a K, and I went and looked at that 10K, and I don't know a whole lot about accounting stuff, so I'm not going to purport to know exactly what it means. But in that 10K, they measured the value of the goodwill of Cumulus Media, Inc. There's a section in there that talks about the value of the goodwill of the company. They've got accountants out there crunching the numbers to figure that stuff out. Now, maybe it's done with accounting tricks, I don't know. But that's what they have in their 10K. Now, that's Cumulus Media Incorporated, the big overseer of all the Cumulus Susquehanna Nation. But somehow, someway, they were able to calculate goodwill. In any event, they haven't established irreparable harm because they have the standard. For a TRO is clearly showing all 4 elements: success on the merits, irreparable harm, the balance of injury between the parties, which is usually a wash, and the whether an injunction will be a disservice to the public. They haven't done that with respect to irreparable harm. They haven't met that high burden of clearly establishing not just, hey, it looks like we've established it, clearly establishing it. And so let me quickly move on to the other claims. Disparagement. Again, they have to clearly show that only Jake caused Dan doesn't have a non-disparagement clause in his contract. Only Jake intended to damage or harm the company, or reasonably expected to damage or harm the company. You saw Mr. Kemp's testimony. He was about as forthright and credible as you could be. He loves those people. Those are his buddies that are still at that station. He doesn't want to vicariously hurt them because of what the company's doing to him. He didn't ever intend or expect to disparage the ticket. The conversion claim. They own the website. This is another place where they just rely on an overbroad, vague, and ambiguous terms of their contract. They fit it in some, they fit in ownership of the website that previously belonged to Mr. McDowell and social media accounts that previously belonged to Mr. McDowell and say, well, because you used them for work purposes now we own them. There's no justification for that in their contract. But beyond that, I didn't hear Mr. Pernini say one word about the irreparable harm that allegedly stemmed from the conversion. Not one word. I didn't hear one piece of evidence from the stand or in the documents that there was any irreparable harm because they can't use the Hang Zone website. They don't even have a show called the Hang Zone anymore. Why do they need a website? Why do they need a Hang Zone Twitter account? The court, you got 4 minutes. Mr. Colley, okay. So they haven't even attempted to establish irreparable harm on the conversion, and I'll give you back 3. The court, okay. Thank you, Mr. Colley, thank you, Your Honor. The court, while I have you up, though, Mr. Colley, sure. The court, counsel. I'm looking back at the agreed temporary order restraining defendants and continuing preliminary hearing that you all prepared. I marked up just a little bit on the first page and signed on August 21, 2023. I think I learned that you subsequently agree to extend that date in view of the long-going the mediation continuing. There are 3 paragraphs that the defendants agreed that they would stop. What I want to focus on right now is if any of these 3 paragraphs are items that these are only, I think, going to extend to today, right? And going backwards, defendants cease commenting on or publishing any social media posts or public posts concerning this litigation, the ticket, the plaintiff, or any employee or affiliate of the plaintiff. Then there were some on paragraph 2 on going backwards already posted. Defendants aren't required to remove them but will not promote or otherwise discuss. And then the first one is, immediately cease uploading any podcast audio available or any other platform. Any of these at this time, before I rule, defendants are willing to agree into. Mr. Colley, I would like Ms. Griffin to address this issue. The court, sure. Mr. Colley, if you don't mind. The court, I was hoping Ms. Griffin will say something today. Let's go. What's your agreement, if any? Ms. Griffin, I wanted to address the first piece, which is 2. The court, honestly, I just want to know if there's agreement on 1, 2, or 3. It's 6 o'clock. I'm ready to rule, but I want to know if there's any agreement. Ms. Griffin, okay. They do want to be able to podcast. The court, okay. So that takes out number 1. Ms. Griffin, and the issue about not mentioning the ticket, the lawsuit, or any employee, I know that was part of I don't want to say what was part of the mediation agreement, but you can tell in the podcast they published since. The court, you're not answering my question. Okay, let me read it to you. Defendants will cease commenting and publishing any social media posts or other public posts concerning this litigation, the ticket, the plaintiff, and any other employee or affiliate of the plaintiff. So, in other words, is the defendants, Mr. Kemp and Mr. McDowell, and their lawyers agree to refrain from talking about this litigation publicly. Ms. Griffin, yes. The court, okay. That's it. You want to continue. You want to be able to podcast. Ms. Griffin, yes. And the court, okay. And what else? Ms. Griffin, sorry. The court, I don't really care about the reasons. I just want to know what the agreement is. Ms. Griffin, yes. The only issue with that second piece I think is just the being able to mention the ticket or employees since they are still friends with them. The court, sure. Ms. Griffin, it's really hard to not mention any. The court, that's why I limited I think it's kind of broad here. And I have free speech concerns, quite frankly. But are you agreeing not to talk about the litigation? What's going on in the litigation? Ms. Griffin, yes. The court, Mr. Kemp. Defendant Kemp, yes, Your Honor. The court, Mr. McDowell. Defendant McDowell, yes, Your Honor. The court, will you tell your lawyers not to talk about it? Defendant McDowell, yes, we will, Your Honor. The court, okay. Thank you. And then with the rest of it, not agreeing to today, correct. Ms. Griffin, yes. The court, all right. And I'm assuming you won't oppose them agreeing not to talk about litigation. It goes 2 ways. It's you too, Mr. Pernini, yes, Your Honor. The court, that's the only agreement we have. Mr. Pernini, that's correct, Your Honor. The court, now, I'm ready to rule. I'm just telling you, talking about this litigation, there's no upside for either party, but I'm not going to impose that on you. But you all agreed to it of your own free will. Your company people are here and I asked Mr. McDowell and Mr. Kemp, who can speak for the company here? Mr. Pernini, Mr. Bennett. The court, you agree with that? Mr. Bennett, yes, Your Honor. The court, okay. You can talk about I guess it might come up in conversation that you know about Dumb Zone or Mr. Kemp or Mr. McDowell, but we're not talking about the litigation. Don't get into the gray area to get me all annoyed. But right now we're not going to talk about litigation, like somebody did earlier. Okay. All right, I'm ready to rule. Under Fifth Circuit law, as recently as this, last month and a couple of months ago, it's real clear just. Some of the cases is Mock v. Garland, that was a Fifth Circuit, August 1st, 2023. Direct Biologics v. McQueen, that was just a couple of months ago, too, April 3rd, 2023. And, of course, there's the Planned Parenthood Association case, Fifth Circuit, in 2012. But up until, I guess, last month, it's been real clear what the standard is for this court in awarding or granting preliminary injunctions. And it is as follows. A preliminary injunction is an extraordinary remedy. Emphasize extraordinary remedy which should not emphasize the word not be granted unless the party seeking it has clearly, I'm emphasizing the word clearly, carried the burden of persuasion on all four requirements. That's straight out of Fifth Circuit law. Again, a preliminary injunction is an extraordinary and drastic remedy. That's straight from the Direct Biologics case, Fifth Circuit, a few months ago. The four elements are substantial likelihood. The movement will prevail on the merits. Substantial likelihood. That's a big burden that the movement will prevail on the merits. Number 2, a substantial threat that irreparable harm will result if the injunction is not granted or likely to suffer irreparable harm in the absence of preliminary relief. And as part of irreparable harm, there is law from the Fifth Circuit that says in general, a harm is irreparable when there is no adequate remedy at law, such as monetary damages. That's straight from the words of the Fifth Circuit in Jan v. Alguire case in 2011. That's long-standing, and it's also the law from the state of Texas as well. Third, threatened injury to the movement outweighs the threatened injury to the defendant. In other words, that the balance of equities tipped in the favor of the movement and the granting of preliminary injunction will not disserve the public interest, so the court denies the application for preliminary injunction. The court finds that on one or more elements that are required in all four elements are required, that the movement has to clearly carry the burden of persuasion on all four requirements. This is not an or, this is not a one out of four, this is an and. I submit there has been a failure to clearly carry the burden of persuasion to me on probably all of the elements. Let's start with the fourth one, the granting of the preliminary injunction will not disserve the public interest. There's been no discussion. There's been no argument. There's no evidence at all that discusses in, other than a very conclusory form to date, and there have been no discussion on it during this evidentiary hearing on that topic. Because the burden is on the movement, which is the plaintiff, fails completely that I heard no evidence on that one. On 3, threatened injury to the movement outweighs the threatened harm for the defendant. Again, I really haven't heard much, and I gave both sides the ability to talk about all four elements, but really, neither side even talked about it. Then and with respect to 3 and 4, of course I'm going to issue more particularized findings as required by law in the next couple of weeks, but I've got some matters ahead of you. But I thought it would be helpful to all the parties to understand where the court is. This is an order that I'm denying your temporary injunction, but I will give particularized ruling. I'll give you particularized findings soon. I have real concerns about free speech on item number 3 and 4. And if I have concerns, I'm not saying the defendants win on this, and I'm not saying the plaintiff loses on this, but the burden's on the plaintiff and the parties seeking to clearly carry the burden of persuasion. And I'm not persuaded. I didn't hear any argument, any persuasion on item number 3, especially when we're talking about free speech. Nobody really went into the balancing test either. Threatened injury to the movement. I'm hearing potential damage to reputation, potential damage to revenues, and that outweighs the threatened harm to the defendants, which is to pursue a livelihood, free speech. I thought many times today I don't really understand why a couple guys can't joke about things when it's clearly a joke. But, that's for the jury or the trier of fact to go into. I'm not saying these are bad points, but you have the burden and you have to carry the burden clearly on all four requirements. Let's go into the second one. Substantial threat that irreparable harm will result if the injunction is not granted. There are so many findings I can make on this. The plaintiff put forth emails from listeners, purporting to show that the Dumb Zone and the alleged disparaging comments recorded on the Dumb Zone caused plaintiff to lose listeners and listener goodwill. However, most of the emails were sent before defendants released the first episode of their podcast. The rest were sent after the filing of the lawsuit. specifically citing the plaintiff's filing of the lawsuit is the reason for the listener's anger, not the defendant's conduct. Much of the rest of the testimony and evidence was conclusory and contradictory on this. I heard no evidence that what was the plaintiff, the ticket, Susquehanna's reputation, what was your goodwill? And how can you say goodwill is your losing goodwill if you don't even put forth what it was before? There was only one witness that came forward and it was put on by the defendants. Nobody came up here on the stand. I was expecting maybe one or two saying, yeah, I moved because I listened to their podcast and I moved because I liked it better. I mean, just something, but there was none. Zero. And irreparable harm. I disagree with the plaintiff. I think instead of spending the time and money to have somebody tell what's obvious, which is that podcasts are moving in on the media market, there's nothing in the expert's testimony with respect to this case or these defendants' actions. Yes, I think there was no attempt by the plaintiff. Probably if there was, they didn't tell the court about it, but I have so many notes here from what I listened to all day. Well, there's no reliable evidence that I heard today or I read of what the goodwill was and how it's being reduced. I did hear evidence of the business interest of the ticket and how percentages are going down. I even heard a number of $157,000, which tells me it's answerable in damages, but not one witness came in, an accountant, somebody to crunch the numbers and say this is how things went down. There's been nobody to come in to persuasively argue to the court that the dip in revenues and the dip in ratings had to do with what the defendants did versus them not getting rehired. In fact, the only witness that came in today, Mr. Romo, said he was upset they weren't rehired, and that's why he very methodically told the court he didn't want to be paying more during the same time period where organically someone couldn't talk about why they should go to his business. Somebody who already eats there. To me, that doesn't really have much to do with the podcast. So, again, you fail to meet that on number 2. And 1, substantial likelihood the movement will prevail on the merits. I think it's a toss-up. I think the defendant, one or more, can lose on this, but they can also win, which is why you should have settled this case, because it's a toss-up. And I don't know, but you didn't. I find that I cannot decide here today that there's a substantial likelihood that the movement will prevail on the merits because there's too many factual disputes. There's too many disputes. I'll just give you one example. In Mr. Kemp's contract, it talks about the intent to damage. That's subjective. That's a fact issue. I can't state today that there will be a substantial likelihood of success on the merits on that. Then on the same anti-disparagement paragraph, and I'm doing it straight from memory, so I may have the words garbled a little bit. It talks about reasonably to expect. All right, that's something that either the court decides, but I can't decide it today, that there was disparagement, so I don't even think I have. I know I talked to you all about this when we were in my jury room, that I had concerns that the contract was overbroad with respect to, especially, Mr. Kemp, and we talked that the Texas law requires me to reform the contract. I don't even think I have to get there because you haven't reached the other 3 elements and number 1, so more particularized findings will follow. Let me just make sure that I made my points. I don't find a handful of emails pushes the needle to support damaged reputation or goodwill or ties it to what it needs to be tied, which is, I believe, the podcast. They could be tied to the fact that they didn't get re-upped. It could be tied to the lawsuit being filed, which your people are entitled to file lawsuits, and people are entitled to file good lawsuits, and people can file bad lawsuits. I'm not making a comment about that. Like I said, the merits, it's a toss-up, but what I do know is there was testimony, undisputed, that the ticket joked about it being cheap. Okay, so your reputation before was, tongue-in-cheek, you're cheap, and now someone says you're cheap. People can say the same thing about me. I like a good deal. I buy things on sale. So, I don't know. But there's a heavy burden when you come in wanting injunctive relief. Again, I mentioned not one witness said they moved over in sworn testimony. I see that there's emails, but as far as I'm concerned it's hearsay right now that you received it. But there's not one witness said that they moved over because of wrongful conduct. And I can keep going, but that gives you a snapshot. I don't want the defendants to think that this is the end of the road. This is I'm not going to enter an injunction. You've agreed not to talk about each other, which I think just harms it each other even more. But I do think trial is a toss-up, so we'll see what happens, whether there's a lot more evidence that will come in. I don't know if it's going to be before me or if it's going to be a jury trial. Oh, one thing I do want to tell the defendants is I think I have jurisdiction, but I haven't done a thorough job on it. If you want to decide now that I don't have jurisdiction, maybe you ought to talk to your clients. Okay, and I don't think irrespective I've got to find a responsive briefing, but I don't think the NLRB is going to come until there's something called separation of powers. I don't think the NLRB is going to, tell this court to cease and desist. So I'm not going to go to their area, and I don't think they're going to come to my area, but we'll see. I just don't think the Fifth Circuit will expand the NLRB's powers, I will tell you that. But, again, I got a lot of research to do on that. What I would suggest at this point is something I've done in very few cases, and that is maybe the business people on both sides, business people on Susquehanna, and maybe Mr. Kemp and Mr. McDowell themselves kind of put your lawyers aside and see if you can reach a deal. Because I don't think you guys want to continue this lawsuit. And I don't think you all do either. There's a lot of lawyering that's gotten, and the lawyers are doing a good job for their clients, being zealous advocates, but I feel in my heart that if you all just get together, maybe with your mediator to help you, that you can reach a deal that's equally unpleasant for both of you to walk away from. So I encourage you to do that. Oh, and by the way, the federal rules of civil procedure and the local rules do anticipate that a district judge will be available for settlement discussion. It only says the only restriction in our local rules is that in non-jury cases, the presiding judge, that would be me, will not discuss settlement figures unless requested to do so by all concerned parties, so I can get involved in the settlement. And I think you should continue to try to do so because I think getting this dispute behind you is good for both sides. So, I think I've said everything that I want to say. I had it all bottled up inside of me, so I know it didn't make a lot of sense. But the bottom line is the temporary injunction is denied. I will make particularized findings in writing in the next couple of weeks, as soon as I can get to it. I encourage you to continue to try to resolve this case. Otherwise, we'll see you in trial in December. Is there anything further that you would like to state on the record or request from this court? Mr. Pernini, Your Honor, just a clarification on the last comment you made about the court being involved in mediation discussions. I wasn't sure exactly the point the court was making on that. The court, I'm just telling you I'm available. Mr. Pernini, so the parties could mediate with the court, basically, is what you're saying. The court, no. I'm just saying that I can talk to the mediator if I want. My position is I don't really talk numbers of whether it's a jury or a non-jury trial. But in state court, what I did is I would get involved. And if the parties asked me to, but they have to state on the record that they waive any objection for me continuing. That's what's in the rule. I just wanted to throw that out. Mr. Pernini, understood. The court, that if you need me to get involved, and I probably will get involved before the trial if it continues, I'll make an attempt, especially if it's a jury trial. Okay. But I can't run numbers if it's a non-jury trial, so, Mr. Pernini, understood. The court, it's just an offer and to tell you what the law is in this Northern District local rules and in the federal rules. Mr. Pernini, thank you, Your Honor. The court, it's different in Texas state rules. Yes, sir. Mr. Kingston, nothing further from us, Your Honor. The court, let's go off the record. Off the record. The court, we're back on the record. Counsel, I appreciate all of the efforts that lawyers made today and their professionalism before the court and each other today. I know you worked very, very hard. I know you also worked really hard to resolve this thing multiple times. I continue to urge you to do so, but otherwise, I think we're going to go to trial in December. Is there anything else right now? Mr. Pernini, well, the only issue we have, Your Honor, is we have a motion to dismiss. I putting the discussions of settlement aside. The court, yes, Mr. Pernini, which we will engage in. If they were not to happen, we have status conference, get discovery started, that kind of thing. And they haven't even answered yet, so, the court, that's true. Mr. Pernini, yes, so we need to. The court, well, it may have to be moved. But that just prolongs the, Mr. Pernini, I don't think, the court, the pain on both sides. Mr. Pernini, I think it's a matter of if we're not going to move it, obviously, we need to do expedited discovery, and we'll have to discuss it. The court, I'll let you all try to talk to each other. We needed to get this out of the way, so. But that's a good point. Okay, I'm making this case a priority, if you haven't figured that out. All right. And I will continue to do so. April Spencer is every time she writes to you. Just assume it's coming straight from me. Okay, so I just want to make that very clear. Mr. Pernini, thank you, Your Honor. The court, and then I read every response that's sent back to her. So she's here if you need a telephone call, a conference, or if you need to come back and we have a little meeting. But please communicate through April. She's making this a high priority for me. Anything else over here? I'm sorry you didn't prevail. Well, I'm not sorry. Mr. Pernini, I understand, Your Honor. The court, but you did a great job for your clients. Okay, Mr. Pernini, Thank you. Over here, anything. Ms. Griffin, nothing further. The court, we are adjourned. Security officer, all rise.
YouTube.com/@SportsCreek